Yes. 21,581 this time. ಏನಾಯ್ತದು ಗಂಗಾಧರಯ್ಯ ಸರ್ 21,581 ಅದೇ ಅವಾಗಲೇ ಹೇಳಿದ್ನ ನಿನ್ನೆ 2:30 ಆಗಿಲ್ಲ ಡೇಟ್ 28 ಏನಾಗಿಲ್ಲ ಅದೇ 2:30ಗೆ ಯಾವತ್ತು ಹೌದಾ ಏನು ಹೌದಾ ಇವತ್ತಾ ಓ ಓ ಬನ್ನಿ announcement of auto file ಇದೆಯಾ
Lordships, kindly one CRP one Section 18 petition under Small Causes Act since 9 years without paying the rent.
Understand?
Matter is
I have asked her because yesterday, day before yesterday, your matter is there. It won't reach. So I asked her to give it. Which day you have given it? Today itself. Then it's there. Why you mentioned?
It is listed at 104 million, not at 230. That's the problem.
Why?
104
Well, it should have been at 2:30. It was there yesterday at 2:30.
17, it was coming from 7. Lordship has directed me to list on 17. 17th also not reached. Lordship directed to list it on this day at 2:30 list, but unfortunately it
what
is.
What to do is look at it tomorrow, day after tomorrow, wherever another 2:30 matter is not there, there to fix it.
With my lord's kindly.
Obligeness.
With my lord's
And please
kindly.
don't make mention about any matters which I'll not take it up at 2:30.
My lord, this is one matter wherein my lord interim order is, I have the benefit of interim order. Wherein my lord, the excise license premises is not supposed to be disturbed by the respondent department. Now my lord, tomorrow is the last date for renewing. In clear violation of the order of this wonderful court, my lord, they are not renewing my license. My lord, tomorrow is the last date. For that reason, I am requesting for end of the
No, if they are not doing it tomorrow, we'll ask them to do it if there is a point in your case.
Yes, there is an interim order operating.
That's what I'm saying. If then, why should we take it today? It is the same order I can pass after 1 week also.
My lord, because tomorrow if I don't renew, I have to close my shop. For that reason, my lord, I am requesting for end of the list today. Because it is an online login.
End of the list. It's so difficult for the court. Nobody's understanding.
I can understand, my lord,
every matter 2:30, whether important. And when I'm asking them to give the memos, 100 memos.
I can understand.
100 memos I have to see. I have to see and say, no urgency in that. From one office, 10 bunch of all petitions which are pending. Please don't take it. Please, before taking the memos, please scrutinize it. And fresh matters, do not take it. 25 matters, vacate petitions, don't take it. Only mentioning reason that the matter is coming up before the trial court, only take those matters. Yes. Yes.
It's a matter of partition. In this suit, it's a collusive suit.
Why are you mentioning? What is the urgency?
The trial court and they have taken it to mediation. I filed a liquidating application, but it's been rejected. And now they're going to mediation and settling.
When did you file the writ petition?
It's filed in the last day, 2 days.
It will come if you comply with the office objections.
Compare the office objection.
And don't tell me having complied with the office objections, matters are not coming. That is not a correct statement. Because I am verifying every day, the registrar is saying every matter that is numbered is in the list. Every day 50 matters are coming in the list. Why not your matter? So you have not complied, please go. If it is not, tell the court officer and I will not take the memo. Yes. Why, what is urgency for a 2025 matter for preliminary hearing now? Let it wait. Yes.
Since the petitioner had filed a written statement and
First of all, not the issue. You have to tell the court when the writ petition filed. Why are you mentioning?
my lords, it is very urgent. It is coming for tomorrow itself before the trial court.
When did you file the writ petition?
That's 2 days back.
2 days back you file and I have to take it today itself. No. You comply with the office objections, it will come. Yes.
Your lordship,
Today morning I have filed. The urgency is, I am running a clinic and lab. The landlord.
When
has
was the
been-
impugned order passed?
You lot no impugned order. There are lots, the owner have disconnected the meter, electric meter, which is running clinic and lab.
When was it disconnected?
Lots, 16th it is disconnected. From 16th and 17th I approached KEB. They say they have not
So
disconnected.
there is nothing, no urgency to take it today itself.
Tomorrow,
So
Lord.
please file it, it will come.
Tomorrow.
Office- It will come, file it. Office objections complied, it will come. I don't have to give a memo for that. Yes, next.
Vacating for the interim order.
Huh?
The respondent is a senior citizen, aged about 92 years. So kindly post the matter.
Which year is that?
1 year back, 18/2005, I will
We
file.
will see. Court has enough work now.
Yes, matter. This is 2012 matter, trial is concluded. After that, after 1 year of disposal of the amendment application, they have come up and filed 3 writ petitions. When first writ petition stay was not granted. Subsequently, suppressing that 2 writ petitions filed and stay is granted. It is due for arguments, final stage, 2012 matter. As such, it may be.
Give the date on 19th of August. Yes.
Interim order is
Anyway.
already has been filed. In trial court miscellaneous petition which was filed is also dismissed, my lord. Nothing is standing in this writ petition. Only in miscellaneous petition in trial court has been dismissed, my lord. In this writ petition, it will not be standing. No, it is not.
But then what is urgency for you?
Interim order is.
What is interim order?
Vacating the suture property.
Huh?
We are vacating the suture property, my lord. We are the bona fide purchaser of the scheduled property.
We will see.
We
Yes.
have filed the
We
vacating
will see. We
application
will see.
also.
Yes.
It may be listed tomorrow.
No. Yes.
This case petitioner obtained a long LT number and running in commercial activity. 90 lakhs has been due from the petitioner's my lord.
Which year is the writ petition?
2025 my lord. The interim order has been granted on 23/10/2022 with liberty to respond to modify the interim order my lord.
That is not a special order. Anybody who is agreed by an interim order can move the court.
My lords, in this case, my lords, the petitioners are continuing with the same.
I can't take up all the vacate petitions whenever you, no.
Any date, my lords, in next week, my lords.
I am, my board is full till August. Yes.
My neighbor is putting up construction.
Huh?
My neighbor is putting up construction, my lords. I had ordered.
What is, why are you moving the memo?
For 20 minutes to go and complete the construction, but he has not left the site.
When did you file the writ petition?
25 minutes. For interim order, we have.
25 matter, 26,
My lords, caveat was there.
26 July, urgency is for interim order.
My lords, 2-3 times it was listed, my lords, but it did not reach, my lords.
No urgency for that. Yes.
My lord, the trial court has issued an warrant, my lords, urgency, my lord, kindly post it,
When was the writ petition filed?
2025.
There should be some reasonableness in making mentions.
My lord,
Kindly,
my
my
lord,
Except 230, no other matters to be mentioned.
My lords, 230,
My
my
lords,
lords, this is a matter where my
serial
lords
number.
power disconnection has happened. I have filed the petition on my lords on 10th. Matter was listed on 16th. Your lordships had directed for notice, my lords, and it was posted on 17th. It did not reach my lords, so it was posted on Monday, my lords.
Inform the other side.
I informed my lords.
My lord, this is this month 28th trial court matters listed, my lord. 28th matters listed at trial court.
Let
my
it
lord.
go on. What happens if the matter?
Actually, we filed application for the witness summons. They rejected my
Call the
application
list.
and.
your lordship, serial number.
my lords, for.
My lord,
230, my lord,
Serial
my
number
ex
My lord.
parte ad interim order is rejected. Despite me demonstrating that there is interference, there is
So
construction.
why should we
by-
take it at 2:30? What will
My
this
lord,
court do?
construction is going on, my lord. It's declined yesterday without assigning any reasons.
Then I'll remand it. I will not grant any injunction.
My lord,
File it. I will not grant. I am in all those matters. I am only asking the court to hear the matter, but I will not grant any injunction here. So there is no urgency. You file it, it will come.
my lord,
lord,
one
my lord,
pending
my lord,
matter, my lord, there is
Such a direction
urgent.
is given, my lord. We'll attend.
That will come tomorrow, but I will not, there is no urgency for that today.
My lords, if I may, if I make a sub,
Come, don't have to give the memo. You comply with the office objections. It will
my
come.
lords, if I make a submission, it's a pending matter, my lords. It had come up before this court on 16th. My lordship was pleased to issue the emergent notice and the hand summons, and my lordship said that you'll hear it for final hearing. The urgency in this matter is, my lords, there was an earlier writ petition filed, and it was disposed by way of an RP. In the RP, my lord, there was a direction given to the trial court that 5 suits has to be clubbed and the evidence has to be led, and within the period of 4 months. It's a direction matter, and the matter is going on day-to-day basis.
Direction by whom?
Coordinate bench of this honorable court, my lords, in an RP, and that direction date is going to end on August 16th. Now, my lords, the entire crux why
Don't
the
worry, the learned judge will address a letter.
please, my lords.
The extension of time.
The urgency here in this petition is, my lords, my application to filing the additional document has been rejected. The whole agenda of remanding back the matter to the trial court and giving the direction was to consider my additional evidence. And there are 5 suits, my lords, 5 suits for partition.
Was it filed?
It was filed in the last week. It has come up before, my lords. The notice was issued.
Was it served?
Please, my lords.
It will come. We'll see.
My lords,
We'll see
kindly-
Your lordship, serial number 12,
List number.
list 1, serial number 12.
All the list.
Maybe taken up at 1 o'clock.
My
Or
lords.
2:30.
Beg to appear for the petitioner minutes.
Bill number 2 for orders matter. My lord, move for withdrawal.
Serial number 76. I want to file a memo for withdrawal, my lord.
Take that.
Liberty to file an appeal, my
You
lord.
ask her 60?
76, my lord. I also request an order be made to give back the documents produced.
You have to file an MFA.
We will file an, we'll go by the,
Memo is filed. The office has raised an objection with regard to maintainability. Then counsel the petitioner submits that they want to file an appeal, hence the petition may be dismissed with the liberty. Accordingly, the petition dismissed with the liberty to the petitioner to avail the appropriate remedy within a period of 2 weeks. Office is
and the
directed to
documents also
return
may be returned, my lord.
documents by retaining the copies. Yes,
Please.
Serial number 2.
yes. It is stated that the petitioner, the matter is posted for evidence and on the same petition marking documents in the trial court, hence seeks permission to withdraw the writ petition accordingly dismissed as withdrawn.
Serial number 3.
Lord, appeals for the petition in this case. Memo may be kindly allowed, my lord.
It is stated that the petitioner has vacated and handed over the sue scheduled property. Hence, it doesn't want to, hence the petition has become infractious. Memo is taken on record and dismissed as infractious.
Absolutely.
Serial number 4.
Responded for withdrawal. Kindly permitted to withdraw the petitioner. Was not present.
Recall application, they have challenged, my lord. They don't want to proceed.
The petitioner wants to withdraw the writ petition. Same memo taken on record and dismissed as withdrawn.
Please.
Yes, fine.
Serial number 5. Rupesh Kumar S.
Petitioner will. Yes, I filed memo for withdrawal. With liberty to file fresh petition.
Why?
My lord, in this case, I have to add few more documents, my lord, with respect to, I am on NOC, my lord, in this.
Then file it. Why should again another round of litigation? Why should Liberty? If you want to file the document, this is a writ petition, what documents, whatever before the trial court, you can file at any point of time. Yesterday, this matter has come up.
Yes, madam.
That's why I have not granted I have not given the permission. Why you want?
My lord, the facts are this, my lord. The petitioner is allotee of a site, my lord.
Whatever it is, documents, if you want to file, you can file. Why should there be a liberty to file a fresh petition on same cause of action?
That I have to amend the entire petition.
2024 writ petition.
I got.
I'll not grant. If you want, whatever you want, the petition is filed. The petition is filed seeking to withdraw the
In that
petition.
case, my lord, I'll withdraw the memo for withdrawal, my lord. and
That's what only on that I'm saying. A memo is filed
2
seeking to
weeks
withdraw the
time
writ
will be granted,
petition.
my lord. I'll
You want to, yes.
comply the officer.
He wants to, it is submitted that he wants to withdraw the memo that's filed seeking to withdraw the writ petition. Yes, next.
Serial number 6. Vipin Hegde.
I appear for the petitioner, my lord. Filed a memo for withdrawal.
Memo is filed stating that the writ petition has become infructuous. Accordingly, the writ petition is dismissed as infructuous.
Serial
Memo
number
is stated
7.
on record. Yes.
Jamari Rahmat.
The same, is also infructuous. Yes, call the list.
Serial number preliminary hearing. Serial number 8.
I appear for petition, my lord. Advocate on record is unwell, my lord. Person inconvenience, adjournment, my lord. Any date, my lord.
Matter on
Any-
22nd of, not, on 28th of July.
Obliged, my lord.
Yes,
Serial number 9.
at the request of
Yes,
non-counsel for the petition.
K. Sri Hari. 9. K. Sri Hari.
Let's, the facts leading to the case is that, my lords. One
What is the
Gideon-
suit for?
My lords,
What is the suit for?
my lords, suit is one for page number 53 at annexure B is the plain. My lord, the-
Don't have to go to the plane to know what is the suit for.
No,
You
my
can
lords.
tell the court what is the suit for.
My lords, it's just bare injunction suit.
Yes, in that what has happened, what has happened to the IA?
My lords, annexure A is the order passed, my lords, relevant page is at,
IA is dismissed or allowed?
my lords, it is dismissed, my lord.
Appellate court has confirmed
Confirmed
it.
it.
Please come to the order in the MA.
Impugned order, my lords.
Yes,
It starts at page number 19.
you can come to the reasoning part.
Please, my lords. My lord, the reasons would start at paragraph number 14, page number 33, my lords.
33.
33, my lords, 33.
Let's read.
My lords, point number 1.
Hmm.
The plaintiffs have filed an application before the principal so and so court.
Para
Mysore.
number 30?
Para 14, page 33.
No, we don't have to read from there.
Please,
You can come to para 26 at page 42.
please, my lords. Accordingly, she is in possession and enjoyment of said property paying tax. She has constructed a small room with a dream to.
Para 26, page 42. It starts where, I'm reading in the MA.
Please, my lords.
Yes, in OS number 114 of
27, ma'am. Para 27.
In this case, it is para 26. Before me, the papers.
Yeah, my lords, there is some. In OS number 114 of 2023, in the written statement, the defendant number 1 and 2 have taken up contention that suit is not maintainable either in law or on facts. Originally, one
So
Giriamma.
not correct. What I am reading and you are reading are not on the same page.
I apologize, my lord.
25, it says heard both sides. Peruse the entire material placed on record.
Okay, one para, there is different.
After that is OS number.
Please.
Please read that.
Page, paragraph 25, my lord. In OS number 114 of 2023, the plaintiff has filed the suit. I think now it is correct what I am reading. Suit for the relief of declaration that he is the absolute owner and she is in possession and enjoyment of over the A schedule property. Consequential relief of restraining the defendants from interfering with the plaintiff's peaceful possession and enjoyment of the A schedule property, and also the relief of declaration to hand over the vacant possession of B schedule property as she is the absolute owner of B schedule property. It is the case of the plaintiffs that the plaintiff is the absolute owner of the sites bearing number 9 and 10 measuring 60/40. The suit schedule property devolved upon plaintiff through a gift deed on 9/1/1982. The said gift deed was executed by the mother of the plaintiff, Srimati Giriamma. She has succeeded to the will, said will dated so and so, executed by her father. Since 9/1/1982, the plaintiff is in absolute possession and enjoyment of the suit schedule property. The said property was gifted to the plaintiff as she is dumb and it was secure her life. Accordingly, she is in possession and enjoyment of said property paying tax. She has constructed a small room with the dream to construct a house and started foundation work of the house. She has invested huge amount on the raw material with respect to construction. It is stocked in the suit schedule property. Hence, at this stage, the defendants have tried to interfere with the plaintiff's physical possession and enjoyment and tried to trespass over the suit schedule property on 25/9/2018. Even after lodging complaint before the local police, they have not stopped the interference. Hence, the suit and application came to be filed not to interfere in the suit schedule property. In OS number 114/2023, in the written statement, the defendant number 1 and 2 have taken up contention that suit is not maintainable either in law or on facts. Originally, one Giriamma was the absolute owner of the property bearing survey number so and so, situated at Metagal village so and so, comes under the vicinity of Mysore city. Said Giriamma farms different revenue sites over the said land. She has sold site number 9 measuring 30 into 40 feet. It is the A schedule property in favor of C. Chennegowda by virtue of the unregistered sale deed dated 10/6/1982 for valuable consideration of rupees 2,000. On the date of said sale deed, C. Chennegowda was put in possession of written statement A schedule property in part performance of the terms of the deed. One Srimati Gauramma was the wife of C. Chennegowda. Giriamma sold site number 10 in favor of one Gauramma described in B schedule property through unregistered sale deed dated 10/6/1982. Later, C. Chennegowda and Gauramma constructed residential structure in written A and B schedule properties. These properties are abutting to each other. Gauramma and Chennegowda are husband and wife. A single building was constructed in the written statement A and B schedule properties. Chennegowda and Gauramma sold the written statement A and B schedule property on 27/12/1985 in favor of defendant number 1 and 2 and put them in possession of part performance of contract. The second defendant is the wife of first defendant. They have applied for regularization of construction in the written statement A and B schedule properties with the concerned authorities through the regularization of unauthorized construction Urban Area Act. On 22/10/2008, when the defendant were doing repair of the said building, one Udayaravi son of so and so tried to interfere with the defendant's lawful possession over the suit schedule property. In view of the same, defendants filed a suit against said Udayaravi and so in OS number 1616 of 2008 on the file of Honorable so Mysore, seeking for relief of injunction. The defendant have produced all the documents. The defendants are paying tax to MCC. They have produced building photographs. One Mahadev, wife of so allegedly derived the said property from one Puttegowda, son of Madegowda, by virtue of the gift deed dated so. Said Puttegowda, son of Madegowda, has purchased the said property from one Giriamma on 10/1/1982. They further contended that they are in possession of written statement A and B schedule property. However, after trial, the suit came to be decreed. The regular appeal filed against the said judgment and decree in RA number 350 of 2016 on the file of the 7th additional so Mysore came to be dismissed on 3/4/2017. In both the above cases, the Honorable Court was pleased to observe that these defendants are in absolute possession and enjoyment of written statement A and B schedule property. Said Ramchandra, second defendant in OS number 1616 of 2008, is son of Giriamma. Mahadevi allegedly purchased the property from Giriamma, is none other than the daughter of said Giriamma. Said Uday Ravi is son-in-law of the said Mahadevi. Now the plaintiff is in this case is none other than the sister of said Ramchandra, being the daughter of Giriamma. In view of final disposal of the above said cases,
Yes, I have seen.
my lord, what has happened may draw the attention of the court to the earlier order, my lords, that is OS number, my lords, that is found at page number 178. My lord, that is OS number 101 of 2018, order passed by that court.
Who are the parties? Defendant is a plaintiff.
Correct.
And your family members are the parties to that.
No, my lords, defendant number 1 and 2 were the plaintiffs in this present suit. There, one Lakshmi was the plaintiff. One Lakshmi.
Who is it? What is the defendant's name in this?
My lords, in this suit, my lords, in this suit, my lords, Tayamma, Swami, Ramchandra and Lakshmi, who is the contest, that's what, my lord. Contesting defendant is defendant number 4. That is Lakshmi, very same person.
Not 4, 5.
My lords.
5, Srimati Lakshmi. From the cost title, I am saying.
Annexure B, page number 53, my lords.
19.
My lords,
The present suit.
I'm not saying that. I'm showing the plaint, my lords. Plaint in the present suit.
Where is it?
My lords, that is at page number 53, annexure B, my lords. Defendant number 4 is the...
Something completely wrong with the...
Judgment, my lords, I will correct it and do it. I'm extremely sorry, my lords. I apologize.
This matter on 28th.
Please.
Cell number 10. Cell number 10.
I pay for the petitioner.
Ashura.
Yes.
Petitioners with a decree holder of a specific performance suit, which are decreed against the respondents 1 to 3 million. They, during the pendency of the execution petition, they sold the property in favor of 4 and 5 million. They were made as a part.
What is the suit for?
Suit for specific performance million. It was decreed million. They did not come forward to execute the sale deed, and the execution was filed. During the pendency of the execution petition, they have alienated the property in favor of 4 and 5. I made an application to include the 4 and 5 as being the purchasers during. It was allowed. They came on record. They never filed any objection to my petition, and they never raised any contention with regard to their bona fide purchase million. Then I produced the draft sale deed, including the names of the 4 and 5 million. Because, my lord, nowadays we have to upload the sale deed through electronic medium, and their name is reflected in the RTC million. Unless they have been made as a party, I will not get the sale deed. It will not proceed at all. And I produced a draft sale deed, including 4 and 5. Office raised objection that they are not the decree holders, they are not the radius before the trial court, hence they cannot be included. And that, yes, ma'am.
Court has impleaded. After that, what has happened?
Yes, ma'am.
After impleading them to the execution proceedings, what happened?
They did not file. I filed a draft sale deed, including the 4 and 5. They did not file any objection to my execution petition or the decree, and they have not challenged the decree till now. And now without them, I cannot go on with the.
No, that is true.
Yes, my lord.
According to you, no further orders needs to be passed by the court except impleading them.
Yes, my lord. They were made as a party. After
they have made a part, they are made a party.
I have made a party.
After that, what is to be done? There should be some order from the court.
Since they did not file any objection, no order was.
They have not filed objections. Also, court should pass some order on that.
Let there be a finding to that effect. Let the court. pass on.
Why should there be a finding by this court?
No. Because the court has not passed any order which, except by making them as a party.
Merely by impleading them, you can, there is a direction to execute a sale deed by the court.
In view of not filing any objection to my petition by them.
That you have to ask the court.
2022.
What is the order impugned? Please come to the order.
Page number 72, 71, 72. See, 71 I am reading. Page number 71.
Page number?
71.
71.
Order sheet. Order sheet. Third paragraph. This court appointed court commissioner after verifying the draft sale deed.
Court was right.
Yes, Miller.
Court was right.
Yes, Miller.
Court said DHR shall file a draft sale deed
Yes,
as per the decree in OS number 362 of 2010. What is wrong in it?
No, unless they are included, I cannot execute the sale deed in respect of the decree, Miller.
There should be a decree. As per the decree, you will file the draft sale deed. There should be an order against them to execute the sale deed or whatever. They should be fine. Just like that, assuming you can't file a draft sale deed adding so many people who are not the parties to the decree.
No, since they are the purchasers, I made them the party. They have not raised any objections. In view of that, I have filed. In view of the fact that without them, I cannot get the sale deed executed.
Whereas in this petition, the question is not adjudicated after their,
Yes.
after adding them as parties.
Yes, Miller.
Nothing has been adjudicated by
Because they
the
did
court.
not file any objection to my.
I'm sorry.
And they have not
Please
filed.
come. The order, the court by order impugned. The petition is agreed with order dated 12/9/2015-25. Is question now. 12/9/2025 by the additional civil judge and JMFC Dolpalapura, whereby the court has directed the petitioner to file a draft sale deed as per the decree in OS number 362 of 2010. The petition is before this court. When counsel for the petitioner submits that he has filed a suit for specific performance that came to be decreed, and during the pendency of the suit, they have
Execution.
the defendant has sold the property.
Execution petition.
Huh?
During the pendency of execution petition. not the suit.
Execution petition, the defendant has sold the property in favor of in favor of a third party. Then an application is filed to implead them. It is submitted that thereafter he has presented a draft sale deed. Sale deed reflecting the names of the original decree holder and as well as the implead applicants. And the court by order dated, by order impugned, has observed that the DHR shall file a draft sale deed as per the decree in OS number 362 of 2010. When counsel for the petitioner submits that, as there are registered sale deeds in favor of the third party, unless and until the third party is a signatory to the document, and he is a party to the document, the same cannot be uploaded, and the same will not be accepted as they are the registered owners. Hence, it is submitted that there may be a direction to the court to accept the draft sale deed as placed by the petitioner before the court. Next part. Having heard the counsel to the petitioner, peruse the order impugned. In the order, the court has observed that after verifying the draft sale deed, the office raised objection that the decree was against JDR number 1 to 3 and JDR number 4 and 5 were also included in the draft sale deed and sought necessary direction. The court observed that in the petition, the decree is against JDR number 1 to 3. This court cannot go behind the decree. It is submitted by the counsel for the DHR that the JDR number 4 and 5 are bound by the decree, and this court should give necessary directions to the office. In support of the submission, that he has relied on a judgment of the apex court. On perusal of the said decision, the point raised in the execution petition is not at all discussed. In the said decision, in a suit for excessive performance, it was decreed that the sale deed by defendant number 1 in favor of defendant number 2 and 3 was illegal. Whereas in this petition, the said question is not adjudicated, merely impleading JDR number 4 and 5 for the reason for purchasing the property could not bind them, and they are not bound by the decree. Whether JDR number 4 and 5 are bona fide purchases or not, is not decided. Unless there is a decree against JDR number 4 and 5, they cannot be included in the execution of the sale deed for executing the decree in the petition. And accordingly, court has directed the petitioner to file the draft sale deed. This court has perused the order, and the court was right in giving, in directing the petitioner to file a draft sale deed as per the judgment and decree, as rightly held by the court. Just because he has impleted the subsequent purchases, that itself will not be conclusive, and the impleted parties are not bound by the decree. No further adjudication is done. In those circumstances, the court has rightly observed, and this court finds no reasons to interfere. Accordingly dismissed.
Serial number 11, VB Kumar for petitioner.
Yes.
Writ petition arising out of the commercial courts. Commercial court writ petition. I am the defendant in the case.
What is IA?
An application is filed at page 23 for production of the documents. After the plaint is filed, written statement is filed, and truth of the statements have been gone into, issues are framed. But the commercial courts cannot entertain any interlocutory application for fresh production of the documents. But the learned judge has allowed the said application.
Let's see that. Where is that order?
Order impugned is commencing at page 20. The order commences at page 18, and it is under 11 rule 1.5.
I think this has come up earlier.
Beg your pardon?
This has come up earlier.
Yes,
I heard it.
I pointed out to this court, but this, the
Take that.
judgment of this court disentitles production of any document.
Yes. Yes.
And a ruling of this court, which I would point out to my lords, the court came into conclusion in a similar aspect where all other judgments of the other courts have also been followed. But kindly go to page 30, para 13, page 27. The commercial courts was enacted with the legislative intent to streamline and accelerate the adjudication of the commercial disputes, to permit litigants to dribble in documents piecemeal long after the pleadings and evidence are progressed, would be to strike at the heart of the legislative command. High courts at Delhi and Madras have cautioned that indulgence that may extend in ordinary civil suits cannot be replicated in commercial matters. As observed above, I am in respectful agreement of those observations. If indulgence would be shown, the very reason that would be defeated. But the application under 11 rule 1 was rejected by the court. But the facts therein was a similar insofar as the present case is concerned, where production of the documents were made before the court. This court said you cannot produce a document in piecemeal whenever you want. And that's the contention that was raised. Court said you cannot produce document in piecemeal.
Then counsel for the petition is before this court questioning an order of the court, where the court has permitted the petitioner to produce the additional document at a later stage. They relied on an order passed by the coordinate bench of this court in IFCO Tokyo General Insurance Company Limited versus Ficus Hats Private Limited, dated arising out of WP number 23634 of 2025, dated 3rd September 2025. In the light of the said order, in the light of the submission and the ratio laid on the said order, they shall be stay of all further proceedings pursuant to the order dated, and the petition serve the notice, hand summons, memo shall be filed by 3rd of August, or else a stay granted by this court stands vacated.
Cell number 12, Srinivas Manohar.
Appearing for the petitioner, Your Lordship. Advocate on record is having an inconvenience. He's out of station. Kindly grant an adjournment.
This is a matter on 12th of August. Yes, next.
Cell number
Much
13, GB Manjunath.
No representation. This in the month of September. Yes.
Cell number 14, Shivakumar K. Shivashankar K.
Let's appeal for the petitioner. The petitioner is the defendant before the trial court. That's the respondents filed the suit for the relief of declaration, possession and injunction. That's after completion of evidence, that's an application has been filed for the appointment of commissioner to identify and measure the suit scheduled properties.
No, what is suit for declaration?
Suit for declaration, possession and injunction.
And what is the present stage?
That's the commissioner has submitted the report. That's the report is not in accordance with law. We have filed the objections before the trial court. Cross-examination has been conducted. No notice has been issued to the petitioner when the defendants are concerned. There is no signature on the commissioner report. 20th notes in the year 2020.
Then what is the IA that is filed by you?
We have not filed IA notes. The plaintiffs have filed the application for appointment of commissioner to measure and to identify the suit property in respect of the suit property is concerned. Commissioner notes without issuing notice, notes in the year 2020 an application has been allowed. After notes the 4 years and a report has been submitted. He has admitted notes his signature is not found on the commissioner report and no notice had been issued to the defendant, prepared the sketch and notes they submitted to the report. We have notes they filed the objections to the commissioner report. Notes the court has tendered for cross-examination so far as commissioner is concerned. In the cross-examination is admitted everything. It's court commissioner notes once a report is wrong. No notice had been issued to the minutes. The petitioner is concerned. Report has to be rejected.
What is impugned now?
Impugned court commissioner has accepted the report. Court has accepted the report.
Let's see that.
Let's page impugned order.
Where is that order?
That's
Accepting
page
the
73.
report.
Orders and commissioner report.
The evidence of CW1 discloses that parties cooperated during the survey proceedings. According to you, no notice.
Yes, minutes, no notice. He has admitted in the cross-examination. His signature is not found on the report.
Where is the cross-examination?
Minutes, cross-examination, page 96.
That was not discussed by the court.
Not discussed minutes.
90?
That 96, page 96 minutes.
Hmm.
93 to 96 minutes cross-examination, detailed cross-examination has been
Where did
conducted.
he say so?
Minutes.
That no notice is issued to you?
Yes, 96, even court has underlined. Minutes, the last para.
Hmm.
Nishane 3 minutes, it's through court minutes, the commissioner exam. Nanna commissioner varadalli, Nanna sahi iruvudilla. Minutes in the Mahazar, his signature is not found. His signature, he has not signed.
That is one aspect. About
Second aspect, minutes, Sadari Varadiyan Wadia GPA holder Tayarisi Nidiruttare endare Sarialla. Sadari ನನ್ನ ವರದಿಯಲ್ಲಿ ವಾದಿಯ ಜಿಪಿಎ ಹೋಲ್ಡರ್ ಬಸವರಾಜ ಏನವರು ಸಹಿ ಮಾಡಿರುತ್ತಾರೆ ಅಂತ ಸಾಕ್ಷಿ ಹೌದು ಎಂದು ನುಡಿತಾರೆ. ಜಿಪಿಎ ಹೋಲ್ಡರ್ ಸೈನ್ ಟು ದ ರಿಪೋರ್ಟ್, ಪ್ಲೇಂಟಿಫ್ಸ್ ಆಲ್ಸೋ ನಾಟ್ ಸೈನ್. ದೆನ್ ವರ್ಡ್ಸ್ ನಿಶಾನೆ 3 ಅಲ್ಲಿ ಪ್ರತಿವಾದಿಯ ಸಹಿ ಕೂಡ ಇರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಡಿಪೆಂಡೆಂಟ್ ಸಿಗ್ನೇಚರ್ ಇಸ್ ನಾಟ್ ಫೌಂಡ್.
No, not signature. Your submission is no notice is issued to you.
Yes, no notice is issued and
where is the cross examination on that?
Because once he has admitted the signature is not found on the the report is concerned. Then we have also denied kindly the report also produced detailed report at page the 86.
No, there are two issues. One is whether the notice is served to you or not. Number two, whether the commission that warrant is executed as per the order or not.
Yes,
there are first two things.
No notice.
That is where do you get that? That is what I want to know.
Now, with regard to the notice is concerned, when
that is your case, for cross-examining the commissioner, you must have put him a question. You must have questioned him that you have not issued me notice.
Yes, minutes.
Where is that?
But he has admitted, he has stated that I issued the notice. But signature found on the notice, it is not the signature of this defendant is concerned. That is the question we have asked. Then, even Mazar has been drawn. There is no signature on the defendant. Everything we have cross-examined because he has not conducted, but suit property is concerned. Suit property is survey, the Kanishmari number 61/2. But he has conducted the survey in respect of different survey numbers. That is also admitted. Totally conducted survey in respect of different survey numbers.
Please tell the court what are admitted by him, not
first thing is no notice had been issued to the defendant.
That is nowhere.
Second
no, that is not. We can't consider it because that is nowhere accepted by him.
So he has denied it, but he has issued the notice.
Second that is for you to prove. That is one. Next, what are the other things?
Second aspect is, he has not conducted the survey in respect of the suit property is concerned.
Where did he say so?
Let's kindly see the suit property and the survey conducted by the commissioner. Page 27 is the schedule.
Oh, you have cross-examined him for this purpose.
Yes,
you should have elicited it in the cross-examination.
Yes, we have elicited.
So let's see that.
Claim.
Only that.
Cross-examination.
We'll not go to the other things.
Please, That's page 93. Yes. The last paragraph after 3 lines. ನಿಶಾನಿಸಿ ನಡೆಸಿದ ನೋಟಿಸ್ ಪ್ರತಿವಾದಿ ನಾನು ನೀಡಿದಂತ ನೋಟಿಸ್ ಜಾರಿಯಾಗಿ ಬಂದಿರುತ್ತೆ ಅಂತ ತೋರಿಸಲು ಯಾವುದೇ ದಾಖಲಾತಿ ಇರುವುದಿಲ್ಲ ಎಂದರೆ ನಿಶಾನಿಸಿ 4 ಆ ದಾಖಲಾತಿ ಇರುತ್ತೆ ಎಂದು ಸಾಕ್ಷಿ ನುಡಿಯುತ್ತಾರೆ. With regard to service of notice is concerned, we have put a question. There is no document to show that notice has been served to the defendant.
Which is denied by him.
ನಿಶಾನಿ ನೆಕ್ಸ್ಟ್ ಲೈನ್ ಮಿನಿಟ್ಸ್ ನಿಶಾನಿ 4 ನೋಟಿಸ್ ನಲ್ಲಿ ನಾನು ಸರ್ವೆ ನಂಬರ್ 42, 44, 47 ಮತ್ತು 42, 44, 47 and 55 ನಮೂದು ಮಾಡಿರುತ್ತೇನೆಂದರೆ ಸರಿ. In the notice, he has issued notice to conduct the survey in respect of different survey number 42, 44, 47 and 55. Suit property is a different property.
That question you have asked him?
Yes, Millards. He has admitted. He has admitted, Millards, he has not conducted kindly Millards in the cross check. ನಾನು ಸರ್ವೆ ನಂಬರ್ 42, 44 ನಮೂದು ಮಾಡಿರುತ್ತೇನೆಂದರೆ ಸರಿ. ನೋಟಿಸ್ ನಲ್ಲಿ Millards, he has mentioned only different survey numbers, not the suit property. To measure the suit property, he could have mentioned this is the property that has to be measured. Then Millards, notice has to be issued to the
When
parties.
was the survey conducted?
Millards, survey the 22 Millards.
In the year 2022.
2022, report has been submitted in 2024, application has been allowed in their 2020. That too, Millards, no signatures have been found on this, the plaintiffs are, the defendants.
How the court has dealt with it? Please come to the order of the
Court has, Millards, all minor discrepancies, it has to be considered. Kindly, Millards, page 73, Millards, the order commissioner report, orders and commissioner report. Court commissioners, your defendants have seriously disputed the correctness and the acceptability of the report. Heard the learned counsel for the plaintiffs. Reasons for report submitted by the court commissioner is not an ordinary private document, but it's a document prepared. Pursuant to the judicial directions issued by this court, the appointment of commissioner is intended to assist the court in elucidating matters which cannot be conveniently brought before the court through oral evidence alone. The object behind appointment of a commissioner is to place before the court a factual and scientific assessment for the physical features of the property and its location.
No,
It
he
is well
has
said.
also given evidence that you people were present. When you will not go to some other property which is not a sue scheduled property for survey.
But that is not the question before the trial court. Question is, Millards, my property is situated in a different village. Their property is situated in a different village. Millards, when the application is.
No, commissioner says that.
Commissioner, Millards.
He says that you were present.
But Millards, we are not, that is the question, Millards, when no notice had been issued to the defendant. Spot inspection, Millards, at the time of conducting the survey, parties should be present before the court. Parties' signature has to be taken to the commissioner report. No signatures is found on the report.
Signature is there, but you are denying the signature.
No, not Millards. He has admitted that its Mazar has been drawn. No, even he has also not signed. Let's page 86 for a moment. Let's page 86. Kindly, Millards, this is the, on the date of the survey, Millards, this is the report he has submitted. His signature is not found on at least Millards, not the defendant. At least the commissioner.
Then when the report is filed in 2024, you didn't file your objections to the report.
We have filed the objections.
When did you file?
Immediately, Millards. Immediately we have filed the objections. Objections and immediately after the report, immediately we have filed the objections.
The petitioner submits that. The court has accepted the commissioner's report, which was conducted in the year 2024. And a report was placed in the year 2024. Now the court has passed an order. It is the case that the petitions are served, not served with the notice. The commissioner has not surveyed the suit schedule, the plaintiff, the plaintiff property and the written statement property. Further, the report does not contain the signature, the Mahajar does not contain the signature of either of the parties or not even the signature of the commissioner, and these aspects were not considered by the court. There shall be stay of operation of the order dated so and so. Notice to the respondents. Petition is permitted to take court hand summons. Memo by 3rd of August. Oral stay granted by this court stands vacated.
Number 15, Mohan PS.
For the petitioner is the respondent before the first, respondent 1 to 3 before the first appellate court and plaintiff before the trial court. The suit filed for the specific performance, suit for specific performance contract, and the suit is decreed in favor of the petitioner plaintiff. And the respondent, the owner.
File the appeal. What happened? What is IA now?
IA filed by the purchaser to implead one of the respondent under 41 rule 20. Though he has not shown any interest to file a separate appeal, he is a purchaser, he has every right to file a separate appeal. He has not filed the appeal. So he admits the decree. in favor of the plaintiff.
No, he was a party to the suit.
Parties to the suit. He's a party to suit, he has not filed separate appeal.
Mm.
So the other respondents have filed the appeal, has not been impleaded as a respondent. In the later stage, after hearing the arguments, the filed application under Order 41 Rule 20 to implead the not interested respondent as a proposed respondent, because the two appeals filed by the respondent defendants. One appeal filed by the owner and another appeal filed by the purchasers. The appeal filed by the owner, the proposed respondent is a party. The appeal filed by the purchasers, this proposed respondent has not been shown as a party. In the later stage, because the appeal is of the year 2018, my lord. So in the year 2026, after hearing the arguments on main appeal, an afterthought filed an application under Order 41 Rule 20. The proviso is very clear. The Order 41 Rule 20 is empowers the appellate, the first appellate court to implead any party as a respondent, though he is not a party in the original suit. Admittedly, in the original suit, he is a defendant. So he is aware of all the proceedings.
So what is the prejudice now? Prejudice to you, he is already contesting the matters, both the matters. Other matter he is contesting, you are a party.
In
to
other
that.
matter, he has not contested, he was placed ex parte. Though he has not shown any interest to come on record.
To the order, let's see.
Kindly see the order, my lord, page number 138, annexure E, my lord.
Please come to the reasoning part.
Para number 10, my lord.
9.
Para 9 and para 10. On perusal of the trial court record, disclosed that the plaintiff have filed suits OS number so and so before the senior judge Hodgson seeking relief for specific performance. The trial court made judgment so and so dated has decreed the suit in favor of the plaintiff, directing the defendant to execute the said deed in terms of the agreement dated so and so by receiving balance sale consideration from the plaintiff. Defendants 2 to 9 are also directed to join defendant number 1. D 2 to 9 are the subsequent purchasers and D1 is the owner of the property. D1 is execution of sale deed with respect to scheduled sites in favor of the plaintiff. Aggrieved by the judgment and decree dated in OS number 51 of the appellants, defendants 2 to 9 have filed the present appeal. The proposed respondent sought to be implead as parties IA 14 for defendants number 10, 12 in OS number 15 of 2000.
The impleading applicant is a party to the original proceedings. In the two appeals are filed. In one appeal he is a party and in the other appeal he was not a party. In the appeal where he is a party, the suit that as he has not pursued the matter, he was set ex parte. Now in the second appeal, he wants to come on record. It is submitted that he has not evinced any interest to prosecute the matter, and the matter was heard and posted for final arguments. At that stage, the present application is filed, and the court, without considering the scope of Order 41 Rule 20, has allowed the petition. Considering the same, there shall be stay of operation of the order dated so and so till the next date of hearing. Same order. Notice by hand summons by third memo shall be filed.
Cell number 16, 1 KP.
Yes, ma'am. My lord, 10th defendant's writ petition. The respondent 1 to 4 filed a suit for declaration and permanent injunction in respect of the scheduled property. My father was a 10th defendant.
What is IA?
IA Order 6 Rule 17.
Let's see.
Yes, ma'am.
Who filed the IA?
The 10th defendant, that is the petitioners.
Yes.
My lord, 2017, my father, 2018 filed a written statement. My father died. So after the death of my father.
What was the case of your father and what is the amendment you want to bring?
Yes, my lord. That is, I'm seeking by way of counterclaim. My father also stated that written statement that we are a owner of the property, that sale deed is in our brother's name. The property has been fallen to
What was the suit?
The suit in the year 2017.
When your father died?
1/1/2024.
So there was ample time for him to see.
No, my lord. So 1/1/2024, 28/1/2025, amended written statement file, amended plaint file. I filed application on 6/6/2025, order 6 rule 17. Because of my lord, after amended plaint has been filed, I have right to file a written statement. So I filed written
That will also include counterclaim.
counterclaim. So by way of counterclaim, I'm seeking
Come
application.
to the order.
Yes, ma'am. Page number 28, that is reasons. Last para number 21, my lord. We sum up our finding that Order 8 Rule 6A, CPC does not put embargo on filing of counterclaim after filing the written statement. Rather, the restriction is only with respect of this occurral of cause of action. Having said so, this does not give absolute right to the
Yes,
defendant to.
you're relying on any judgment for the proposition you're submitting before the court that you can file the counterclaim after 6 years because they have filed a additional, they have amended the plaint.
No, my lord, because 6 years means when I come on record, I came on record, I have
cannot,
right to file.
The original plaintiff has enough time and you are a legal representative.
Yes, my lord.
You cannot
My
take up a
defense,
substitute.
I can.
You cannot. You
No, my
can't take
lord.
contrary to what has been stated. And you have to also submit before the court that you can file the counterclaim whenever the plaint is amended.
Yes.
Then I'll consider. This is matter on 29th of July. Yes,
When, my lord?
17,
29 July.
Much.
Satya
Till
MN.
then, my lord, matter is on.
No. Unless I'm convinced, I will not pass any interim order.
Yes, ma'am.
Satya MN for petitioner.
Plaintiff writ petition, ma'am. The plaintiff has filed the suit for cancellation of sale deed dated 4/1/2023, executed in favor of defendant for consideration 1,75,60,000, ma'am.
What is I?
IFR not to alienate and are creating any third party interest, ma'am.
What happened?
Actually, the sale consideration is 1,75,60,000, ma'am.
No, what has happened to the IA?
Only court not frame up a similar case and issue emergency notice, ma'am.
Where is that?
Page number 22, ma'am.
Page number?
22, my lord.
The suit is for declaration injunction.
Yes, my lord.
Land counsel for not land counsel, the petition is agreed with the order dated 19/12/2020.
5 mile.
You are questioning it now.
Sorry, yes, my lord. Actually, notice was issued, and then the court was not sitting, and then they have 2 dates.
19/12/2025, whereby the court has issued suit summons. It is submitted that in a suit for declaration injunction, when he has filed an IA number 1 and 2, seeking injunction, the court ought to have considered the same. Land counsel has placed before the court the order sheet to show that the defendants are served.
Only different number 3s appear.
It is submitted that the matter is pending till now. It is a submission to the land counsel that when an application is filed seeking ad interim injunction, the court has to consider the same on the merits of the matter, and the court cannot issue suit summons. He has relied on a judgment of the coordinate bench of this court and so, considering the submission of the land counsel, the petition and the judgment of the coordinate bench of this court. This court deems it appropriate to force following order. The petition is disposed of, directing the court to consider IA number so in accordance with law within a period of 1 week from the date of receipt of the copy of the order, notwithstanding the fact that the notice is not served on the defendant.
Cell number 18. Patabi Ramansi.
I'm appearing the petition, the suit for partition. I am the third defendant, wherein I appear the IA-5 to condone the delay of 32 days for filing written statement.
32 days.
32.
It's a regular suit.
Yes, my lord.
Suit was filed when?
Suit was filed, my lord. On 13/6/2025, suit was filed, my lord.
13/6/2025.
6/2025.
After the amendment.
No, suit was filed on 30, wherein I am the third defendant.
I'm saying after the amendment.
No, amendment was not done. 13/6/25, suit was filed.
Amendment to the CPC.
Yes, ma'am, after the amendment.
Land counsel with the petition submits that. He has filed the written statement after with the delay of 35 days that came to be dismissed in the light of the amended provision to the CPC. It is submitted that a coordinate bench of this court has stayed the operation of the same, considering the same. There shall be stay of all further proceedings pursuant to the order dated so and so. The same hand summons, notice, third memo shall be filed, or else stay granted by this court stands vacated. Yes.
Cell number 19. Rupesh Kumar S for petitioner.
Yes.
Petitioner.
Who
Excuse me, Lord.
appears?
Lord, I'll take notice for 1, 7 and 8, my lord. Contesting respondent is CHESCOM, my lord.
AGA takes notice on behalf of 1,
7 and 8, my lord.
1, 7 and
8, my
8. Why you made these many people parties?
But, I have submitted representation to all of them, my lord. That is the reason.
Serve the papers on.
Yes, yes, my lord.
Give the panel councils.
The state I have already served, my lord.
No, BESCOM.
Yes, yes.
Then I'll dispose of the
It is CHESCOM,
representation.
CHESCOM, my lord. CHESCOM, Mysore.
It is-
Mysore, CHESCOM, CES.
Oh, who are the council?
Not aware, my lord. I'll ascertain.
Oh, there was the other day somebody appeared for this Chamundeswari electrical. The other day I disposed of on matter. One lady advocate appeared. Find out and the petitioner is permitted to serve the notice, serve the papers on the panel council. List this matter tomorrow, print the name of so and so, tell the court office. Tomorrow in the first list.
Impugned endorsement is in Kannada.
Huh?
Impugned endorsement is in Kannada. My lord. I may have to translate.
What is that? We seeking a dispose of representation.
Please.
If other side is there, we can do.
Please.
Yes.
Till number 20. Ingegowda.
Yes.
This is a suit for permanent injection and later on it was amended for a declaration suit. Okay, I filed a IA and the 26 rule 9 for the appointment of the commissioner.
What the suit for? Declaration.
Basically, it's a permanent injunction.
What is the present stage of the suit?
Present, it was a cross-examination of D2.
Evidence is not completed.
Evidence is not completed. So on the basis of the sale deed of the defendants, so they take the wrong measurement. On the basis of that, the municipal has been issued the permission for the construction. So the survey has been conducted in the different land and they have encroached my 9 into 34 square feet of land. So I filed for the appointment of commissioner and the trial court has been rejected the application.
Let's see the order. Where is the order?
It's page number 13, Swami. Your Lordship, it's Annexure A. Annexure A, page number 13. Reasons.
Yes.
Suit filed by the plaintiff against the defendants for the relief of declaration of title and permanent injunction respect to the suit scheduled property and submits that the defendants have created some documents and they have not claimed any right or interest over the suit scheduled property. And the defendants have set up their false defense for trying to grab the suit scheduled property, hence just and necessary to appoint the above said technical person as a court commissioner to demarcate, resolve the dispute arise in this suit. On the other hand, the defendants have resisted the said application by submitted the objection and they are contending that the suit scheduled property is not identified and also the property is not in existence. He is trying to make the trace out and identify of the suit scheduled property, hence it is not acceptable under the law, hence pressed to reject the same.
Yes, will grant you liberty to move an application once the evidence is concluded, if it is required, not at this stage.
Now, one submission, we have the trial court advocate has been advised to file the amendment application because in the original plaint he has not bifurcated A scheduled property and out of that B scheduled property which
Whatever
has been
it is,
encroached.
now at this stage, will not allow this application and at the same time give you a liberty after the evidence is concluded, if it is warranted, then you can move an application and the court will consider in accordance with law. Please come. Agreed with the order. The petition is before this court. Agreed with the order dated 15/12/2022.
And both the plaintiff and the defendants have not they have not explained their scheduled property, even the defendants
Passed
their
on
boundary.
on an application under 26 rule 9 read with 151 CPC. In OS number 233 of 2012 by the third additional civil judge and JMFC at Mandya, dated 23rd September 2025. The petitioner before this court is the plaintiff. Originally, the suit is filed seeking the relief of injunction. Thereafter, sought amendment for the seeking declaration and injunction. When the suit is posted for the defendant's evidence, At that time, an application is filed under Order 6 Rule 9, read with Section 151 CPC, for appointment of a technical person as court commissioner for local inspection to measure and demarcate the suit property and also the alleged property claimed by the defendants, and to report the same to the court so as to enable the court to come to just and fair decision in the matter, as it is essential to meet the ends of justice and equity. The court, by order impugned, had dismissed the application. While dismissing the application, the court had observed that the suit is filed with the plaintiff against the defendant seeking declaration. It is a case that the defendants have created some documents and they have not claimed any right or interest of the suit scheduled property. And the defendants have set up their false defense for trying to grab the suit scheduled property. Hence, it is just and necessary to appoint the technical person to demarcate or resolve the dispute arised in the suit. The court observed that when the plaintiff has come before the court seeking a relief of declaration injunction, the burden lies on the plaintiff to prove his title with cogent evidence by placing relevant documents. In this case, evidence is also commenced and also they're ready and they have already adduced the evidence. If the suit scheduled property is inspected by the court commissioner, then it would amount to collection of evidence because the parties may be put to confusion and inconvenience in proceeding with the suit. At this stage, the court is of the opinion that appointment of commissioner at the stage of the suit will amount to collection of evidence, and the application filed with the plaintiff is not acceptable at this stage in the eye of law, and there is no merit in the application. Hence, the court has dismissed the application. When counsel appearing for the petitioner submits that the court ought to have considered the application in the light of the dispute between the parties when it is a specific case of the plaintiff that the defendant has encroached the land of the plaintiff, and if the commissioner is appointed, the true facts will come to light and it will help the court to adjudicate the dispute between the parties, and the court, without considering the same, has dismissed the application. Next para. Having heard the counsels on either side, peruse the material on record. The suit is filed for declaration and injunction. As rightly observed by the court, the burden lies on the plaintiff to prove his case. No doubt, the advocate commissioner can be appointed when in the considered opinion of the court. That is very much necessary to decide the dispute between the parties. In this case, the case is at the stage of evidence. Once the evidence is completed and basing on the evidence let in by the parties, when the issue cannot be resolved between the parties and appointment of an advocate commissioner is necessary, the court would be doing so at an appropriate stage. As rightly observed by the court, this is not the stage for appointment of the commissioner. In that view of the matter, this court do not find any reasons to interfere. Next, accordingly, this court is passing the following order. The writ petition is, this court do not find any infirmity with the order passed by the court, accordingly dismissed. Number 2, however, it will not preclude the petitioner from making an appropriate application once the evidence is completed, and the court shall consider the same in accordance with law.
So number 21, let it be.
Yes. Yes.
Petitioner is the owner of the vehicle, Lord. The award has been passed and it was enhanced by this honorable court. Subsequently, Lord, execution petition was filed. Executing court has directed to auction the movable properties, and in view of that order, Lord, the movables were auctioned. Then, Lord, the further proceeded by the executing court to issuing warrant. Since, Lord, the entire amount has not recovered. Now, Lord, by virtue of that further proceedings, Lord, the arrest warrant has been issued. Lord, in order to take such coercive steps, the application to be explained with the deliberate act of with the intentionally, he filed an affidavit said he do not have any means. And without such application, the court has proceeded further to arrest him.
Are sold,
Property is auctioned.
immovable properties are auctioned.
Auctioned.
How much is realized?
That as per the auction, not only 50,000 was recovered.
What was the amount to be paid?
11.5 lakhs.
Come to the application, come to the order impugned.
Lord, the impugned order, as per the executing court at page number 77. Lord.
Let's read from the reasoning part.
Please.
Yes.
The affidavit of, in the affidavit, PW1 stated that petitioner number 2 and 3 are his brother and sister. They have filed an above execution case for recovery of award amount so and so, which was modified by the Honorable High Court so and so. In future interest at the cost of execution petition due from the judgment debtor. The respondent number 2 is the owner of the goods vehicle bearing number so and so. Mode of recovery of attachment of movable belongings to the respondent apart from the arrest. The JDR number 2 has raised a false and frivolous contention that he has no means to pay the decree amount. JDR number 2 is the owner of the goods vehicle so and so. The said vehicle is commercial vehicle and said respondent depriving the income from the said vehicle. He has do not doing tender coconut business. The said respondent is earning more than 5,000 per day from the above goods and vehicles by tendering coconut business. He has produced the B extract of the above vehicle and Abdul Karim son of so and so, the owner of the vehicle, and his judgment debtor number 2. The debtor number 1 is sufficient means and asset to pay the decretal amount to the. He is intentionally avoiding and neglecting to make payment. Hence, he prays that the above vehicle may be attached and sold it in the auction, and sale proceed may be paid over them. In the cross-examination, the counsel for the accused has deposed that he knows the condition that vehicle stated at exhibit P1 and denied that the vehicle is not in good condition.
For attachment.
Yes. Now they are attached. And for
The present order, I am asking.
present order, kindly see at page number at the page number 34.
34.
KP advocate files IA for so and so, seeking set up the purchase of the amounts.
Passed an order.
Yes.
Please come. Then counsel for the petitioner submits that in the execution. Initially, an application is filed for attachment of the mobiles, and the same was ordered. Thereafter, the order was executed, and as for the bailiff report, the vehicle was auctioned for rupees 53,000. Thereafter, the advocate for the decree holder filed a memo seeking issuance of arrest warrant for remaining balance of amount. The court has issued arrest warrant. When counsel for the petitioner submits that, the court the court without assigning any reasons cannot issue arrest warrant when it is a specific case of the plaintiff of the judgment debtor that he has no means to pay, and even the decree holder has not placed any material on record to the contrary. In spite of that, an order bereft of reasons is passed by the executing court. Considering the same, there shall be stay of all further proceedings pursuant to the order dated so and so. Same notice on the council memo by 3rd of August, or the stay granted by this court stands vacated. Yes, next.
22, Santosh S. Gogi.
I appeal for petitioner in this matter, my lords.
Yes.
My apology, my lords, for some little inconvenience, my lords, personally I could not go.
Yes.
My lords, it's a petitioner is the defendant, my lords. A plaintiff application for amendment is allowed. My lords.
What is the suit for?
My lords, amendment, my lord, they want to sort, my lords, permanent injunction, they want to seek a cancellation of a sale deed, declaration for cancellation of sale deed, my lords. Which in fact, my lords, I can't.
Suit is of which year?
The suit is of year 2014, my lords. Suit filed on 28/8/2014. I
What is
filed
the
a
origin?
written
What is the original prayer?
prayer for permanent injunction, my lords. Could find it page number 34, my lords. And my lords, categorical admission in plaintiff.
And you have denied the title of the plaintiff by filing the written statement.
Yes, my lords. And I disclosed about this sale deed in 2015 when I filed about, my lords, in the written statement.
Please
And
come.
after 8 years, my lords.
That counts for the petitioner submits that the suit is filed in the year 2014, seeking bare injunction. And the year now, when is this application?
2022 application is filed on 16/3/2022.
When is the order passed?
Order is passed on 2/3/26.
It is submitted that in the year 2022, an application is filed under order 6 rule 17, seeking amendment of the pleadings, whereby now the petitioner wants a relief of the declaration and also that the sale
Declaration of cancellation of sale deed, my lords, not for ownership declaration.
declaration that the sale deeds are not sale deeds are null and void.
Yes, my lords.
Sale deeds are null and void. It is submitted that in a suit of 2014 and a relief 2022, and the court, without considering any of these aspects, has allowed the amendment. Considering the same, there shall be stay of all further proceedings pursuant to so and so. Notice to the same. In this also, third by memo shall be filed by third. Yes, next.
Please, ma'am.
Yes.
Page 56. Issues had to be recast, some additional issues. We filed that application for additional issues. The trial court, by a cryptic order, says because there is no rejoinder to the additional written statement, there is no need for kindly similar the order. Just a 4-line or 2-para order, page 51.
You're the defendant in the suit.
I'm the defendant. So 15, page 15, 51, sorry, 15, sorry, running page 15. Counsel for the defendant filed IA.
No, 50 or the original issues.
50, I'll just, correct. 50 was
What are the issues?
No, not the additional issues. Kindly see page 52. The additional issues which I sought to be recast. In view of the additional written statement which was permitted by this court in January 26.
No rejoinder is filed.
No rejoinder is filed. No, Lord, assuming, Lord, a plaint is filed, no written statement is filed. But still, one or two issues will
But
be filed.
generally, if it is case of the plaintiff,
Yes.
because the burden lies on him, the issues will be framed
Yes,
on that.
yes. But
No,
Lord,
whatever you have raised, he has no
Yes.
objection for that.
Correct.
That's what has to be assumed because he has not.
correct. But what will happen, Lord, is supposing there is an issue pertaining to identity of property which I have raised in the additional written statement. And there is an issue that he has not executed, the GPA has not resulted in transmission of possession. That issue had to be framed by the court, Lord, because
No,
we have to
he
go
has
on.
not filed the rejoinder to that. That means he's accepting all your.
But Lord,
submissions.
in a
Continue.
similar situation, Lord,
Mm.
assuming that the written statement is not filed, plaintiff will still have
No,
to.
but plaintiff just stands on a different footing.
Yes,
Because he has
yes.
to prove his case.
Yes,
So
but Lord,
whether you file or don't file,
Yes.
he has to succeed on
Yes.
his own merits.
yes, but what would happen on the contrary is, I'm just placing before you.
Yes.
Suppose written statement is filed and plaintiff succeeds in his burden, then I will have to prove, or the burden shifts for proving all the other issues, which I have raised. On that principle, Lord, he should have recorded the issues because when it shifts will depend on how much of evidence he has read. It is all taken together after both parties have led the evidence. On that principle, Lord, he could not have said.
Suit for.
Suit is for declaration.
Declaration that he is the owner of the property.
That he is the owner of the property.
And
That
what
is why
is the
I'm not-
case of the defendant?
Defendant is, one is that he has obtained, that his original schedule does not match with the sale deed schedule, that he has got a subsequent rectification in order as an afterthought. And then that the GPA that is there with, and an agreement which shows that possession is transferred does not show the possession.
We'll issue a short notice.
Please, please.
Notice to the respondents, petition is permitted to take out handsomens and shall file.
But because he is going almost day to day,
No, but it is just, I have granted about 10 days.
because he has taken my cross as nil simultaneously, and then he has proceeded to their to arguments. That is why.
But I can give you a short date, but I will not.
One
grant stay
issue
in
will
this.
be, he
No,
may.
I can take it after 2 days also, provided he.
But
he
can
serves the-
can he be requested not to pass any fine notes? That's all.
No, no, what I can do is I can take up this matter on 27th.
Ah.
Let him come up with the memo, I'll take up the matter. Even end of, on Friday also, but I will not grant stay. Because I'm, prima facie, I'm not convinced.
Trial is over. Blood.
Trial is over.
Trial is over. He takes my, in the same order,
When is this recasting of issues?
blood, after this honorable court granted the order.
When was that order?
That was on 26 January 2026. Then we filed the recast immediately.
No, 26 Jan, we are in July.
Correct, Lord. Then we filed the recast immediately. Then he took some time to pass orders. But what he did, on the day he rejected the recast, he said cross of PW1 is nil.
When was it rejected?
This was rejected on 9/6/26. And he says, in the same order, Lord, which I read to your lordships, he says cross of PW1 is nil. And proceeds.
This
to
is
next.
matter on 27th of July. By 24th, the petition shall serve the hand summons on the council appearing for the respondent and shall file a memo to that effect. On 20, if a memo is filed on 24th, this is matter on 27th. Until 27th, the pronouncement of judgment shall be deferred.
Please. Oblige.
And by that time, if memo is not filed by 24th, the interim order granted by this court stands vacated.
Yes, please. Oblige.
Number 24, Kalyanar for petitioner.
The defendant's petition.
Yes.
But, the defendant has filed an application for appointment of court commissioner.
What is the suit for?
Suit for bare injunction.
You are the plaintiff?
I am the defendant. My lord, the plaint A schedule property is measuring about 48 acres. The case of the plaintiff is this was a Goma land, government land, and he is claiming an extent of 20 cents out of 48 acres.
20 cents out of 48 acres.
48 acres. That is the B schedule property. The allegations of the plaintiff is that the defendant is trying to put up construction in his property. Therefore, he has approached the civil court. Now the evidence is.
Who is the defendant?
I am the defendant, the petitioner.
No. What is the relationship and what is the,
They are not related. He claims to be the owner of the property.
what is the case of the defendant?
Case of the defendant is that, my lord, he is the owner of the property.
It's a government land.
Which government land, it is subsequently granted. There are several other revenue records.
In
The
favor of the
defendant, the
defendant.
plaintiff does not dispute my property is concerned. Only disputed question of fact is the identity of the property. He claims that I am putting up construction in his property. The defendant says that, my lord, he is putting up construction in his property.
So
There
you
is no
filed the application or?
filed the application for appointment of a court commissioner to ascertain in which property I am putting up construction. The
For bare injunction.
suit for bare injunction. The trial court holds that, my lord, it amounts to collection of evidence. To put an end to the dispute, if I am putting up construction in my property, the question of consideration of.
What is the stage of the proceeding?
Now it is posted after recording evidence. It is now posted for arguments. The application for appointment of commissioner can be done only after completion of the evidence.
Please come. Let counsel for the petitioner. Where is the order?
My lord, order is annexure A. My lord, translation is at, my lord, page number.
Agreed with the
18.
counsel for the petitioner submits in a suit for bare injunction. When both the plaintiff and dispute, when there is a dispute with regard to the property and where the construction is made. After the evidence is completed, an application is filed by the defendant that came to be rejected by the trial court and says before this court. And it is submitted that the court ought to have or to appointed a commissioner, which will help the court in adjudicating the disputes between the parties concerning the same. There shall be stay of all further proceedings pursuant to the order dated. Same appear the third other matters, all the matters. Notice to respondent, narration, and substance. Third of this order, statement of the report is advocated. All the matters the same.
Lord, in serial number 25, my lord, I may be permitted to appear online, my lord. Some difficulty. My lord, petitioner is the decree holder.
Yes.
My lord, the decree is for declaration of title and, my lord, mandatory injunction. My lord, the defendant filed a counter suit for injunction. My lord, plaintiff suit was dismissed. Defendant suit for injunction was decreed. My lord, first appellate court, my lord, reverses it. Decrees my suit, and my lord, plaintiff is declared as the owner, my lord, and mandatory injunction is, my lord, given to clear the encroachment. My lord,
Yes.
matter comes before this court, my lord, in an RSA, and in an RSA, my lord, there is a compromise that is filed. My lord, compromise petition, my colleague will hand over. The order, my lords, will get at page number 116. The order is there, my lord, by oversight, my lord, compromise was not, my lord, attached. My lord, compromise is that, my lord, the appellant who is the defendant who has suffered the decree will pay 18 lakhs as compensation. My lord, that had to be paid as per, my lord, para number 4 on or before 3rd of January.
Next matter. Next matter will come. Some technical issues. Yes, next.
Cell number 26. Cell number 26, Subba Reddy Kane for petitioner.
26. This property of this petitioner, my lord, I'm the plaintiff. Property of this seeking eviction. Property was used by the government for sub-registrar's office. Now, what they did in September 2021, they vacated to another office, but they kept all their things inside. The whatever is their stores and other things, they kept it inside. So I've been asking them, Lord, take the balance material, give me the keys, pay the arrears of rent till date. This is the short controversy, Lord. What they have done, they have not paid any arrears of rent, saying that we have vacated the premises, but they have kept their goods inside, substantial goods inside. Normally, if I enter, I cannot take possession unless it is handed over by the court. So I asked them, deposit the balance arrears of rent before the court. Don't even give it to me, number one. Or else unlock the premises for it to be cleaned because there's so much of dirt there. So court has said, we cannot direct deposit of rent. But court has said, defendant shall cooperate in unlocking the premises and cleaning the premises.
No, what is this? What is the decree?
The
pending.
Suit is pending. Suit is pending.
And it is a case of the defendants that they have vacated it.
They say they have vacated, but there is substantial sub-registrar's office material there. So I cannot enter and take possession.
AGA takes notice on behalf of the first respondent. Look into it.
Copy is not.
Suppose them, Lord, they can hand over the keys to me.
That's what.
We'll
Pass
fight
a
it
final
out.
order.
Yes.
Yes, AGA
We'll
takes
serve a copy.
notice
Serve.
on behalf of the respondent and counsel the petition serve the copy of the writ petition. Does this matter on 28th?
Please.
Cell number 27, MD Raghunath for petitioner.
I am a tenant in respect of the scheduled property under R4, respondent number 4. Bescom issues a notice to me at Annexure G, page 27, saying that this property where the transformer I have put up is in the property belonging to BDA, please. BDA doesn't issue notice to me. They give a direction
Please serve
that
the
I
notice on Mr. Vinayak VS. Mr. Vinayak VS is directed to take notice on behalf of the respondents number 2, 3.
2, 3 is BDM.
Oh, to
It's not
respondent number
to-
2. Now your grievance is only against Bescom.
because they wanted to disconnect the
Yes,
property.
first AGA takes notice. Then counsel for the petition serve the copy of the writ petition on both the councils. Print the name of the councils tomorrow.
Please.
In the first list.
Please.
Yes.
Cell number 28. 28, Ashok P.
My lords, in this
Yes.
matter, a suit is filed by the sister against brothers for the relief of partition, my lords. Along with the suit, an application for not alienating was also filed. Emergent notice was issued, my lords. Subsequent to the filing of suit, my lords, a suit item was sold out to in favor of third parties, my lord. Therefore, now that the respondent is trying to sell one more item, my lord. Therefore,
When is the suit summons issued?
my lords, order sheet in page number 42, my lords. 42, my lords. Plaintiff absent issue notice on IA.
This is dated?
This is dated, my lord, 3/8/2021, my lords. Till now, my lords, IA is not disposed. It is still pending, my lords.
So that you have come to the court too early.
My lords, they are illiterate, my lords. They are residing in village, my lords. Now one item.
Even till now, the court has not decided the IA.
Not yet, my lords.
Please come. Let counsel for the petitioner, the present writ petition is filed. Agreed with the order dated 3/8/2021, whereby the trial court has issued suit summons without considering the IA, which is filed by the petitioner not to alienate. Which court is this? Write this. The petition is agreed with the order dated. Order dated 3, you said what is the order?
3/8/2021, my lords.
3/8/2021 by the civil judge in JMSC Kankapura in OS number 334 of 2021, whereby the court has issued suit summons. It is submitted that it is suit for 2021. Even till now, the notices are not served.
Notice is served and return statement is filed, but IA is not decided.
It is submitted that the notices are served, and even after appearance of the parties and the written statement is filed, till now the court has failed to consider IA number 1. It is submitted that one of the suit scheduled property is already sold by the defendants, and if the court fails to pass any orders on the IA, there is every likelihood that they may alienate the other properties. Next, considering the submission of the land counsel of the petitioner. No, before that, when an application is filed seeking interim injunction, if the court has to consider the same and pass orders on the merits of the court cannot issue suit summons. A coordinate bench of this court in so and so has held extract that in the light of the submissions made with the petitioner and the light of the order passed by a coordinate bench, and considering the fact that right from 2021 IA number 1 of 2021 is pending before the court. This court deems it appropriate to pass following order. The writ petition is disposed of directing the so and so to consider IA number 1 of 2021 within a period of 1 week from the date of receipt of the copy of the order.
My lords, till then, in order of status government.
No.
Bill number 29.
We will not further, increase litigation.
Please.
Yes.
29, Girish B. Baldare.
Plaintiff writ petition, my lordship, suit filed for seeking specific performance of contract. And defendant filed the written statement on 9/2/2024.
Plaintiff is the?
Ismail?
You are the plaintiff.
I am the plaintiff.
What is the suit?
Suit for seeking specific performance of contract. And defendant filed the written statement on 9/2/2024. And the very same day, application came to be filed under section 45 of the Indian Evidence Act for sending the documents, agreement and renewal agreement.
By the defendant or by you?
Defendant has filed, my lordship. For sending the documents for a scientific expert. And that application and IA number 1 is still pending for consideration. Subsequently, another IA was filed, which is in page number 91, my lordship, annexure. Initial IA was filed on IA number 4 in page number 43, my lordship.
Yes.
As on today, no order has been passed on the IA number 4.
Now, IA number 8.
Subsequently, IA number 8 is filed on the same cause of action and the same relief. And said application is allowed without the trial yet to be commenced. Evidence is not yet commenced.
No, your grievance is that second application is allowed, and allowing the application is bad.
Allowing application is there is an irregularity committed by the court below. Yes, my lordship.
Come to the order impugned. Page number?
Page number, reasoning is page number 108, my lordship.
108?
Because it is, when there is an ambiguity during the course of the trial, the court can allow such application. The evidence are not yet commenced, my lordship, and the documents are not yet marked. In the written statement is also not allowed. It is filed in a belated stage. After
it is not taken on record.
That is not taken on record.
And now the court allows this application.
No, the court has allowed this application. I take your lordship to the order sheet.
Please come, then counsel the petition submitted. OS number, suit is filed seeking specific performance. The defendant written statement is of, as of now, is not taken on record. Earlier, he has filed IA number 1, seeking IA number 1 to send the suit agreement of sale.
IA number 4, my lord.
IA number 4 to send the suit agreement of sale for expert opinion. And when that order, that IG is pending consultation, again IA number 8 is filed, and the court has allowed that application. It is submitted that the evidence is not let in. No evidence is not let in. The written statement is not taken on record. In those circumstances, court ought not to have allowed the application. Considering the submission, there shall be stay of all further proceedings.
The further proceedings of the
There shall be stay of operation of the order dated so and so. Notice to the respondents. A memo shall be filed by 3rd, or else the stay granted with this court stands vacated 3rd of August. Yes, next.
13, 18B for petitioner.
I request for pass over, my lords, as senior as.
Pass over. In your passwords will not be called. I pass over it. Yes.
Cell number 31. N. Sridhar.
Appearing for petitioner, challenging the order of attachment of mobiles and arrest warrant against the petitioners in execution petition, my lord. Petitioners of the remote villages and the illiterate, my lord. Respondent is the finance.
Is this a matter you have mentioned the other day?
Yes, ma'am.
It has come without a memo?
No, I have filed the memo prior to that, my lord.
It has not come because of the memo. It has come up because of office objections are complied. So what I request the advocates is don't burden the court with all mentionings in the morning. Provided you comply with, there is no, I am not putting.
She was on leave, my lord. That is the reason. That's minor office objection.
That's what minor or major. Only you comply, then only it will come.
And she's on leave. So 17 we could not.
Yes.
My lord, finance, my lord. It's page number 12, my lord.
Yes, come to the order.
Yes, my lord. I'll just read out para number 2, my lord. Judgment letter number 1 to 3 appear through the advocate in response to the issuance of cause notice and filed the objection stating that the illiterate, they do not read and write than other language except Kannada. The main branch of DHR office is situated at Tamil Nadu, Chennai. They are having the branch at Tipturu town. The officers of DHR from Tipturu branch came their house and told them they would lend the money to mortgage of the landed house property. The JDR borrowed the loan of 4 lakh on 5/12/2019, but they were not aware that they were agreed to repay the same in 84 equal monthly installment of rupees 10,062. But they told that the DHR that they would pay the same in 48 equal monthly installment at the rate of 10,062 PM. But the DHR had deceived them, taking the advantage their literacy. In all, they paid the 3,52,170 in 35 installment at the rate of so and so. The balance amount has been received by the field officer of DHR, but he did not issue the receipt, thereby cheated him. They are not due any towards the loan amount of 4 lakh borrowed from DHR, and even prior to release of 4 lakh, DHR received 30,000 from JDR, and they have taken 50,000 to get the e-khata in the name of JDR. Hence, they have received only 20,000 from JDR, but out of that,
Can these kind of objections be considered by the court?
It is a objection we have filed that it is not considered, ma'am.
No. Award is passed. It's for execution.
Award, we have not received the notice, ma'am. Award is in the Tamil Nadu.
In that case, what you should do?
If
you are not received
next page, arrest warrant.
I have seen that.
Arrest warrant, attachment of mobiles. This is finding it has been given and reasoning is here, and it is order has been passed, my lord.
Fourth page, it is not there. The objections filed
Next
with
page,
judgment
50.
letter.
This is objection, my lord. And it's in Kannada.
No, what I'm not able to understand is, when the decree is passed, executing court's duty is to execute the decree. You are a judgment debtor.
Yes, my lord.
Go before the court and say that then you have to go before, you have to question that.
No, it is not allowing, my lord.
That's not the order.
My lord.
The court cannot pass any order of that nature.
It's today it is posted, my lord. Arrest warrant.
I'm not convinced.
My lord, it is, see, they are demanding, they have, we already filed 3,52,000, my lord. Now they are demanding 7 lakh something, my lord. It is goes around, we have taken only 4 lakhs, my lord, and they intimated that it is 48 installments.
There are two things. One is about the award, you're not a party, you're not received notices and all. Go, you have to avail the remedy available.
Like we
to
have
you.
highlighted, my, but it is not considered, my lord. We have not
So
received
why
the,
will the court consider, executing court, why will it consider?
my lord, we have not received any notice from this proceedings, my lord.
I think I don't have to tell you what is to be done. What you have to do, you have to question that award.
My lord,
Set
stay
aside
this
the-
order, my lord.
Huh?
Stay this order, my lord.
Why should I say this order? Without a reason.
Because we are not knowing the proceedings, my lord. And that too, that head office is in Chennai, my lord. We have not
Let
received
it
the
be, let
notice,
it
my
be.
lord.
I'm not convinced. Yes. Notice to the respondents. Yes.
It is posted today, my lord. My lord, kindly see the interest rate, 48 installments, it goes around 8 lakh to 45,280, my lord. They have borrowed only 4 lakh, my lord.
How much you're going to pay now?
No, now already we have paid 3,52,000 to 2,000. Now they are demanding
The
for
money-
another
it's a-
7.5
It's
lakh.
a
my-
money decree. It will not be
It
stayed
is
just like
another
that.
7.5 lakh. We are illiterate, my lord. They are not knowing. We are not knowing about all these things.
Yes, notice to the respondents.
Cell number 32, Shankar Narayan Bhatt. N.
Question. Defense petition, my lord. The suit for partition was filed, and after service of notice on 112 parties to appear, and on that day petitioners appeared through their advocate, and it was adjourned to 6/3 for final written statement. Because it is beyond 90 days, the defense advocate advanced it to 3/2 or 26 and filed written statement. Learned judge rejected that, stating that's barred by time.
Suit is filed when?
Suit is filed on 25/7/25.
Please come. Counsel for the petitioner submits that the court has refused to take the written statement on record as it is beyond 120 days. It is submitted that the coordinate of this court has stated the operation of the amended provision in that view of the matter. They shall be considering the submission. They shall be stay of all further proceedings. That number and all will be there in the other order. Notice to the respondents, same hand summons third. Memo shall be filed or else a stay granted to this.
Interim.
Yes.
Cell number
Well,
33,
interim
Mohan
prayer.
Kumar D. Mohan Kumar D.
I'm the plaintiff before the trial court, my lords. I have filed a suit for bare injunction and along with IA, my lords, 39 rule 1 and 2, my lords. My lords, while passing in order, my lords, which is at page number 35, my lords, the trial court observed that, my lords, I am the owner of the property and I have not produced the survey documents. That's the, he wants.
What is the suit for?
Suit for bare injunction, my lords. My lords, defendants is interfering with my possession and creating illegal activities, my lords. My lords, annexure F, my lords, page number 41, which is a sale deed, my lords. I have purchased the suit schedule property in the year 2015, my lords. Till 2015, till today, my lords, I am in the possession, my lords. When I have applied for a survey, my lords, and adbust is also done, my lords. Kindly see, my lords, which is at page number 77.
I'll ask the court to hear it.
My lords,
I'll ask the court to hear this matter.
my lords, yes, my lords.
Please come.
My lords, I have also, my lords, after this order, my lords, I have also advanced, I have praised the court to advance.
With the order dated 15/7/2026, passed with the civil judge and JMSC Devanhalli, Bangalore Rural, invoice number 341 of 2026. It is submitted that when the petitioners filed an IA seeking ad interim injunction that came to be, in that the court has issued the suit summons, it is submitted that the court ought to have passed an order on the merits of the matter. It is submitted, he has relied on a judgment of the coordinate bench of this court and so and so. The having heard the land counsel for the petitioner presents the material on record. When the application is filed, seeking ad interim injunction, whether the petitioner is entitled for injunction, the same has to be granted. And if he is not entitled, the court should dismiss the same. But the court cannot issue summons in the light of the, in view of the same, this court is passing the following order. The order, the court shall hear IA number 1 within a period of 1 week from the date of receipt of the copy of the order, notwithstanding the fact that the notice is not served on the respondent.
That's one request, my lords. The defendants are creating more trouble, my lords. So order may be.
That submissions won't work out. Yes.
34, Shashanka K.
I am for petition. Let's. The defendant, I am the defendant in the original sentence. The plaintiff filed a suit against me for I am interfering in the suit schedule property. Then court has issued a notice. I have filed a detailed written statement and objections. Court has heard the application and disposed the application, saying that parties has to maintain this status quo because both the parties are claiming the very same property. Then they challenge the first appeal, MA. MA has reversed the order. Agreed by the same, I came.
Come to the order in MA. No, the court has granted injunction in the MA.
Yes,
directing you not to put up any construction.
Yes,
What's the difference between that and this? What is the difference between the trial court's order and the appellate court's order?
The trial court order, the
status quo. Not to put up any constructions.
Yes,
even in an order of status quo also, you can't put up any construction.
The thing is, here, while passing the MA, they restrain the defend means 1 minute. While directing, according to the IA under 13(1) the section so and so, Shumaga hereby set aside. That order has been set aside. That is why, again, consequently, defendant is hereby restrained the interfering to the plaintiff's possession and enjoyment over the suit schedule property pending disposal of the suit. Now they are trying to construct. That is the issue, The earlier order, if till disposal of original suit, there were no construction. I am in the position of the property.
It is stated the plaintiff and defendant both are directed not to put up any construction. If they are constructing.
Consequently, defendant here, page number 32, order passing MA.
Yes.
That order has been set aside. Consequently, the defendant is hereby restrained from interfering with the plaintiff's possession and enjoyment over the suit schedule property pending disposal of the suit.
Come to the reasoning part. Reasoning part.
Both the parties are claiming that.
Let's read the order from paragraph number 9.
9. The counsel for the appellant, the plaintiff, has advanced the argument and put up the narration of ground the appeal memo. The advocate respondent also argued the grounds of memo, so and para number 10. The plaintiff has filed this present suit for relief of permanent injunction. Further, she filed IA against the defendant seeking restraint from the restrain him from interfering with the peaceful possession and enjoyment of the suit schedule property. According to the plaintiff, she is in possession of the suit schedule property, though the schedule sale deed dated 8/4/2024 purchased from one Jayamma as a wife of Ramanna, so and so. This Jayamma acquired the suit schedule property through Hakkupatra in the year 1991-92, bearing site number 272, measuring 30 into 50 feet. In the Kata is still in the name of Jayamma. She moved application before the committee to transfer the Kata to her name. The issue is, I will come to the conclusion point. The entire argument advanced before the first appellate court is
to complete this order.
Yes, it is the case of the defendant that the Manjula acquired the property measuring 50 into 90 through the Hakkupatra. She gifted the 30 into 40 feet site measuring out of the measuring 50 into 90 in favor of the Kempegoda, son of Gopala Swami, through the registered gift deed dated 23/2014. Later, pertaining to the schedule, she has executed a gift deed based on the Kata, the mutation in favor of Kempegoda, son of Gopal Swami, on 4/12/2017. The said Kempegoda Gopala Swami sold the said property in favor of B.S. Chandrasekhar Shivarudrappa. Later, the said property sold in favor of defendant. Now, the defendant is in possession and enjoyment of the property. According to him, he has applied the license, construct the house in CMC, and authorities visited the spot and issued a license on 5/6/2024 to construct the house. He has prepared to construct the house in the property. Both the parties filed several documents to show that show their property. The plaintiff relied Hakkupatra issued in her favor, Srimati Jayamma, Gadikuppa Mandal Panchayat. The defendant is also related Hakkupatra issued the same Panchayat in favor of Manjula, wife of Dasegoda. Both produced a copy of the said document. In perusal of both Hakkupatra, it appears on 21/10/91-92
the suit schedule property granted in favor of Jayamma, wife of Ramana. The schedule noted in the application, the schedule noted in Hakkupatra produced by plaintiff are one and the same. The Hakkupatra clearly shows her vendor has allotted the site number 272 situated in Gram.
Yes, I have seen that.
Here, my lords, the issue is the Hakkupatra issued the vendors of me, my lords. Site number has not been mentioned. That is the crucial issue, my lords, while
Not
disposing.
only the site number, the boundaries are also not mentioned.
My lords, that has been rectified by the gift deed afterwards, my lords. That has been rectified. I produced the rectified gift deed schedule rectified, my lords, in the gift deed also, my lords. My vendor. My lords, I have and still till today I am paying the taxes to the concerned panchayat. The panchayat also so and town municipal
If you look at
corporation.
the appellate court's order, appellate court says that you have the Hakkupatra, the original grantee. What is
Yes,
mentioned
ma'am.
in the original grant is not there in your Hakkupatra, and there are no boundaries in your document. Without a boundaries, how can you claim that this property, as far as the plaintiff is concerned, it shows the boundaries. That's a
My lords, I
observation.
have been in 2000. I have purchased the property in the 2017. Till today, there was no interference. My lords. He has purchased the property in the 2024. Immediately, she filed a suit.
But the grant is much prior to your vendor.
My lords, the thing is, both the grant certificates are issued in the very same year, very same date, very from the
So
very
not
same
very same
panchayat.
date, two
My
different
lords,
dates.
dates are different, but very same year. My lords.
21/10/1992 and 23/10/92.
Yes, in the very same series, my lords. In the same process has been under the same process. My lords, the one of the grievance is, my lords, till disposal of original suit, my lords, if it is constructed.
Then counsel for the petitioner submits that the petitioner is a defendant in the suit, and the trial court, while considering the IA that's filed for injunction, has passed an order directing both the parties not to put up any construction. However, the appellate court has altered the said order and granted injunction. It is submitted that the only reason on which the court has reversed the order of the trial court is that the Hakkupatra, which is in favor of the defendant, does not contain the boundaries. It is the case that, in fact, the defendant has filed the owner has executed a rectification deed, and that has been placed on record, and the same was not discussed by the court. Considering the submission of the land counsel, this court deems it appropriate to direct the parties to maintain status quo. Notice to the respondents, petitioner is, there is a caveator is there.
Caveator is there.
You have served the papers on him.
I served the papers, my lords. Earlier
Then
occasion-
in that case, no interim order. Land counsel for though the caveat is filed on behalf of the respondents, no representation on behalf of the caveator. It is submitted that the papers were served. List this matter tomorrow. I'll dispose it of tomorrow in the first list. Yes.
Cell number 35. H.V. Bhanu Prakash for petitioner. Y.V. Ashwath Narayan Reddy for respondent.
I am for petitioner. The respondent number filed a suit for declaration. I am for defendant before the trial court, my lordship. They have filed a application for amended the return statement. The application has been dismissed, hence I filed this writ petition.
Suit is of the year 2007. When did you file the application? for
After
amendment?
filing the return statement, the defendant have got the document, my lordship. At the time of filing the
No,
return
no, no,
statement.
2007 is your written statement.
Yes.
When did you file this amendment? In the year
Recently, my lordship.
2025?
24/3/2026.
24/3/2026, yes. Now please come to your affidavit in support of the IA.
Support of the pink page number 103. 103.
Yes.
I am the GPA order of the Srimati Girija, son of Annappa and Sushila, daughter of so and so. I know the fact because I am the fairly submitted on behalf of the other them. The plaintiff have filed the above suit for declaration and position on respect of this land bearing survey number 71, measuring about 36 guntas, situated at Bagalonti village, so and so. I said after receiving the summons from this honorable court in the above suit, I have filed the return statement. At the time of filing the return statement, the sale agreement dated 12/7/95 entered between the plaintiff and Pailama Prasanna Kumar, Tammana Ramchandra in favor of the Ramya Gowda, BK
When was the
Narayan.
cross examination done? When was the cross-examination?
Cross-examination completed
When?
last 1 month back.
Notice to the respondents.
Notice already, the caveated copy has been already served.
Sir, it is, when counsel for the petition submits that he has served the caveat, he has served the papers on the caveator, no representation on their behalf. This is matter tomorrow. Tomorrow I'll pass out. Will see. He is the plaintiff.
Cell number 36,
No, that's the passed over matter, Mr. Abhinav Ramanan.
Abhinav Ramanan, pass over matter, serial number,
He appears to be
cell
on.
number 25. Cell number 25, Abhinav Ramanan.
I appear for the petitioner, my lord. My apologies. My lords may kindly see the compromise, my lord, and the order passed by this court, my lord. The compromise clearly states that, my lord, a sum of rupees 18 lakhs has to be paid. And my
Page
lord, if
number,
it is
where is the order in the RSA?
RSA order, my lords will get it. My lord, page number 116, my lord.
Yes.
My lord, it is a simple order which says that the compromise is taken. My lords may please take the compromise and appeal is disposed of in terms of the compromise.
No, yes, in terms of this, it is disposed of. Court has not expressed anything on this.
Yes, my lord. Now, my lord, the condition says that, my lord, on or before 3rd, my lord, the payment has to be made, or else consequences will follow. Now, my lord,
Has
the
agreed to
judgment
pay the
letter does
amount
not.
on or before 3/1/2020, failing which consequences will follow. Yes.
Yes, my lord. Now, my lord, after he does not pay, my lord, now, my lord, please turn to page 118. After failing to pay the compromise amount, when execution is taken out, my lord, at page 118, my lord, the judge 118, my lord, annexure F. The, my lord, judgment debtor would contend that the judgment and decree is not executable. That is the application which, my lord, the judgment debtor files. Please turn to page number 131. At para 22, my lord, it is noticed that 18 lakhs is not paid. And therefore, my lord, the decree becomes executable. And, my lord, the trial court judgment and decree, which is reversed by the appellate court, is not overturned or set aside. And the application is rejected. Now, my lord, I file an application.
So, as per this settlement, you are entitled to
Lord.
recover the money.
No, my lord, I am entitled to, my lord, if the money is not paid, I am entitled to, my lord, proceed with the execution and take possession. That is what, my lord, I showed. That is the order of the executing court, which is what I showed, my lords, my lord, page number 131.
No, I am referring to this memo that is filed before the
Yes,
court.
my lord. Memo says, my lord, if it is
The compromise is for the money.
ends with the money, my lord, if money is not paid, my lord, it says that consequences will follow, which is, my lord, I can execute it. That is how.
Consequences is what is agreed upon between the parties.
True, my lord. Now, consequence, my lord, is if the money is not paid, my lord, then I will be entitled to execute it. Of course, the decree does not specifically say so, or the compromise petition does not say so. But, my lord, the executing court interprets it in that.
No. In your compromise memo, you have not stated that the so and so has to pay this amount. If he fails to pay the amount, the original decree can be executed. That's not your case.
Yes, my
So,
lord.
by virtue of this
Unfortunately,
compromise
my lord,
memo,
it is not mentioned.
yes. So by the compromise memo is as it is accepted by the court. As per that, if
Yes,
that
ma'am.
amount is not paid, you can execute it. Now, what is that
My
now
lord,
you are
our-
seeking? You are seeking
my
to
lord,
execute the original.
Yes, my lord. Our interpretation, my lord, is, my lord, they have encroached upon the property. They were supposed to pay the amount by a cut-off date. If the, my lord, amount is not paid, then, my lord, the consequences will follow is, my lord, that we will be entitled to execute it.
Let respondent come, will say notice to the respondent and someone.
Yes, ma'am. Yes, ma'am.
Yes,
Grateful, my
next.
lord.
Number 36, cell number 36, T. Sheshgiri Rao for petitioner, CH Jairaj. Correspondent.
Yes.
Appear for the respondent.
All the respondents are served?
Contesting respondents.
Contesting.
Yes.
Whoever are contesting at
Yes,
that.
yes.
Annexure A is the order, my lords. It's a plaintiff's.
1 minute. There are how many respondents?
8 and 1 are served.
13 till there are 14 respondents. You appear for whom?
It's
I appear
only
for the
defendant number
legal
one
heirs,
and
legal heirs of the defendant number 2,
You appear for
that is respondent number 6 to
14.
14, I'll take notice. Caveat was
you
filed.
already taken notice?
Insofar as,
They're on KB.
insofar as respondent number 8, I had filed caveat, I'll take notice.
Then council submits 30 as instructions to file wakalat on behalf of respondents, 6 to 14.
Please.
And what about 5?
1A to 1E, my lords, I think they're represented by Mr. Rajesh.
I appear for
You
1A
appear for
to E, 1A to E, man.
1?
Respondent number 1,
1 to
A,
5.
A to E.
1 to 1.
His respondent numbers 1 to 5.
1 to 5.
R1 to R5.
R1 to R.
A to E.
So then it is completed.
Yes.
Yes.
Lords, the plaintiff is before this honorable court. Lords. If the lordship would see that it was a suit for declaration based on a will, and my lords, the suit was initially dismissed before the trial court. My lords, allowed by the first appellate court. My lords,
You're the
then
plaintiff. You're the plaintiff.
I am the plaintiff. My suit was dismissed before the trial court, allowed by the first appellate court. Then, my lords, ultimately the second appellate court remands the matter. I'll just point out what is the nature of remand. It remanded the matter on the count that the plaintiff is relying on a will. And when the plaintiff brought the witnesses to the court stand, the defendants did not examine them. And then later on, when they came before the court, or for some reason, when they came and they did not appear.
To that order, let us see
Please,
what
my
is the nature of
my lordship will see the RSA beginning at 124.
Yes.
The directions will be at 145.
Come to that.
Yes, my lordship. Does your lordships get 145 minutes?
Yes.
Regular second appeals are allowed.
Yes.
The judgment and decree dated so and so are all hereby set aside. Then the third one, OS number 94 is 185 of 94 is restored to its original file. Does your lordship? Liberty is reserved to the plaintiff to keep PW2 and 3 present for cross-examination, and court shall conclude the evidence of PW2 and 3 within 15 days from the date of appearance. It was conditional because the defendants had dilated the same before. And then thereafter pass appropriate judgment. The court has not made any adjudication on it. All contentions are kept open.
Yes.
Then office is directed to transmit so and so. And then last one is, if 68 is not possible, go to section 69 of the evidence. Remit, I would point out, it's a remit of this remand. So if my lordship would see, there are two parts to this. One, my lords, the suit in its entirety is restored back to its original file. Just to clarify what is the remit of the remand, that is 3, subcondition 3 in the judgment. And if my lordship would see.
And has limited the adjudication, what is the nature of remand and what is to be done has been stated here.
It's an open remand.
Yes.
It's an open remand. What was conditional was the examination should not take more than 15 days because the witness cannot come time and again.
That's what is the whole confusion in this order.
Exactly. If your lordships could see again, I can just point out.
No, I've seen when
Yes.
you say, when the court will say, if that is the intention of the court,
Yes.
this order is set aside and the matter is remanded only for the specific purpose of,
It was not so.
examining these witnesses under section so and so.
If that were to be the case, it would have done, the exercise would have been carried out under
Exhibit
4128.
P53 only. Exhibit P53 will.
That is the will. That is the will. That's not.
That is the will. Only for that purpose it was remanded.
No. Kindly, that is why I wanted to point out.
No, probably the court must have set aside the order because any finding that is given on this
Yes.
will alter the entire nature of
Exactly.
the suit.
That is
result
why
will
not
be
both
changed.
the suit. Otherwise,
But still from this, what we can infer is.
Yes, my lord.
The courts, the intent of the court is only to restrict it for the evidence.
may I just read out that part once again? If your lordship would see, Maybe I thought not. Then what happened not was the second appellate court at 141, 142 recorded the findings not of the first appellate court and noted not
So
that
why don't you seek a clarification of this order instead of you people interpreting it?
the trial judge is also very clear about the order, my lords. The trial judge is also very clear about the order.
According to the trial judge, what is the order?
My lords, the trial
According
judge.
to him, the entire,
Yes,
no,
yes.
it's everything is
Very
open.
well,
Now you will please start arguing on the merits of the matter. Everything, lead evidence, everything.
Then my lords, may I just take.
Case, if that is the case,
Yes,
court wouldn't have said that 15 days time.
15 days is only vis-a-vis the examination of PW2 entry.
So remaining things can take any amount of time.
Not exactly, my lords. I think we are in the 1991 suit. So we want to finish because it's my suit.
There was no, if all the contentions and all issues are
kept
open.
Open.
There was no reason for the court to fix a timeline of 15 days.
May I just point out not what is the 15 days for one moment. 18 is the order passed by the trial court on the amendment application. My lordship will see 27 for a moment.
Before reading this,
Yes.
please go to the preceding paragraphs.
In the
Yes,
second.
where is the mention about this evidence and all, how it is
Yes,
discussed by the
my
court?
lordship will get that there. In the while dealing with the
I
substantial
think you
question
can
of law,
come
my
to
lords,
paragraph number
139.
19. Paragraph number 19.
Fair enough. From the perusal of para 34 of the judgment of the first, it clearly discloses that the order sheets speaks that the plaintiff has made attempt to examine the witnesses, but as the date was given, they have turned up for cross-examination once, but the other side took time. This shows that the plaintiff has made all efforts to examine both the attestation document. The said finding recorded by the first appellate court in para 34 of the judgment is contrary to records. Although PW2 and 3 are attested to the alleged will, affidavit in form of examination in chief was filed. They have tendered themselves for cross-examination once. When the learned counsel for the defendant sought time on that day, further the matter was adjourned for cross-examination of PW2 and 3 and on that day PW2 and 3 remained absent. Trial court has taken the cross-examination of PW2 and 3 as nil. Thereafter matter was posted for judgment. Plaintiff filed an application for recall of PW2 and 3 for cross-examination. The said application was rejected and the plaintiff preferred writ petition which came to be dismissed in the absence of the evidence of testator of the will. First appellate court records a finding that the plaintiff has proved the will. The findings recorded by the first appellate court is contrary to section 68 of the Evidence Act, section 63 of the Indian Succession Act. Findings recorded by the first appellate court is arbitrary and erroneous and without application of mind. If the first appellate court had come to a conclusion, the plaintiff had made an attempt to examine the attestants of the will and did not tender themselves for cross-examination, the first appellate court could have remanded the matter to the trial.
Yes, I have read it. Please come to the impugned order.
Please, minutes. And so on, minutes, the judgment and decree is so and so. Now
Please.
kindly see, minutes, with this backdrop.
Impugned order.
Yes, minutes.
Page number.
18 it starts.
Yes.
And my lordship will see the findings or the reasonings at 25. If my lordship intend to see what is the nature of the amendment, not inter alia the same order, page 21 for a moment.
Page 20.
1.
Yes.
Page 21. This is the amendment. That's all. Nothing.
Yes.
It is submitted that the plaintiff, subsequent to presenting the suit, came to know that the sale of item number 6 of plain scheduled property by defendant number 1 in favor of defendant number 2. Taking note of the said fact into consideration, plaintiff has made the defendant number 2 as a party to the said suit. It is submitted that on the day when defendant number 1 sold item number 6 in favor of plain scheduled property in favor of defendant number 2, the will executed by Marisidaya dated 15/4/91 in favor of the plaintiff had already come into
I have read the order. I have read the order.
Very good.
Yes.
Now, your lordship saw the amendment part. This is the proposed amendment. So all we wanted to point out before the court was, a month before prior to filing of the suit, there was a sale which was executed by D1 in favor of D2 with respect to item number 6. In view of the operation of the will, that will not bind my right, title or interest over the same. 1. Number 2, minutes, we have also indicated that even prior to filing of the suit, 6-7 months before the filing of the suit, there was an intimation by way of a legal notice that there is a will. Please don't deal with any of the properties and it belongs to the plaintiff. That is sought to be introduced. That is also sought to be stated. If your lordship sees that last 2 lines in 21. And That is exhibit P54 for a moment. If my lordship would see the array of the trial exhibits 89 for a moment, the legal notice what is referred to in the last two lines in page 21 is exhibit P52. I'm sorry, not 54. It is so it's a part of record. Whatever was there, my lords, it's an elucidation of the part of record. Now, my lordship will see the finding of the trial court is only at page 27 for a moment. I can read the entire reasoning.
No, I have read it.
Yes. So now, my lordship will see 10 reiteration of what one says. Then, my lords, again 11, 12. Then, my lords, is the reiteration of what the defendant says. 13, my lords, is the condition is the judgment what one of us stated before the court. Then, my lords, 14 is what, my lords, the argument which the trial court says, my lords, it is right so for the moment. And then, my lords, the trial court says it has a very limited scope for giving an opportunity to examine the attesting witnesses. That is exhibit P53. Then, my lords, kindly see 27 minutes. Your lordship will get the clinching finding for one moment. May I, my lords, read it from IE to keep PW2 and 3 present for cross-examination, and there was cross-examination. Their cross-examination was supposed to be concluded within 15 days from the date of appearance of parties. Further, if PW2 and 3 were unavailable, opportunity was to be given to the plaintiff to lead evidence as per section 69. This is the nature of remit with respect to the timeline for examination and cross-examination only. Then, my lords, kindly see 15. This is the reasoning which is there before this court. Accordingly, the plaintiff side evidence has been concluded as per the direction of the Honorable High Court within 15 days. When the matter was posted for final argument, counsel for plaintiff has filed present which are beyond the scope of remand. Now, kindly see, my lords, is it a limited remand? Because, my lords, if it were to be a limited remand, I am very sure, my lords, exercise of powers would be under Rule 28. Possibly, my lords, the second appellate court itself would have said, I'll remit it only for the purpose of recording evidence, and I will again retransmit the records on this file. You argue the second appeal on its merits thereafter. It is not the nature of so. If my lordship would see the nature of the judgment, not the nature of the judgment and decree, my lords, is all contentions being kept open. It's an open remand. It's an open remand.
I'll consider. Please
it's
come.
open remand. And my lords, I'm sure that the other side may also say it's a post-trial amendment. It's a post-trial amendment, 2002. What are you doing? For that, my lords, the answer is.
I'm not asking the other side.
I'm sure, my lords.
Yes,
just pointing out. This is the answer to that also.
Take that.
Please, my lords.
The
The suit being of the year 94.
Yes.
The amending act 99 as well as 2002 is inapplicable to the current fact scenario. Not would be the consideration that has been held also.
Agreed with the order passed in. An IA.
While the lordships are disposing of, my lords, in that form or this form, liberty, my lords, in terms of 180, 105 also be reserved, my lords, so that in a future date, whatever happens at a future date to either of the parties.
What is that liberty?
105 CPC. In case if something, my lords, if because of one of these reasons, the trial court, my lords, chooses to go against me, rejecting my suit claim there. In an appeal court, my lords, I am entitled to raise that ground under 105.
That whatever
That's
is
the
available to
liberty. That is the
that
105.
whatever is
not that is-
available to you. Now I will only record whether the order of the court is correct or not.
Your lordship may hold. Your lordship may hold.
Agreed with the orders passed in. An IA. What is this IA number? There is no number to this. An IA that's filed under order 6, rule 17. Order passed and dated 2nd,
ALY.
2026
Number.
by the principal civil judge and JMFC at Nelvangala in OS number 185 of 1994. The petitioner plaintiff is before this court. The suit is filed by the plaintiff against the defendant for declaration to declare that the plaintiff is absolute owner of the suit scheduled property and for permanent injunction, restraining the defendants from interfering with his peaceful possession and enjoyment of the property. That came to be dismissed by judgment and decree dated 26/20/2011. Against that, the matter is carried in appeal. Plaintiff has carried the matter in appeal by filing RA number 10 of 2011. That came to be allowed by order dated 4th September 2013. Against that, the defendants have filed RSA number 2014 of 2013 and RSA number 1526 of 2013. Those two appeals were allowed by order dated by judgment and decree dated 18th November 2025. And the court has set aside the judgment and decree, and the operative portion of the order reads thus: at 145, extract the entire order. Thereafter, the petitioner has come up with the instant application under Order 6, Rule 17. By virtue of this amendment, the petitioner wants to place on record the pleading that the plaintiff, subsequent to presenting the suit, came to know about the sale of item number 6 of the plaintiff scheduled property by the defendant number 1 in favor of defendant number 2. Taking note of the said fact into consideration, the plaintiff has made the defendant number 2 as a party to the suit. And it is stated that when the defendant number 1 has sold item number 6 of the plain scheduled property in favor of defendant number 2, the will executed by the deceased Mari Siddhaya, dated 15/4/1991, in favor of the plaintiff had already came into operation. Since Mari Siddhaya was passed away on 3/6/1991 by bequeathing the scheduled property in favor of the plaintiff, consequently, the CLD dated 47/1994 is void and inoperative. And it is stated that the plaintiff, before instituting the suit, in the month of November 1993, got issued a legal notice to the defendant number 1, informing her about the will executed by Marisithaya in his favor. Despite the fact that defendant number 1 on 14/7/1994 has sold the scheduled property in favor of defendant number 2, consequently the CLD dated 47/1994 does not create any right, title, interest in favor of defendant number 2 in view of the will dated 15/4/1991. Then he wants to add before prayer B that the prayer that is sought to be added is: hold and declare that the sale deed dated 14/7/1994 executed by defendant number 1 in favor of defendant number 2 in respect of item number 6 of the plain scheduled property, which has been registered in the office of the sub-registrar Nelamangala as null and void, which does not affect the right of the plaintiff in respect of item number 6 of the plain scheduled property. That application seeking amendment came to be dismissed by order impugned. While dismissing the application, the court has observed that, as rightly contended by the counsel for the defendants, the Honorable High Court of Karnataka in RSA number 2014 of 2013, clubbed with RSA number 1526 of 2013, has restored the present suit on the file of the court with very limited scope by giving an opportunity to the plaintiff to examine the attesting witnesses of the will, that is Exhibit P53, that is to keep PW 2 and 3 present for cross-examination, and their cross-examination was supposed to be concluded within 15 days from the date of appearance of the parties. Further, if PW 2 and 3 are unavailable, an opportunity was to be given to the plaintiff to lead evidence as per Section 69 of the Evidence Act. Accordingly, the plaintiff side evidence has been concluded as per the directions of the High Court of Karnataka within 15 days, and when the matter was posted for final argument, the counsel for plaintiff has filed the present application, which are beyond the scope of remand, and further, as rightly contended by the counsel for the defendant, the CLD dated 14/7/1994 is already on record as Exhibit D1. Hence, the application is devoid of merits and accordingly dismissed. When counsel appearing for the petitioner plaintiff submits that if it is while remanding the matter, if it is if the scope of the remand is only to examine the PW1 and PW2, the court would have remanded the matter as far as that recording of evidence is concerned and would have kept the matter pending here. And after the same is placed before this court, after the evidence is recorded and the same is placed before the court would have examined the same. It is submitted that the court has set aside a judgment and decree and remanded the matter to the trial court when it is open for all the parties to make their submissions, and all the contentions are left open, and it is submitted that there is no cap on the remand, and it is a open, it's an adjudication in all the aspects. In those circumstances, when an application is filed by the petitioner under Order 6, Rule 17, seeking amendment of the plate by inserting a prayer, the court, without considering the application on its merits, has dismissed the same, had dismissed the same, holding that that is contrary to the order of remand by the High Court. And counsel of the petitioner has drawn the attention of the court to the operative portion of the order in the RSA and submits that the court has the court has set aside the order and remanded the matter, and there is no limited purpose of remand, and it is for the trial court to adjudicate the matter. In those circumstances, court ought to have considered the application on the merits of it. He relies on a judgment of this court in case of Vinayaka House Building Cooperative Society versus Sri Chikka Timmaya and others, reported in ILR 2015 Karnataka 4596 for the proposition
99 and 2002, the bars and the due diligence bar post-trial amendment does not
this
attract.
is a suit of
94.
1994.
94.
1994, and the amendment is
99 and 2002.
the amendment to the
32 years.
CPC Order 6 Rule 17 is in the year 2000, and it is submitted that
2002.
that would not apply to the suit which is instituted much prior to it. Anything else?
That the amendments were purely formal in nature and the sale deeds could be very well ignored in terms of section 45
The
and
amendment that
46
is
of
sought
TP
is
Act.
formal in nature. Already pleadings are on record, and the court ought to have allowed the same. Then counsel appearing for the respondents submits that the court has rightly considered the order of rightly observed that the order of remand is only for specific purpose of recording the evidence of PW 1 and PW 2 and 3, PW 2 and 3. And the court has rightly observed that the court cannot go beyond the terms of the remand in the RSA, and it is submitted that there are no grounds to interfere. Next part, having heard the counsels on either side, peruse the material on record. It is appropriate to look at the order passed by a coordinate bench of this court in RSA number 2014 and 2014 and 1526 of 2023. At paragraph number 9, the court has discussed about the manner in which the
19.
the court has observed that although PW2 and PW3 or the attestors to the alleged will affidavit in the form of examination in chief was filed, they have tendered themselves for cross-examination once, wherein the counsel of the defendant sought time on the day. Further, the matter was adjourned for cross-examination of PW2 and 3, and on that day, PW2 and 3 remained absent. The trial court has taken the cross-examination of PW2 and PW3 as nil. Therefore, the matter was posted for judgment. The court observes that even before the appellate court also, first appellate court also, the court ought to have the first appellate court could have remanded the matter to the trial court with a liberty to the plaintiff to keep the witnesses attestors present for the cross-examination. Instead of remitting the matter to the trial court, the first appellate court allowed the appeal and decreed the suit of the plaintiff, which is erroneous. The judgment and decree passed with the first appellate court is arbitrary and erroneous. Hence, on these grounds, the court has allowed the second appeal by setting aside the judgment and decree, and liberty is reserved to the plaintiff to keep the PW1 and 3 present for cross-examination and conclude the evidence within 15 days, and thereafter the court shall pass appropriate judgment in accordance with law. This order, the operative portion of the order, read with the discussion in the preceding paragraphs, makes it very clear that the limited purpose of remand is to examine PW2 and PW3. As submitted by the land counsel for the petitioner, when the order is when this court has perused the order, when it speaks about when the entire order is set aside, on a first blush, the impression would be that the court has left has remanded the matter for consideration on the merits of it. But the order, coupled with the paragraphs number 19, 20, and clause 4 of the operative portion of the order makes it very clear that the remand is only for the specific purpose of conducting the cross-examination, and thereafter, after hearing the arguments of the parties, such an order to be passed in those circumstances, the trial court has rightly considered and understood the scope of remand and rightly held that the court cannot entertain any other application but for the evidence of PW 2 and 3, and hence this court finds no reasons to interfere. Accordingly dismissed.
Till number
Great.
37.
One minute, sir. That liberty what I sought for 105 may be kept.
What is the liberty? No, we are on a point, whether it
Not
is
that.
permissible or not, that I've decided no
Because your
other,
lordships have not expressed any merits of the application.
I'm not expressed.
And so did the trial court, because it's
Ask
on
the
that.
trial court for the liberty.
105 minutes CPC for a moment.
Ask the trial court for
No,
the
that cannot be
liberty.
done by the trial court. That has to be done only at this court. Or that is why, that liberty is only at this court. 105.
Why you are entitled for a liberty?
That is because the application is not considered on its merits. We are on a.
I am
Right.
giving a finding that you are not entitled to be considered. So
Then
in that case.
let's
that
imagine
is
a scenario, if
finding.
someone dies, then we can't even file a LRF.
Passed
That
an order.
that is
I
not the
have
scope.
passed an order.
That can never be the scope of it.
Order 6, Rule 17 is beyond the scope of the remand, and the court has rightly dismissed the matter. On any other issues, this court is not
Very
inclined to pass any order. Yes.
Great.
37, Giridhar SV for petitioner, PS Manjunath for KV 1.
Yes. Yes.
That's, I am the second defendant in a suit for partition. That suit is filed by the daughters against the mother. The family is that the husband passes away. Widow has 2 sons, 2 daughters. 2 daughters are the plaintiff. The mother is the first defendant. I am the second defendant. My older brother is deceased, so his wife is made the defendant number 3. Lord's written statement was prepared as defendants 1, 2, and 3. Lords, at the time of filing, the defendants 1 to 3 was struck off, and it was only defendant number 1. So I was not aware of it. Then the defendant
number?
I am for the defendant number 2. It was prepared as though it is to be filed by all the defendants. I did not sign. My sister-in-law, the defendant number 3, did not sign. Maybe the advocate struck off. I was not informed. I was the one who gave instructions. That is their case also. The case proceeded. My mother was extremely old, so we made an application for immediate examination, considering she is about 90 years of age, so that her evidence is not discarded or lost on account of her demise. Her evidence was recorded even before the issues were framed. Then, my lords, the plaintiff examined herself. I have cross-examined her on behalf of all the defendants. Since the first defendant is already examined, my lords, we were the counsels who came on record subsequently. At the time of preparation of the evidence affidavit of the defendant number 2, lords, we secured the entire certified copies of the documents, at which stage we noticed that the written statement of D1 is there, written statement of 2 and 3, 1 to 3 is
The
just
suit is
deleted.
of which year?
My lord, suit is of the year 2022.
22.
Yes,
When did you notice this, that your written statement is not on record?
my lords.
When did you notice that your written statement is not filed?
My application, my lords, may I just request this court to take, when we prepared page number 30, the affidavit in support of the application,
Yes, let's see.
paragraph number 6, running page number 32.
Yes.
Subsequently, all the defendants changed counsel. At that time, this fact was not brought to the notice of the new counsel and record. I was under the bona fide impression that my written statement was already on record. During the course of the proceedings, application for amendment of pleadings was filed by both the parties, is allowed by this honorable court. Pursuant thereto, an amended written statement along with counterclaim was filed, and the pleadings was executed by all the defendants. In fact, I have now signed the amended written statement. I have not signed the original written statement. I was not aware, my lords. Both of us filed applications for amendment. The same was taken on record by this court on 20th of September 2024. I stated the matter is now posted for defense evidence. The evidence of the defendant number 1 has already been completed. Now I am required to file my evidence affidavit. Upon verification of the order sheet and certified copies.
1 minute. Here you say that you have filed the additional written statement on 29/2024.
Yes, my lords. I was not aware that the original written
Evidence
statement
has
didn't
already
have my
been
signature.
completed. Then when did you come to know? You don't even say anything.
My lords, that is, my lords, at the
And
time
this
of filing this
is filed
application,
in the
16th
year
of
two-
March.
In the year 2026.
Yes, my lords. Lords, it's a suit for partition.
No, whatever it is,
Yes,
you have to be specific on when did you come to know?
My lords, when the matter was posted for my evidence at the time of March
Then court has to
2026.
look at the record, when your matter is posted for evidence.
No, sir, produce the order sheet, my lords. Then,
Come to the order.
now
And,
I will
understood the
just
facts.
read my application, my lords, what my application was for. I did not seek to file my written statement.
Yes,
Page 30.
yes.
Defendant number 2 respectfully prays that this honorable court be pleased to recall the order dated 8th of June 2022, taking the written statement of D2 as not filed. Permit D2 to adopt the written statement and counterclaim filed by defendant number 1. I did not want fresh issues to be framed. I didn't want to reopen the entire case. It is a suit for partition, just permit me to.
We'll ask, let other side come.
Lords,
We'll
I'm
see.
They're
I'm
there,
for
my
the
lords. They're there on
respondents, my
caveat.
lords.
What is your submission?
My lords, may I kindly turn to page number 35, my lords, our objections to this, my lords. They have not produced the order sheet, my lords. I am producing.
No, whatever, no, what is the prejudice caused to you now? No, once, he doesn't want to file any fresh written statement.
No, my lords, what has happened is that the second, defendant number 1 and 2, my lords, they have filed wakalat on 7/2/2022. Only defendant number 1 and 2. Further, my lords, the matter was adjourned to 28/2/2020. For this purpose, I would like to produce the order sheet, my lords.
So we'll accept all that there are lapses on his part.
Yes, my lords.
Now, if this is allowed, if this application is allowed, what is the
My lord,
prejudice
what
to
has
you?
happened is.
It's a suit for partition.
May
Already defendant's evidence is on record.
May I submit,
Defense
my
written
lords?
statement is on record.
My lord, this defendant, my lords, he has filed another subsequent suit, that is OS number 2551 of 23 against one of the defendant for possession of one of the suit scheduled properties. This honorable court, in a writ petition order, my lords, has directed to club, consolidate, try both the cases together. So, my lords, now even the order sheet is taken as in the originally instituted suit. My lords, our evidence is complete. Their evidence is also completed, my lords. And now, without seeing this, it is just an abuse of process of law, my lords. They, after lapse of 4 years, they're coming to file the written statement. And my lords, without filing written statement, he cannot adopt a counterclaim. Without there being no pleadings at all, how can this defendant claim counterclaim?
Heard reserved.
Great.
My lords, may also produce this citation, my lords.
Take that. Yes, next.
Cell number 38.
Lords, may I make one submission? At the time when the writ petition came to be filed in view of the urgency, the entire order was not produced, only the operative portion. Subsequently, the order was uploaded. May be permitted, my lords.
Yes, take that.
The
Yes.
detailed impugned order, my lords. Grateful.
Next.
Cell number 38. Please, Krishna for petitioner.
Here for respondent.
I appear for the plaintiff in the trial court, my lord. Your suit is filed for specific performance.
Yes.
Go ahead. Suit is filed for specific performance in respect of several items of property. Lord, I am a society. I had, my lord, advanced monies to the first respondent developer to develop and give me sites so that I can distribute it among my members. Lord, if your lordship kindly looks at the plaint, it's at page 144.
No, what is the present IA?
Application is filed in the court below for an injunction not to alienate the properties.
That was dismissed.
Pardon?
That was dismissed.
That was dismissed, against which an appeal came to be filed before the first appellate court. Appellate court, my lord, in the first instance says that you have made out a prima facie case. There is balance of convenience, but refuses to grant me any relief, against which I come to this court, my lord, in a writ petition. Writ petition, my lord, passes an order saying that you consider the application that is pending
Remanded.
and remands it back. On remand, my lord, the order is again passed. Now, for the first time, holding that I have not made out a prima facie case and there is no balance of convenience in my. That's why I just want to point out, your lordship may kindly look at the plaint. Please look at page 144 is the plaint. Suit number is OS 392 of 25. 144 is the plaint.
Yes.
And your lordship would kindly look at page 152. The advance that I have paid,
Yes.
paragraph 11, my lord, about 5 lines from 11, 17.11 crores I have paid. Lordship gets that? Similarly, my lord, at page 153,
What is
about
the
8,
consideration?
about 17, about 18 or 19 is the consideration, my
You have
lord.
paid 70.
95% I have paid. I have paid. Similarly, your lordship may look at page 153, paragraph 12, 17, about 8 lines from the bottom of the page. Now, please look at the written statement at 166.
Yes.
Lord, 168, paragraph 6. Subsequent to the executioner, they went on remitting amounts to the first defendant commencing from so and so.
Which para?
Para 6, top of the page. 17.11 admitted, my lord. Similarly, at page 169, your lordship would kindly get, before paragraph 8, about 8 lines, my lord. 17 points, so collected by the plaintiff, the first defendant refunded 323. So according to them, my lord, as on 28 to 25, the balance was 1388. Say about 14 crores was the balance. Now, my lord, please come back to the plaint. There are, my lord, several items of property. Please look at the relief that is sought at page 154. 155, this is for specific performance. And my lord, your lordship will see there are 32 items of property, various survey numbers, my lord.
Yes.
Now, in the written statement that, my lord, my suit is filed on the basis of an MOU that is dated 16/4/2018. May I just hand over to your lordships?
No, agreement is one.
No, agreement is disputed. That's why my agreement, the agreement that I am relying upon for which I have filed the suit is dated, your lordship, just make a note, 16/4/2018.
And it refers to all these suits.
All these survey numbers are referred.
Also about the consideration of 17 crores.
No, not that, because the consideration is paid post agreement, no. So in that there is not there, but the consideration says 945 rupees per square meter, it says. It's a calculation, because on the date of the agreement.
Can we see the agreement?
Yes, I've just given it to your lordships. My lord, the same agreement is at page 119 of the paper book, but it's not clear. Therefore, I'm giving your lordships a copy. Please see, my lord, this is the agreement is dated 16th of April 2018.
Yes.
Lordship.
Yes.
6th. Lord, the stamp duty is paid at page 2. There's an endorsement, my lord.
Yes.
Just before the suit comes to be filed, I have paid the deficit stamp duty. What is important is, please look at page 4, ink page 4, para 2, consideration, 945 rupees per square meter. My lord gets that?
Consideration.
945. And please look at page 6 onwards. All the various items of property are mentioned there. Now, in the written statement that is filed by the other side, they set up a different agreement at page 16.
Of the same papers?
Yes, on the same paper book. Yeah.
This is 9th.
9/4/2018. Mine is 16/4/2018. They say 9/4. Now, before your lordship comes to their agreement, please look at this agreement at page 1. The stamp paper for this agreement was purchased, if your lordship looks at the second item on top, 9/4/2018 at 4:22 p.m. And your lordship will kindly see, as far as the society is concerned, the resolution is passed on 8/4/2018, page 3, top. Board of Directors resolution dated 8/4/2018. And as far as the defendant, my lord, their resolution is passed on 12/4/2018. Just plaintiff's resolution is 8/4. Sorry, plaintiff is 12/4, my lord. Sankalpa Welfare Society. Resolution is dated 12/4/2018. The Lordship gets that?
What the resolution says?
Resolution, I have a copy of the resolution. It's not part of the documents, I'm producing it.
No, then you have to make an application for it. It can't be like this.
No,
When
that is not part
They're not
of
part
the-
of the document. All of them are coming anew, my lord.
Very
Afresh.
well.
Then we will not look.
Very
into
well,
that.
very well. Your Lordship may kindly see, my resolution is dated 12/4/2018, under which this agreement of 16/4/2018 came to be entered. It has consideration, it has schedule. Well, these are the most important things, my lord. Without this, no money can be paid by the society at all. Now, please look at the contentious agreement that is put forward by them at page 16. First thing your Lordship would kindly see is that the stamp paper is 9/4/2018, 4:23 PM. Then please look at the date of the resolution, my lord, at page 17.
Yes.
Now, my lord, at page 16, as far as the defendant, my lord, the resolution is dated 8/4/2018, end of the page. As far as the plaintiff is concerned, my lord, it says resolution dated 8/4/2019. Please have a look at page 17, my lord. How could there have been a resolution on 8/4/2019 with respect to an agreement on 9/4/2018? Therefore, this is obviously a fabricated resolution. Now, please look at this, my lord, page 17. No consideration is mentioned in this agreement. The end of page 17, the second party promises to pay the amount as advance, so and so, as mutually agreed. Cost of the land is subject to revision. And look at the schedule, my lord, at page 20, undeveloped alienated land of various survey numbers for resident. I ask myself a question, my lord. You collect 17 crores from me in respect of what? Obviously, this 16/4/2018 resolution. I mean,
No, how that amount is paid? Is there any?
no,
have you state-
that's why I pointed out the written statement. Receipt of the money is not in dispute.
To understand.
All check
You
payments,
must
my
have- You
lord.
must have stated so in your plane.
Wire transfers, my lord.
Yes, you must have stated the dates.
Has the dates been given? My lord, since they have admitted, it's all bank transfers, my lord.
No, before you filing the plane, they won't admit. You must have narrated the facts that I've transferred so and so amount on so and so date, which will strengthen your case.
No, at page 152, 153, I have said I have paid the money. They have also said that we have received the money. So that's not in.
There is no
in
dates
fact,
with regard to the money.
No,
paid.
no,
But
except
either
that-
from you or from them.
No, or from them, except that what they say is, yes, we received 17.11 crores, but out of that, we gave you back 3 crores. Therefore, what is now remaining with us is about 14 crores, 13.88 crores. Therefore, because 13.88, they returned 3 back to me. Although there are 36 items in the schedule to the agreement, I have scaled it down to 32 items only. Because they paid me back the money, the 3 crores was paid back to me. So because the 3 crores was paid back, I have deleted 4 items of the schedule and restricted my claim for specific performance only to 32 items. Now, whether it is the 16/4 agreement as contended by the plaintiff, or is it the 9/4 agreement as contended by the other side, or it is some other agreement which they are propounding now.
What is the difference between your agreement and their agreement?
My agreement and their agreement is, their agreement doesn't contain consideration, doesn't contain any schedule. Mine contains 945 per square foot. Mine contains the 32 items, which is the subject matter of the suit.
No, let's see what is the schedule of
No,
their,
nothing. Please have a look at, my lord. I just given your lordships the schedule in the 9/4 agreement, page 20.
Yes. Don't even mention that in respect of what property.
No, it just says the name of the village. No survey number, no schedule, no extent, no consideration.
Yes.
Now, my lord, so there are two agreements, 16/4 propounded by the plaintiff, 9/4 propounded by defendant number 1. The difference in the two agreements, as your lordship asked me, was
We'll continue after now.
please.
Sorry, can we have it tomorrow? Tomorrow. Sorry, my lord.
Lord,
Can we
may
have
I-
it tomorrow, my lord? Not
Lord,
only
serial
tomorrow,
number-
because
whatever is convenient.
Tomorrow in the first list.
yes,
My
Serial
lord.
number 100, serial number 100, my lord, there's an urgency in the said matter. There's the-
2:30 put all three as.
Yes.
ಯಾವ್ದಿಲ್ಲ ಲಿಸ್ಟ್ ನಂಬರ್ 1 ನಂದಿದೆ ನಾಳೆಗೆ. ಈಗ ಆಗ್ತಾ ಇದೆ.
ಎಷ್ಟು ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತು? ಪಾಸ್ ಓವರ್ ಎಷ್ಟಾಗಿದೆಯಮ್ಮ?
ಪಾಸ್ ಅವರು ಒಂದೇ ಒಂದಿದೆ ಸರ್.
ಒಂದೇ ಒಂದಾ? ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರಲ್ಲ ಲಿಸ್ಟ್?
ಲಿಸ್ಟ್ ಬಂದ್ಮೇಲೆ 230 ಮ್ಯಾಟರ್ಸ್ ಇದೆ.
ಹಾ.
230 ಮ್ಯಾಟರ್ಸ್ ಇದ್ದೀನಿ. 230 ಅಂತ ಹೇಳಿದ್ರೆ 230
ಎಷ್ಟಿದೆ?
ಕಂಟಿನ್ಯೂ ಮಾಡಿ ಅಂದ್ರೆ ಲೇಟ್ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ ಮೇಡಮ್. ಆಯ್ತು ಆಯ್ತಾಯ್ತು.
ಮೇಡಮ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ತಗೊಳ್ಳಿ ಮೇಡಮ್.
ಇವ್ರು ಹೇಳಿದ್ರೆ ಅವ್ರು ಕೇಳ್ತಾರ? ನೀವು ಚೆನ್ನಾಗಿ
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಇಲ್ಲ ಅಂದ್ರೆ ಅದೆಲ್ಲ ಡೇಟ್ಸ್ ಹೋಗ್ಬಿಡುತ್ತೆ.
court officer, will 230 matters be taken up?
Ma'am, you have to wait for the instructions till madam is resuming back. ಇವಾಗ 2:30 ಇಂದ ಲಿಸ್ಟ್ 2:30 ಮೂಡು ಆಮೇಲೆ 2:30 ಸೆಟ್ಲ್ಮೆಂಟ್ ಎಲ್ಲ ಇದೆ ಕೇಳ್ತೀನಿ. ಓಕೆ ಕೇಳ್ಬಿಟ್ಟು ಹಾ ದೂರ ಫಾರ್ಮ್ ಹೌಸ್ ಮೆಮೋ ಬುಕ್ ಆ ಕಡೆ ಇಂದ ಬೇಕು. ಅಲ್ಲಿದೆ ನೋಡಿ ಆ ಟೇಬಲ್ ಅಲ್ಲಿ. ಗೊತ್ತಿಲ್ಲಪ್ಪ ನಾವ್ ಯಾವತ್ತೂ ಓದಿಲ್ಲ. ನಾನು ಒಂದ್ಸರಿನೂ ಅದು KCC ಶೋರೂಮ್ ಹೋಗೇ ಇಲ್ಲ ಮೈಸೂರು. ನಾವು ಒಂದ್ಸತಿನೂ ನಾನು ಅಲ್ಲಿ ಹೋಗೂ ಇಲ್ಲ, ಪರ್ಚೇಸು ಮಾಡಿಲ್ಲ. ಅಂದ್ರೆ ಅವಳು ನಮ್ಮ ಅಕ್ಕ ಹೋಗ್ತಾಳೆ ಸರ್, ನಾವು ಅಲ್ಲ. ಅವಳು ನಮ್ಮ ಅಣ್ಣನ ಮಗಳು ಮದ್ವೆ ಇಲ್ಲ ಅವಳು. ಸರ್ ಪಾಟಿನ ಯಾವುದು ಅಡ್ಡೇನ್ ಆಗಿಲ್ಲ ಸರ್, ಎಲ್ಲ ಮ್ಯಾಟರ್ಸು ಇದೆ. 39 ಇಂದ ಕಾಲ್ ಔಟ್ ಮಾಡಬೇಕು, ಅದು 2:30 ಇದೆ, 2:30 ಮೂಡ್ ಇದೆ. ಅಲ್ಲ ಹಂಗಿತ್ತಂತ ಮಾಡಿಸ್ಕೊಳ್ಳಿ, ಕರ್ದಾಗ ಹೇಳಿ. ಹಾ ಸರ್ ಒಂದ್ 2 ನಿಮಿಷ ವೇಟ್ ಮಾಡ್ಬಿಡಿ. ಯಾವ್ದನ್ ಕರಿ ಅಂತಾರ ಅದು. ಡೇಟ್ ಹೋಗಿದೆ ನಿನ್ನೆ, ಡೈರೆಕ್ಷನ್ ಬೇರೆ. ಹೇಳಿ ನೀವೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಆಡಪ್ ಆಗ್ತಾ ಇರುತ್ತಿದೆ. ಅದು ಯಾವ ಸೀರಿಯಲ್ ಇವತ್ತು 87 ಇರೋದು, ನಾಳೆಗೆ ಇನ್ನೆಲ್ಲೋ 90 100 ಅದು ನಾವು ಸೀರಿಯಲ್ ನಂಬರ್ಸ್ ಎಲ್ಲ ಹೇಳಕ್ಕಾಗಲ್ಲ. Because fresh matters will be added to the list. List number 1 ಗೆ apart from date given today, all other fresh matters will be added up. ಅದು ಎಷ್ಟು ಮ್ಯಾಟರ್ಸ್ ಆಡೆಡ್ ಅಪ್ ಆಗುತ್ತೆ ಅನ್ನೋದ್ರ ಮೇಲೆ ನಿಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಡಿಸೈಡ್ ಆಗುತ್ತೆ. ಏನ ಸರ್ ಅದು ಅದೇ ಸರ್ ಕೇಸ್ ಕಾಲ್ ಔಟ್ ಮಾಡ್ತೀನಿ. ರೀಚ್ ಆಗ್ದಲೇ ಇದ್ರೆ ಅದೇ ಇದು ನಾವು ಲಿಸ್ಟ್ 1 ರೀಚ್ ಆಗ್ದಲೇ ಇದ್ರೆ ಅದು ಡೇಟ್ ಹೇಳಿದ್ದಾರೆ ಮೇಡಮ್, ಅದ್ರ ಪ್ರಕಾರ ಡೇಟ್ಸ್ ಹೋಗುತ್ತೆ. ರೀಚ್ ಆಗ್ಬಿಟ್ರೆ ನಾವೇನು ಮಾಡಕ್ಕಲ್ಲ. ಕರ್ದಾಗ ರೀಚ್ ಆಗ್ಬಿಟ್ರೆ ಯಾರು ಗೊತ್ತು ಸರ್. ಅದೇ ಓಕೆ ಓಕೆ ಅವರು ಎಚ್ ವಿ ದೇವರಾಜು ಅವರೇ ಇದಾರಂತೆ ಸೆಸ್ಕಾಮ್ಗೆ. ಹಾ, ಅವರು ಬದಲಾಯಿಲ್ಲ ರೂಪೇಶ್ ಕುಮಾರ್ ಅವರು. ಚೆನ್ನೇಗೌಡ ಅವರು ಇದ್ದಾರೆ, ಸಿ ಚೆನ್ನೇಗೌಡ ಸೆಸ್ಕಾಮ್ಗೆ. ಅಲ್ಲ, ಇವ್ರು ಚೆನ್ನೇಗೌಡನೂ ಇದ್ದಾರೆ, ಸಿ ಚೆನ್ನೇಗೌಡ ಅವರು. ಅವ್ರು ಇದ್ದಾರೆ ಅನ್ಸುತ್ತಾ, ಆ ಸ್ವಾಮಿನಿ ಮೋಹನ್ ಅಂಬಾಲು ಇರ್ಬೇಕಲ್ಲ, ಸೆಸ್ಕಾಮ್ಗೂ ಇದ್ದಾರೆ ಅನ್ಸುತ್ತೆ ಅವರು. ಅವ್ರು ಅವತ್ತು ಹೇಳಿದ್ದು ನಾ ಕೇಳ್ಬಿಟ್ಟು ಬರೆಯೋಣ, ಈಗ ಇಬ್ರು ಕನ್ಫರ್ಮ್ ಆಗಿದೆ. ಅವರು ರೂಪೇಶ್ ಕುಮಾರ್ ಬೆಳಗ್ಗೆ ಅವ್ರು ತಿರುಗಿ ಬರಲೇ ಇಲ್ಲ. ಅವ್ರ ನೇಮ್ ತಂದ್ಕೊಡಿ, ಈಗ ನಾನು ಎಚ್ ವಿ ದೇವರಾಜ್ ಅವರು ಹಾಕ್ಸ್ಬಿಟ್ಲ, ನಾಳೆಗಿದೆ ಅದು. ಬಟ್ ಇವ್ರು ಸರ್ವ್ ಮಾಡಿದ್ರಲ್ಲ, ಸರ್ವ್ ಮಾಡ್ಬಿಟ್ಟು ಇವ್ರು ರಿಪೋರ್ಟ್ ಟು ಕೋರ್ಟ್ ಆಫೀಸರ್ ಪ್ಯಾನಲ್ ಕೌನ್ಸಿಲ್ಗೆ ಸರ್ವ್ ಮಾಡ್ಬಿಟ್ಟು ಅವ್ರು ಬರಲೇ ಇಲ್ಲ. ಅವ್ರು ನನಗೆ ನೇಮ್ ಕಳಿಸ್ಬೇಕು ನಾವು ನಾಳೆ, ಇಲ್ಲಾಂದ್ರೆ ಅಂದೇ ಬರ್ತಾರೆ ಅಷ್ಟೇ. ಬರ್ಲಿ ಬಿಡಿ, ನಾಳೆ ತಿರುಗಿ ಸರ್ವ್ ಮಾಡ್ಲಿ ಅವರು.
My lord, serial number 100, my lords, there is extreme emergency, urgency in this matter. This court had reserved liberty earlier to move the petition if respondents come up with an auction notification. Auction is held on 24th, my lords. There is extreme urgency. 4:30.
What is the extreme urgency? I should understand that.
My lords, 24th auction bidding is held.
Yes.
And we have applied for license
24th of which month?
this month, ma'am.
Hmm.
After 2 days.
May I intervene, Lord? The notification which they have challenged, my lord, 3/11/25 notification.
Yes.
It's been dismissed by the Supreme Court.
My lords, I'm not in that Supreme Court petition. It has not been challenged. My lords may kindly hear at 4:30.
What is happening today that I want to know?
Serial number 100, my lords.
What is happening today that I should take it up at 4:30 today?
Because auction is scheduled on 24th. Live bidding is on 24th. That is the after
So
2
then
days.
today is what? Today is Friday.
Yeah.
24th
today
is Friday.
21st, my lords. Because the serial number is 100, it might not reach today.
So I will not take it up at 4:30. We'll see. Yes.
Serial number 63, my lord, withdraw, my lord. Serial
Take
number
that.
63.
63 in which list?
First list, my lord.
Yes.
Liberty to file appeal, my lord.
The memo is filed seeking to withdraw the petition with the liberty to file a regular appeal. The regular appeal accordingly. The writ petition is, the CRP is dismissed, has withdrawn. The liberty to file the appropriate, to initiate, to file an appeal. The petitioner shall file the appeal within 3 weeks from the date of receipt of the copy of the order.
This too, serial number 30, they are settling, my lords. Parties are there.
All the parties are present.
We'll see. To the matter you call.
Humble submission regarding memo for posting, my lord.
Take that memo and list that matter after 6 months.
There's an urgency, my lord.
Like
The
there is no
petitioners.
time, there is no
I
time to the
understand, my lord.
court.
I understand, my lord, but I'm
Why
the
everybody
respondent.
is making mention now? And I will not accept. Please stop it there, or else I'll take the memo and post it after 6 months. Yes, call the list.
Cell number 103, Timaya KH.
Where is that? Writ petition is dismissed.
230 matter, cell number 105. Prashant.
Yes.
Before the next matter is taken, senior lord is arguing in 10.
Yes, call the another 230 matter.
Please.
Cell number 106.
Petitioners, my lord.
Vavanna.
100 and?
My lord, for sake of convenience, I would like to submit dates and events.
Yes.
My lord, this is a case of suit for partition filed by the.
It has to be taken up now. Can it wait for some time?
My lords, I filed an application. What has happened is one of the plaintiff has passed away, and the endorsement has come as the plaintiff is dead, and I have to take steps. I am one of the purchasers who has purchased the property way back in 2004 September.
What is the IA?
I have filed an application seeking direction to respondent number 1 to 5, 7 and 8, who are sisters of the deceased plaintiff, to produce details of the death and the LRs so that I can bring them on record.
What is the impugned order?
The impugned order, Order 7 Rule 11, I have filed seeking for rejection of plaint on the ground that the plaintiffs have not made all the joint family properties as parties, as scheduled properties. They have not made all the purchasers who had purchased the properties as parties, and they filed the suit after 9 years from the date of alienation. The alienation is much before the cutoff date to the, that is 2012,
You are saying about the
2024.
present IA before the court, IA number 1 of 26.
IA number 1 of 26 is seeking direction to respondent number 1 to 5, 7 and 8 to disclose details of deceased respondent number 6, who is none other than their sister, and their legal hair details.
Yes.
Collect the information, pass on to her.
You will pass on it to her. IN number 1026 is filed seeking direction to the respondents whereby the details of the LRs of R6.
R6
R6 are requested by the.
and the date of death, my lord,
And
so
the
that I
date
can
of
file
death, so that-
necessary application.
So that the necessary application can be filed. Then counsel the respondent submits that he'll ascertain the details and pass it on to the counsel for the petitioner. Yes, accordingly, IA is ordered. Delete from caption 230. Yes, next.
My lord, interim order previously granted may
Order earlier
kindly be
granted is
extended.
extended. Yes,
Much obliged.
yes.
Remove matters. Cell number 1. Mahesh Kiran Shetty.
Yes.
Your Lords, and for the petitioner in this case, Your Lords, the matter is pertaining CL9 license, Your Lords.
Yes.
This is a matter wherein the CL9 license belonged to one deceased Premamma.
It's a 2025 matter.
Yes, my lord. What has happened is there is an interim order, your lordships may kindly, 26th September 2025.
Yes.
Interim protection with regard to my license premises is granted by this honorable court, and it is extended from time to time. And based on this interim.
What were you doing from that day?
No,
to
what
till
has
now?
happened, I'll narrate the facts, my lord. What has happened is by virtue of.
Come before a day before saying that tomorrow the time will expire.
No,
So
what-
that should I hear it today?
What happens is, my lord, the government has now extended the renewal of license till tomorrow. Now, what they do is at the last minute, they said, no, we will not renew it. In spite of an interim order wherein an interim protection is there by this
What is
honorable
the
court.
interim protection?
Your
Where
lordships
did
will
the court speak about your entitlement and other things? Only said don't take any coercive
Yes,
steps.
that is what, because my lord, in view of 17A, from the deceased, the license has to be transferred in my name. They say that, my lord, I have to obtain a succession certificate. Succession certificate I have applied. Matter is pending before the civil court. Now, in the meantime, my lord, if they don't renew it, my lord, I have to close my shop, and by virtue of the latest developments, they will auction all the lapsed licenses. Now, that's the reason, my lord, I have moved. Otherwise,
So till you get the succession certificate, it will take 2 years, 3 years.
My
It
lord-
has to keep on renewing your license.
yes, because, my lord, it is for the even revenue loss to the government, as well as my investment, my lord, I have invested a huge amount. I cannot keep
Yes,
my
Mr.
license.
My lords, it's been 10 months, my lords. He himself at page 24, my lords, is given an undertaking that he'll submit the succession certificate.
Yes, we have applied. That is what my submission is, my lord. Once
And
we
moreover,
file
my
an
lords,
application.
there is an alternative remedy also under section 61. And also, my lords, one Mr. Ashwath Narayan Reddy, the immediate brother of the, madam, immediate brother of the deceased license holder, my lords, he's given an undertaking, I mean, he's given a representation, my lords, not to consider their license, my lords. Kindly read it.
My lords may kindly appreciate. One factor.
And
I'll
he,
bring.
he is also given
This is-
the,
One nimsham. The license belonged to one deceased Premamma by virtue of through her.
the class two
husband.
hairs, my
One
lords.
nimsham, please. Through her husband. Once husband dies, my lord, it fell into the, by way of succession, it went to deceased Premamma. Now, once Premamma dies, my lord, in view of the Succession Act, it will go back to the husband's side and not to the wife's side. Because that is what, my lord, section 15 of the Hindu Succession Act. By virtue.
All that we will not be determining here.
No, that is what-
Until-
that's
Till you get the succession certificate, I will not pass any order.
My lord,
directing
at
them to
least
renew
in
the
terms of
license.
this interim order, which is granted by this honorable court, let it be continued till such time. If my
What is till such time?
my lord, till I get the succession certificate, my lord, succession certificate is one thing wherein we have to apply before the civil court and we have to obtain it. My lord, it is not that as if my learned friend is submitting, my lord, succession certificate, we don't get in the shop so that we can purchase it and bring it to.
and
bring
even
it
they are
give-
asking for liquor license, my lord. It's not driving license.
Driving license also, once it is lapsed, the procedure that is contemplated that need to be followed. Here is a situation, my license is renewed from time to time. It is in operation till
Please
date.
come to the present order.
Please,
Present
ma'am.
petition, what is that you are seeking?
My lord, I am seeking, your lordships may kindly
We'll
see.
decide this.
Please.
Yes. You're seeking quashing of endorsement dated 24/9/2025.
Yes.
Yes, what is and directing the respondent number 3 to transfer the CL license.
CL9 license in
Which
view
we
of
cannot
section
do
17.
unless and until you follow the procedure.
Yes,
that
section
is contemplated.
17A, your lordships may kindly see.
My lords, if they are referring to that page number.
Let him complete, Mr. AG. After
Please,
that you can
please.
submit.
My
Yes.
lords may kindly, section 17A of the general condition of license rules may kindly be taken. Karnataka Excise General Condition of License Rules, 1967.
What is your relationship with the
Brothers,
SNC?
the deceased husband's brother, son, and all the other persons they have given a.
Let me understand. Your deceased.
My lord, deceased husband's brother's son.
Your.
Yes.
She
And
has no
everybody,
hair.
every
She has
other
no
legal
children.
heirs, my lords.
She has no children.
She had no children. There were no issues.
And who is this Adnara and Reddy?
My lord, she is from the
He is
deceased
the
side.
immediate brother of the deceased.
Deceased. So deceased
No,
side.
now we will law of success with the court.
It's a
where your
family
case
dispute,
is
my lords.
pending, will decide that.
My lords, may kindly, for a moment, my lord, until such time, till they, my lord, my lord, till I get a succession certificate, my lord, it will take months together. Till such time, I cannot keep my license premises closed. My lord, I will be under revenue loss. Even the government will be under the revenue loss. My lord, in all the matters, my lord, government are interfering like this. If your lordships could kindly recollect on the other day also.
They are bound by their own.
My lord, they are not bound by that order. What they are trying to do is, my lord, they want every license to be get lapsed, so that, my lord, they can auction the licenses. That is what they have done in
If they
respect
have
of
any such grievance, they have an alternative remedy. They
alternative
cannot-
remedy. My lord, here there is no
Necessary.
alternative remedy because there is no order as such. Deputy Commissioner of Excise is not even rejecting my application also. My lord, if at all he rejects my application, I get a benefit of alternative remedy. It is not their case also. Even today, my lord, he has not.
Ask him to do so. Something let him pass so that you will get an opportunity.
Yes, let him reject my application.
I'll
Let
ask
the
him
Deputy
to-
Commissioner reject my application
I'll
so that,
ask
my
him
lord,
to
I can
do-
prefer an
I'll ask
appeal.
him to do
Let him
so.
pass an order on my application.
Yes, please come.
My lord, in all these matters, unnecessary interference with regard to the businesses, I don't understand the, my lord, the intention of the department. My lord, they are getting the
So
revenue.
now you are questioning an endorsement where they've asked for a succession certificate.
Succession certificate.
Only thing.
Yes. My lords may kindly see. If there is no succession certificate as such, my lord, I will give an undertaking that I have applied before the civil court. I'll give the succession certificate. Till such time, my lord, let them not disturb my business. That is what.
I'm not able to understand that till such time. What is that time?
Your lordships may grant me.
No, some may take 10 years, some may take 20 years, some may take 1 year.
My lords may
But
kindly.
you have to be
Yes,
specific.
yes, my lords
Forever
may-
you will not
my lords may
continue.
kindly.
Just to avoid the
One
fees.
minute. My lords may kindly appreciate.
AGA, please understand. Let him complete. I'll hear you.
My lord, in view of succession certificate, my lord, court has issued paper publication. Paper publication, one application has been filed by the very same person. That is now being rejected. Now what happens is, my lord, now I have to lead my evidence. That will take 3 to 4 months time. Till such time, let them not disturb, let them renew it. If I don't get it within 4 months, my lord, let them take appropriate action. That would be the order which will meet the ends of justice.
Yes.
Let them give a representation, my lords. We consider.
I'll
Let
give
us
an
see.
undertaking, my lord, within 4 months, I'll give the succession certificate.
That is for them to consider. I'll ask them, you please give the representation. Whatever they do, if you're agreed, you can come back.
My lord, a representation I had already given. They have rejected my representation. I have given my application. They
Where
have,
is
my
that-
lord, they are not.
Where is that order of, where are those proceedings rejecting your request?
May I take your lordships to kindly annexure M, my lord?
Is it what question before this court?
Yeah, that is what, my lord, what they say is, I have to upload the succession certificate. Uploading of succession certificate is not possible because I have intimated in orally, because I don't have a succession
What is to
certificate.
be done? Whatever is your grievance, tell them. In that case, what is to be done, they will do it.
My lord, they will not do that. That's the reason, my lord, I am before this
Sir, don't
honorable court.
anticipate something. I will ask them to do it.
My lord, there is an interim order by this honorable court. My lord, the order which is passed by this honorable court, that order itself they are violating.
Mr. Counsel.
My lord, by virtue of the
You
interim
have- please
order, interim
understand.
protection, my
Please-
lords may
please
kindly, for a
understand.
moment. My lord,
No,
I'm,
let me complete.
please.
You have argued, what is your case? You have said, you moved it for a reason. This is my order. If you like it or don't like it, you have an option. And you can't compel me to pass the
My
same
lord, I'm
order
not
which you
compelling,
want.
my lord, it is not the question of compelling or something like that. In all matters, my lord, if these kind of orders are passed, wherein, my lord, this honorable court does not honor the order of the coordinate bench, then I am helpless.
Yes.
My lord, that is what I am trying to make a submission. My lord,
Yes.
there is an interim protection by this honorable court, wherein this honorable court has directed that my business should not be disturbed. Based on that order, my lord, my license is renewed.
Yes.
Now this honorable court says, no, no, I am not going to follow that order. I am helpless.
Yes. Yes, Mr. Counsel, I heard.
Yes.
I'll pass an order. You question it in appeal. You have a remedy. You can't say that what you want I should do.
My lord, that is not my submission. That is not my submission at all. My lord, what I am trying to submit is, my lord, I have raised an issue wherein, my lord,
Yes.
I have a valid license.
Yes.
I have made an application. They have not passed any appropriate orders on that. There is an interim protection granted by this honorable court.
You are the one asking the court to pass the orders. Did they say that I'll vacate this order?
My lord, that is not what I'm saying. I'm trying
What
to
you're
submit. My
asking-
lord,
what
my
you're
lord, my
asking, I'm
difficulty
not-
is this. My
I'm-
difficulty is this. My lord, tomorrow is the last date that is government has extended for renewal of license. My lord, it is more than 10 days that I have made an application seeking renewal. The deputy commissioner, either he has to reject it or he has to allow it. If he rejects, my lord, immediately I have the benefit of approaching the excise commissioner and pay the fees, which they are not permitting because their intentions are very clear. My lords are not, my lord, appreciating their conduct also.
Yes. Anything else? Please come. The presented petition is filed. Sing the following prayer. Is a case of the petitioner, that is son of one Gopal Reddy. Late Krishna Reddy was the elder brother of the father of the petitioner. It is stated that one day Srimati Premamma, being the aunt of the petitioner, was possessed and holding Form CL-9 license for the sale of Indian liquor or foreign liquor to sell the liquor at premises bearing site number 1576, new EP ID number 2682407-496, Kata number 1520/1550/1576/1552, 4th Main Road, E Block, AECS Layout, Marthalli, Bangalore, which comes under the jurisdiction of respondent number 3. It is stated that the respondent number 3 has issued the license and has renewed the license for CL9 for the excise year 2025-26 after receiving the prescribed license fee. The renewed CL9 license for the excise year 2025-2026 dated 23/7/2025, which is valid up to 36/2030. It is stated that late Premamma was also holding RBB license in the same premises, which is also renewed for the excise years 2025-2026 by paying the necessary excise fees, which is also valid up to 36/2030. She expired on 13/8/2025, leaving behind her legal heirs whose names are detailed in the family tree, which is placed before the court. The petitioner, along with others, succeeds to the estate of the deceased Premamma. And since her husband had already expired and her husband have no surviving children to succeed to this estate, the family of the petitioner decided to transfer the CL9 premises in the name of the petitioner. All other family members had given no objection for transferring the CL9 license in the name of the petitioner. It is stated that the Rule 17A of the Karnataka Excise Rules provides that in the event death of the licensee or the license, the Deputy Commissioner may, on an application by the legal heirs of the deceased, with the previous sanction of the Excise Commissioner, transfer the license or the lease as the case may be in their favor. The petitioner has filed an application to respondent number 3, requesting the respondent number 3 to transfer the CL9 license in his favor under Rule 17A of the rules. The petitioner was required to submit online application for transfer of the license, and accordingly, he submitted the online application seeking transfer of the license in favor of the petitioner. The petitioner has also given a separate application requesting the respondent number 3 to transfer the license, since a change of transfer is required to be done within 45 days from the date of death of the licensee. He has also provided all necessary documents that are required to be submitted for the purpose of transferring the license in favor of the petitioner. The various undertakings given to abide by the statutory requirements are submitted along with the application. it is stated that all the other legal heads of late Premamma V have submitted their no objection certificate to the respondent number 3, expressing their no objection to transfer the license in the name of the petitioner. The petitioner also sought for transfer of trade license for the Food Safety and Standards Authority of India, which is also transferred in the name of the petitioner based from the family tree. It is a case of the petitioner that the respondent number 3 refused to transfer the CL9 license in the name of the petitioner, in spite of the petitioner providing all the necessary document substantiating his claim, seeking transfer of license under Rule 7A. The respondent number 3, by virtue of his endorsement dated 24/9/2025, refused to transfer the CL9 license in the name of the petitioner on the ground that the petitioner has not produced a no objection certificate from the other legal heads. The petitioner, being agreed with the said action of the respondent number 3, has filed this petition. Then counsel for the petitioner, this writ petition is filed in the year 2025. When this matter came up before a coordinate bench of this court, the coordinate bench has passed an interim order
26/9/2025.
on 26/9/2025, wherein the court has observed that it is the apprehension of the petitioner that due to the impugned order passed at an ex rem, petitioner would be refused to continue the operation of the CL9 license in the premises run by the petitioner who is running business. The respondent shall not precipitate or take any coercive measures to either restrict the petitioner or close down the licensed premises till the next date of hearing. The said interim order is continuing till now. Today, the matter is moved in the morning, saying that tomorrow is the last date for renewal of the license, and if there is unless the orders are passed by this court, directing the respondents either to renew the license or to continue or not to interfere. If it is submitted that if the petitioner's license is not renewed, he will not be able to run the business. Hence, the matter is taken up today in the afternoon. Land counsel appearing for the petitioner submits that he has already filed a petition for obtaining the succession certificate before the competent court, and the same is pending consideration. He submits that there be a direction to the respondents that till the petitioner submits his succession certificate, the license which is granted in favor of the petitioner may be renewed till such time.
Please.
Any other submission?
Yes.
Maybe renewed in his favor. It is submitted that unless such an order is passed, it would cause lot of hardship to the petitioner, and further, it is also learned AGA. On the other hand, submits that one Ashwath Narayan Reddy has given a representation dated 14/10/2025 not to renew the license in favor of the petitioner as what is this case?
Immediate brother, my lord.
He submits that he is the brother of the deceased and he is entitled for the transfer, and the same shall not be transferred in name of the petitioner. Then AGA further submits that. What is that remedy you're saying available?
Alternative remedy, my lord. Let them give a representation. We'll pass orders, my lord.
It is submitted that if a representation is given to the respondents, the respondents will consider the same and pass orders. When this court is inclined to dispose of this writ petition, Land Council has expressed that this court is not honoring the orders of the coordinate benches of this court, and this court is not. If these kind of orders are passed, it would cause a lot of hardship to the petitioner. And submissions are made with a lot of very aggressively submissions are made before the court that this kind of orders cannot be passed by the court. Next para. Having heard the counsels on either side, this court has perused the material on record. The petitioner is aggrieved by an endorsement by the respondents stating that if they require transfer of the license, what is required, whatever as contemplated under Rule 17
A,
of the
general conditions.
general conditions, the party has to submit a license. It is a submission of the counsel for the petitioner that till he submits a license, submits the succession certificate, the license shall be renewed in his favor. It is also the submission that the respondents are not passing any orders. If they pass an order, he would get an opportunity to he'll get an opportunity to question the same. When the rules prescribe that a license can be renewed in a particular manner and on submitting a particular documents, unless and until that procedure is satisfied, this court cannot compel the respondents to do anything contrary to the rules. The petitioner repeatedly submits that till he gets a succession certificate. With that kind of an order, this court, with that kind of a condition, this court cannot pass an order. Already, in respect of the very same license, for transfer of the license, objections are already filed by the people who are related to the deceased before the respondents. The respondents, in the facts and circumstances, this court is of the view that the respondents shall consider the representation of given by the respondents, and in the light of the application that is made by the petitioner, and shall pass appropriate orders in accordance with law within a period of 3 days from the date of receipt of the copy of
3 days, it will be difficult. At least 2 weeks, my lords.
2 weeks till such time.
One submission.
2
Sorry
weeks.
to interfere. One submission. My lord, application is already submitted. It is in the login. My lord, there is no difficulty in he rejecting that application.
Yes.
Let him do it tomorrow, because what is my difficulty is, I'm sorry, my lord, if at all I have argued aggressively, but my difficulty is this. The other day, my lord, I withdrew one writ petition before your lordships, wherein, my lord, I have sought for the being agreed by the imperial order that is passed with regard to that death that has taken place in the licensed premises. My lord, I withdrew that writ petition. The reason is this. My lord, I withdrew that because, my lord, I was getting some difficulty in getting an interim order from this honorable court in spite of my repeated request. I had to withdraw it. I had to give back my files. Lord, see, these are the difficulties that are faced by advocates day in and day out. For that reason, my lord, out of emotions, everybody are here, my lord, emotions come out. It doesn't mean that we are arguing aggressively.
No, that is what you want to say. You have said what I felt. I
Yes,
said.
but
So
what your lordships
discussion on
expressed here, that I argued aggressively. My lord, if at all in so many nearly 100 advocates who are sitting here, if I have said anything wrong,
yes,
I have said anything wrong, my lord. If at all, if I am
discussion on
put
that.
forth in my case, if that is considered as an aggressive argument,
shall pass orders within 2 days from the date of receipt of the copy of
Please.
the order. Yes.
Ajit PP. Yes, Karthikeyan.
First response.
Disconnection of power, my lords.
Yes, what are your instructions?
Lords, my instructions are BBMP has issued notices because they are B-Kata properties, my lords, so they don't have a plan. They are putting up the construction, my lords. So later on, my lords, when the BBMP want to demolish, my lords, if at all the order comes to pass, at that juncture, my lords, disconnecting the power will become difficult. So as such, we have been asked to disconnect and action.
Can you do that?
Lords, it's only an order from the BBMP, the
Who is
requesting.
BBMP to order you?
It's an interdepartmental communication that is as per the statute itself, my lords. As per the BBMP Act, my lords.
BBMP will take action against them.
Yes, please, my lords. If there is.
There is a judgment of a coordinate bench of this court.
Yes,
On
please.
considering all this,
Is it-
and I have also passed an order considering that
Yes, please.
that
It's only
that the PESCOM has no business to do it.
Please, I'll leave it to
And
my
it
lords.
is, if it is
Because
there-
only of the safety on that ground, my lords.
We have this interim
Because
order,
of
my lords, in
unauthorized
this respect of the
construction and
same
you are
waiver.
disconnecting the power supply.
Yes, please. Because, my lords, if there is an order of demolition that is passed, my lords, subsequently,
No, that is a
Please.
far-fetched.
it is a request that is sent by the BBMP, my lords.
No,
So as such,
even BBMP
The
have not
present
issued any
expedition
notice to
my
Fine.
lordships were to see annexure, the second page, my lords, I don't have a copy, sorry, my lords. It only says get an NOC from BBMP, we will not disconnect. That is all it says. Within 7 days, kindly get an NOC from BBMP, we will not disconnect. But my lords, he does not approach the BBMP, but he approaches this honorable court, my lords. It is only that, my lords, which says the whole order, the summon substance, my lords, it says, please get an NOC from BBMP.
This is show cause notice.
Yes, please. Show cause. The second page, my lords, of Annexure A, the last line, it
No,
says.
he will submit, first of all, you forthwith restore the power supply.
Yes, ma'am, I'll submit the representation. In fact, my lord,
Petition is, we'll keep this writ petition pending.
Please.
The petition is before this court, questioning the action of the respondent, already disconnected. When
my lord, it's disconnected on 12th, my lord.
it is submitted that on the request made by the BBMP, the respondent Bescom has disconnected the power supply of the petitioner, supply to the petitioner's premises. It is submitted that the Bescom cannot act upon the instructions of the BBMP, and if there is any unauthorized construction, BBMP can take independent action. He submits that a coordinate bench of this court in so and so.
My lords, in the same interim order, my lords, only the site property, my lords, is pertaining to the scheduled property of the same layout, where my lord site number is
Submitted that this court in respect of a adjacent site
adjacent
has
site.
passed an order on 15/7/2026 in WP number 21370 of 2026. In that view of the matter, the respondent shall forthwith restore the power supply to the petitioner's premises. The petitioner shall submit his explanation, submit his response to the show cause notice within a period of 2 weeks from today. Yes. Objections for the respondents. This is matter in the month of September. Yes.
Obliged.
The same matter, my
Same
lords,
matter.
it's pertaining to the another site. My lords,
adjacent
it is
site, my lord.
one.
Yes. Same order.
May I request that this matter be tagged along with this, my lords?
Tag this along with that writ petition. The one which I have sent the order, tag these 2 writ petitions along with that.
Great.
My lords, on the request for hand delivery, my lords. Hand delivery of the order.
Yes, handle. He is here, he'll inform.
Please, my lords.
You are here, you will inform.
I shall inform, my lords.
Yes.
Much of it.
Diplo.
No, that one pastor matter is there.
One pass over, that 230 pass over. Cell number 1.
ಎಷ್ಟಿದೆ ನಮ್ದು DD? 560. Lords, out of 10 crores, 5 crores 60 lakhs I am handing it over today. Out of 12 crores, I'm sorry, my lords, I stand corrected. Lords, I'll only make this statement. Your lordships may have this matter on 28th. If I don't come with the demand draft of the remaining amount, I'll not make even a single statement before your lordships. I'll just rest my case on that day. Lords, I am making an application. Lords, one of my sister, she has kept her property for sale. I have a purchaser. Can I just persuade this? Lords,
about you?
My lords, I am for the auction purchaser, my lords. I'm for the auction purchaser for the same, my lords. My senior's name is not reflected as P. Prasanna Kumar, my lord.
Lord, I have one submission before.
You can't ask time on that.
No, my lords.
Lord, my suggestion is this.
let them hold the demand drafts. Let them not even present it.
What,
my lords.
my lord, my lord,
If I
CJ
don't
made a
pay the
submission before this honorable court on last occasion. If my lords use 1 week's time, my lord, I'll deposit 12 crore rupees. Based on that, my lord, this honorable court directed them to, my lord, deposit. After 2 adjournment, today they're coming with a 6 crore and seeking, my lord, one more
Lords,
adjournment.
I am only saying
In
this.
fact, my lord, sale took place. Auction purchaser paid entire money. That is, I am holding for my lord in the month of May.
Lords, I am paying. The reason is this: the property which we kept for sale, my sister kept for sale. There is a requirement of registration of an e-khata. Some problems was faced. I am just producing that document. Because of the problem which we faced in registration of the e-khata, this difficulty arose. Otherwise, we were thinking, my lords, by Saturday itself, we are going to get the registration completed. Because of the e-khata, I am producing those documents. If I don't pay this 12 crores, I am not saying that your lordships may accept this, my lords. If I deposit this 12 crores before your lordships, I am in your lordships' hands to pass appropriate orders. I'm not, because whatever lordships have extended as a leverage to my lords, I know that I have skipped it. I will present 12 crores. I will show my bona fides on 28. If I don't, lords, I will not even make a statement and I am in your lordships' hands. I will not make a statement beyond that.
On the previous. Can you see the order passed by this honorable court? Even as a last chance.
I have to see, I remember everything.
He made a submission before the court saying that, my lord, I will pay 12 crore. He so much undertook before this honorable within 1 week. I'll pay.
For how much you have sold the property?
I sold, my lord, 10 crore 35 lakh 86,000. That is not the matter here. I have to record, my lord, 195 crore. That is different aspect.
I'm not on that. I'm just.
My lord,
I just
10 crore 35 lakh 86,000 rupees deposit by
I
auction
wanted to know is what is the amount that fetched in the auction and how much they are going to pay. And 4 days, how is it going to make a difference? And I'll pass.
4 day, my lord, it's a question of third adjournment. My lord,
28th, I'll pass an order and this time I will not adjourn.
my lord, in fact, my lord,
But
previous
I'm
order
even
is-
making a statement.
Because
my lords.
having kept the matter, this
my
many
lord, previous
adjournments
order,
and
my lord,
bearing
you
that.
undertook said that, my lord, in case, my lord, they are not coming with the money, my lord, I'll not say one submission before this honorable court. And
That's
today,
not
my
the
lord, is coming and saying,
statement
my
which I
lord,
made.
well, it is recorded. I'm not saying.
My
Kindly
lord,
see the order, my lord, passed by this honorable court.
Even I need some time to seek instruction, my lord, because my senior is not well and our name is not reflected. So kindly have it in the next week, my
My
lord.
lord, either, my lord, he has to-
Auction purchases.
Yes, my
seeks
lords,
time.
my
My lord,
interest
what about
has.
I have to appropriate that to money.
And I have to hear him also.
Yes, my lords, because I've paid
respond.
already
Am
10
I-
crores.
Am I not supposed to hear him?
Yeah,
because
Lords,
of-
I will
My lord,
hand
I
over the
have-
demand
My lord,
draft
it's
of.
not paid, my lord. The reason is, can you see the, his own statement
What
before
we
the
do
honorable court,
is,
based on
what
that,
we
you
do
got.
is, I'll tell you, on 28th, no arguments.
Yes.
Senior also need not come.
I will not.
If he comes
Yes.
up with a.
Demand draft, then
DD,
there is enough, please.
Then that's enough. I will
Please.
not entertain any
Whether
of the
Melody is
arguments.
Melody is handing over this money or
I'm handing it over, my lords, 5.6
No,
crores.
no,
want to take
I
it or
them not
I-
presented.
No, I don't want, my lord, if my lord directs, my lord, I'll accept it. My lord,
Okay, let them keep it. Yeah, entire 12, you can take it on that day.
28,
recorded,
please.
my lord. It's second or third.
I will record that.
My lords, next date of hearing, I would like to make my submission because my interest has also been.
No, that's what your senior should have made
Yes,
it
ma'am.
today.
His-
Senior counsel appearing for the petitioner submits that. In fact, today they have come up with a DD for an amount of rupees 5 crores.
5 crores 60 lakhs.
5 crores 60 lakhs and and it is stated that with respect to some property, as there was some difficulty in change of khata, the other amount they could not get the same. It is submitted that by 28th, that is Tuesday, next Tuesday. By 28th, they'll come up with a DD for an amount of rupees 12 crores. And if on that day, if they're not able to come up with the DD, they will not make any arguments.
It is recorded in
Please.
previous orders.
Huh?
The same thing recorded in the previous orders.
They will not make, no, this time I'll ensure that. They'll not make any arguments because thing is, still you are benefited by.
I am not
another-
benefited, my lord. That reason is this. My lord,
As far as this property is concerned, Mr. Vignesh Shetty, why you do not understand? This property is concerned, you're benefited by 1.5 crore, 1 crore 70
Sorry,
lakhs,
yes.
which is in the
the
interest
reason, my
of
lord, I
the.
am not insisting, my lord, on the last date of hearing. Otherwise, I was ready with my submissions because I filed my objections, my lord, in the month of June itself. My lord, since, my lord, they offered, we are coming with a 12 crore rupees within 1 week, my lord. That is the reason, my lord, I am not argued before this one.
Yes, what did you write? That they will not, they will not make any argument, they'll not seek any adjournment, or they will not address anything on the merits of the matter.
Please.
And the court can pass appropriate orders on 28th July. List this matter on 28th July as a first matter.
Please, please.
My lords, my submission may be heard on.
What is the name of your senior?
P. Prasanna Kumar.
It is there,
P.
Prasanna Kumar.
P for
Initial is
Punjab.
left out.
P for Punjab.
P. Prasanna Kumar. The registry shall reflect the name of the counsel for the respondent number 3. P. Prasanna Kumar.
Please, my lords. So grateful, my lords.
Yes, continue the list.
Interim order.
Continued.
Interim
Cell
order.
number 39.
Interim order earlier granted is extended.
My lord, on settlement,
Srinivas.
Settlement.
my lord.
Cell
That
number
you take.
30.
30.
List 2, cell number 30.
Cell number 30, list number 2.
Both the parties present, my lordship.
Take that. This is arising out of what? This order?
My lords, it's arising out of one memo filed before the commercial court.
Hmm.
It's a suit for money recovery.
Hmm.
It was settled before the local Adalat before, but thereafter they could not settle the case. Thereafter, it went back to the commercial court for execution. So again, I came on one IA here, but now we are settling the matter.
What is IA?
No, it was for a memo of calculation. Now, my lords, we are agreed to settle the matter for 40 lakhs.
Recovery is for 1 crore 39 lakh 43,424.
Yeah, everything is paid as on date. Only 40 lakhs were pending.
Again, after 60 days.
We are handling over the DD worth rupees 20 lakhs today. Within 60 days, we will be,
So like next another third round of litigation.
no, my lords, it will be settled and reported in the commercial.
Before the court, after making the payment, you can settle the matter.
No, my lords, it's a huge amount, 40 lakhs, my lords. That's the reason we have taken 60 days of time. There will be no breach of, there will be no such breach, my lords.
Where are the parties?
Parties.
Parties are.
Srimati Swati. And where is Srimati Usha? Sri K. Mukund. The writ petition is filed. Agreed with the order dated. You have received 20 lakhs.
My lords, handing over the DD.
Another 20 lakhs after 60 days.
Yes, my lordship.
The agreed with the order dated 5/8/2024, passed on I number 3 and or 21 rule 54, 64 and 66, read with 151 CPC. The petitioner is before this court, whereby the court has passed an order by allowing the application of 151 CPC, and the petition scheduled property is attached for recovery of the requital amount, and the judgment debtor are restrained from alienating or creating any third-party rights of the petition scheduled property till further orders. Today, the compromise adjourned memo of settlement is filed before the court. All the three petitioners and the respondent are present before the court and identified there by their respective advocates. As per the compromise, as per the memo, it is stated that initially the respondent, the suit is filed seeking recovery of 1,39,43,424 along with future interest. And as per the settlement before the Lok Adalat, an amount of rupees it is settled at 1,40 lakhs due to financial constraints of the petitioner. He could not settle the agreed amount as per the compromise on time. Hence, they had a mutual and after discussion they had a mutual understanding between the parties, and they have decided to settle the matter as per the same. The petitioner has agreed to pay a respondent a sum of rupees 40 lakhs as a full and final settlement, and before this court he has paid a sum of rupees 20 lakhs on DD bearing number 074516 dated 29/6/2026, drawn in the Karnataka Bank in favor of respondent. The said DD is handed over before this court by the learned counsel by the petitioner to the respondent. It is stated that the petitioner have agreed to pay the remaining outstanding amount of 20 lakhs within 60 days, starting from 6/7/2026 to the respondent. It is stated that if the petitioner is failed to pay the said amount, the respondent is at liberty to proceed with the execution proceedings that are pending in commercial execution 85 of 2023 as per the judgment and decree in commercial OS number 750 of 2011. If the full payment, if the payment is made, remaining payment of 20 lakhs is made. The petitioner, after the full payment is made by the petitioner, the respondent shall forego all his claims as made in judgment and order dated 29/20/22. Once the amount of rupees 20 lakhs is paid, then the respondent would report the same to the commercial court in commercial 85 of 2023 and withdraw the proceedings pending before the court. In the light of the joint memo for settlement filed before this court, the writ petition is disposed of in the light of the joint memo dated 21/7/2025. The joint memo shall be part and parcel of this order.
Obliged.
Obliged.
Yes.
Cell number 39.
The petitioner in this case, may I please, my lords. My lords, I am the legal heir of the original plaintiff. This is a suit for specific performance, my lords. My application under order 6 rule 17 is rejected, my lords. Aggrieved by that, I am before this court, my lords. My lords, the original plaintiff filed the suit on 28/7/2008, my lords.
Yes.
The matter was contested. Respondent number 1, through his GPA holder, respondent number 2, filed his written statement, my lords. During the pendency of the suit, my lords,
Suit is on 2008, in the year 2000.
28/7/2008, my lords. During the pendency of the suit, my lords, there is settlement talks between the plaintiff, original plaintiff, and the respondent number 1. Respondent number 1 says, I am agreeable to convey the property to you. He conveys the property to me under 2 separate sale deeds, my lords. The said sale deeds are kept pending by warrant of 45A, my lords. Thereafter, my lords, then in 2014 I died. My legal heirs are on record, they come on record, my lords. My lords, I come to know in that respondent number 1 had fraudulently also conveyed the property to respondent number 3 in 2008. That is even before commencement of the suit, my lords. That is on 3/7/2008. The said sale deed was kept pending and was not registered. And in 2013, it got registered, my lords, on 23/9/2013.
When was this amendment filed?
My lords, I filed this amendment on 26/1/2000. 17/1/2026, my lords. The legal heirs of the original plaintiff have filed this amendment, my lords.
Yes, please come to the order.
My lords, the order is starts from Annexure A, ink page number 18, my lords.
Yes. Para 17?
Para 17, my lords.
Yes.
The records further disclose that the sale deed in favor of defendant number 2 was executed on 3/7/2008. It is also an admitted fact that the deceased plaintiff purchased a portion of the suit property measuring 5 acres 22 guntas under 2 registered sale deeds executed by defendant number 1 on 3/6/2013, one of which was subsequently registered on 7/3/2014. It is equally undisputed that the deceased plaintiff had instituted OS number 1587 of 2013 challenging the sale deed in favor of defendant number 2 and seeking a declaration of his ownership based on sale deeds executed in his favor by defendant number 1. Para 18, my lords, these facts clearly establish
that the deceased plaintiff had knowledge of the sale transaction in favor of defendant number 2, at least in the year 2013. Not only was he aware of the transaction, but he had also taken legal action challenging the same before a competent court. Despite such knowledge, no steps were taken to seek amendment of the plaintiff in the present suit for more than 12 years.
What is the
19
present, what is the present stage?
My lords, evidence has to commence, my lords.
Commenced means what is the stage?
It is posted for evidence, my lords.
It is not yet commenced.
No, my lords.
Yes.
Then
When the plaintiff died?
2014, my lords. 22/3/2014 he dies, my lords. The original plaintiff dies on 22/3/2014.
Are you not prosecuting that suit?
I am prosecuting the suit for declaration also, my lords.
So you are
This
aware
suit
of-
for specific performance got transferred to Krishrajapuram court, my lords. And it was renumbered as the OS number 807 of 2025, my lords. And the suit for declaration is also pending before the Bangalore.
This is what, when you are after the.
I am
death of-
prosecuting that suit also, my lords.
After the death of the father, when you are prosecuting that suit, you are aware of all this. Why are you seeking amendment now, after keeping quiet for these many years? This is a question.
Inadvertent, I accept, my lords, there is some kind of
Secondly, my lord,
delay, my
same
lords.
set of facts
But
of
my
the
lords, if this is a amendment wherein I'm seeking only few amendments, man. It's not, I'm not changing the nature of the suit or anything of that sort, man. Only after paragraph 10, I'm bringing to the notice of the court as to what happened. That's all, my lords.
He is a party to that.
Yes, he's a party to that.
Then how will it change if you are a party to the?
No,
to
my lord, one
those?
submission, my lord. In the same set of facts of the case, can you see, my lord, there are two competent courts are giving two different findings. There could be possibility of different findings or contradictory findings, my lord. If this
So
applies alone.
he is-
Now,
he-
if there is same
No, no.
pleadings,
One minute. Is he seeking amendment of the prayer?
no, pleadings. Pleadings means that means the court has to give findings on that. Then what could happen to the other case?
What is
where
this suit for?
They are also declaration on the same ground.
This is declaration.
No, this
Suit
is not
for
declaration,
specific
specific
performance.
performance. There it is a declaration that the sale deeds during the pendency of the suit, etc., sold is not binding, etc. That is the case.
No,
there.
but
Now the pleadings are same.
between the very same parties, two suits are pending. Those pleadings, if they are brought on this record of this suit.
No, so one submission, now I am learned because he has filed a memo in the court below also to transferring that case and to club that case along with this case and try the case.
No,
They has filed. So that means,
no,
means
what is the
rejecting.
prejudice I'm asking?
Yes.
What is the prejudice to you? I can
No, prejudice
understand.
is such, my lord. Here in this case, the specific performance prayer is sought. There, that's why court said it is prejudice the case of the defendant because limitation aspect arises here also. 2015 itself, they had the knowledge. The father opted for filing a separate suit rather than filing an amendment. I kindly see the affidavit filed with the support of the application, my lord, page number.
No, in a suit for specific performance, court will not decide about because it's not even his prayer. It's a suit for specific performance.
Yes.
And another suit is for declaration between the very same parties. What now he is seeking, he wants those, whatever the pleadings in the other suit, he wants it to be part of, place it on record about the pending.
Place it in record means the issue has to be framed, my lord.
What issue?
Issue regarding the pleadings.
Suit for whatever he says, suit for specific performance,
No,
why will
issue-
the court
once
go
issue-
into all that?
Once the issue is framed, which contradict to each other in the two cases, finding arises,
In
then
the light of
complication,
the
legal
fact,
complication
no,
will be
in
there.
the light of the fact, already a declaratory suit is pending.
That's
Why
the
would the
reason
court give any findings?
In this case, it cannot be brought in. That is what my submission, my lord. Because same set of pleadings, he has already invoked this, elected the remedy of filing a separate suit. Not bringing it in this case, very case that regarding that particular pleadings and relief. When separate relief is sought with the same cause of
I
action,
couldn't understand what is the prejudice.
prejudice will be caused because of the delay that has been caused in this particular case. There I can contest it separately. Here I can contest it on the basis of that it is the 2015 itself when the father was he was alive.
Is it your
He had filed a
submission
separate
that,
suit.
is it your submission that
Yes.
if the pleadings are allowed, the court will decide about the relief of declaration in this?
May not be, but the pleadings that is being made in this case, pleading in this, suppose if it is brought in this case, if the court finds a fraud, etc., everything is proved, etc., then what would happen to the pleadings in that case, my lord? That has to be given findings. There, that court may give different findings.
So according to you, on the merits of it, it is not correct.
Yes,
On the merits of the matter.
yes, merits of, ultimately prayer is to be given. Prayer is to be granted. Here, one more aspect, your lordship may kindly see. Declaration is with regard to the 5 acre 16 untas in that case. Whereas in this case, specific performance sought for 9 acre 6 untas. The extent is also different. Now, the map, the original plaintiff had the knowledge in the year 2015 itself, and he filed a separate suit. Till 2026, no application was filed. The respondents that legal layers have come on record in 2014 itself.
Yes.
2014 itself, they have come on record. They have not filed such application within the reasonable period also. Now, the case was dismissed when case is posted for evidence in 2012, dismissed for non-prosecution. This alienation has taken place after the case was dismissed. There was no legal impediment for the first respondent to transfer or alienate the property in question or portion of the property when it was sold to respondent number 2. Because subsequently this case was restored after the sale was made. So in between there was no legal impediment. So totally cause of
So the
action.
delay aspect I understood.
Well,
Delay
well,
aspect I understood. They are contesting the suit for declaration from 2014 after the
No,
death of the
2000
father.
It-
After the
yes,
death
yes,
of the
yes,
father
yes.
from 2014, they are contesting, and they have not brought these earlier. I mean, they not sought for the amendment.
Yes.
The next question was, what is the prejudice? According to you, the same facts it would overlap, or
Yes,
is
two
what is your
cases.
submission on the merits
Yes,
of the
yes.
amendment?
Yes, that again, it's the pleadings means it has to be, relief that is sought to be given based on the pleadings, my lord. When the pleading is examined by the court and if findings is given, that will binding on the other case also. So that conflict cannot arise in the civil proceedings. That is the reason on the same cause of action, two parallel proceedings cannot be initiated. But their original, the plaintiff, when he has elected the remedy in 2015 itself to file a separate suit, my submission to your lordship, my lord, that may not arise in this case at all. To bring in that pleadings and seek for a finding on that. Cannot be mere pleadings. The court will have to give findings on it. Findings on that. Then there is complication, legal complication.
Yes.
My lord, my amendment is only to the fact as to what happened subsequently, how sale took place in the name of respondent number 3. Other than that,
Where is that pleading? Let's see.
my lords, the amendment sought by me, my lords, is at page number 51, my lords. Annexure D.
Yes.
May I please, my lords? Insert paragraph 10A. During the pendency of the present suit, defendant number 1 approached original plaintiff Sri A. Manjunath seeking an amicable settlement by expressing that he could comply with the terms of agreement of sale dated 16/7/2004 by executing and registering sale deed in favor of original plaintiff Sri A. Manjunath in respect of scheduled property subject to payment of additional sale
Like
consideration.
these transactions are by whom?
These transactions were done by the original plaintiff, my lords.
Hmm.
This was not brought up during when the suit was filed in 2008.
So you are saying that all these have taken place after the suit.
After the suit,
As
my
far as
lords,
the specific performance suit is concerned,
please, my lords.
why these facts are relevant?
My lords, these facts were relevant because the sale was my lords, even before execution of the sale deed in my favor, he had already executed a sale deed in favor of respondent number 3. That is what I am bringing to the fact of the court, my lords.
You already sought for declaration of.
That I have sought for declaration. I am bringing to the notice of the court that even prior to the sale in my favor, in sale in my favor, the suit scheduled properties were sold to a respondent number 3. Please come.
One submission, your lordship may put the right question on this thing, whether prayer is sought to be amended. Yes, he is seeking for prayer also amendment.
What is the prayer?
Prayer he seeks for, kindly see paragraph in the application.
My lord,
page number 54,
prayer,
my lord.
if I can kindly tell about prayer, my lords.
Regarding prayer, my lords,
Seeking,
substitute the word defendant with defendants. And regarding prayer A and B, substitute
Defendants.
every word plaintiff with plaintiffs. That's all, my
no,
lords.
no, no, regarding prayer A and B, substitute every word plaintiff with plaintiffs. Number 8, substitute the word defendant with defendants. It is not defendant number 1. Now he is seeking prayer for against these defendants also.
Where is the template petition file?
Pardon?
How many are the defendants to the original?
3
suit?
defendants.
Three,
One is the
ma'am.
first
Three, my
defendant is the owner.
But it said only defendant. That's why you
I've
wanted to-
stated only, I've stated defendants. Instead of
Now the-
defendant, I've stated
because now the prayer
defendants.
is also changed. Prayer is also going to be changed with these paragraphs,
How?
with these pleadings. Now the question is, earlier he had crossed for against defendant number 1. Prayer was
Defendant number 2 and 3 are the
2 and,
purchasers.
2 and 3 were parties.
My
No
lords,
relief
2
was
is
sought.
the power of attorney holder.
Now 2
3 is the
two
purchaser.
purchaser, 3 is the power of attorney holder, no relief was sought. Now the sale deed was executed even prior to filing the suit. If she was aware of that, then prayer could have been against all the defendants. Now we are at this stage in 2026, he is seeking such a prayer, having knowledge of in 2015 itself. Is not correct, my lord. There is an inordinate delay in filing, seeking this amendment, and it affects the limitation aspect also with regard to the defendants. It will prejudice his rights with regard to the limitation aspects.
I number 6, the petition is before this court, agreed with order passed on 9 number 6, dated 22/6/2026 by the Principal Judge Junior Division at Bangalore, invoice number 1129 of 2008. The father of the petitioner herein has filed a suit for such performance in the year 2008. He died in the year 2014. When it is a case of the plaintiffs that the defendants have executed a sale deed, have sold the property, and they have filed a separate suit for declaration that the sale deeds are not binding on them. After the death of the father, the plaintiff is prosecuting both the declaration suit as well as this suit.
Death of the husband and the father.
That's for the death of the husband and father. The present suit is at the stage of the evidence of the plaintiff is not yet started. Matter is posted for the evidence. At that, it is submitted that now this matter earlier, now this case is transferred to the present court and numbered as OS number 807 of 2025. The petitioner has filed an application under Order 6 Rule 17 seeking to amend the plaintiff. By way of this amendment, he wants to bring on record the pleadings pertaining to the transactions that had taken place between that had taken place, which are part of the pleadings of the declaration suit. Further, he also earlier he sought a suit for specific performance against defendant. Now, by virtue of this amendment, he is seeking the said relief against defendant number 1, 2, against all other defendants. According to them, defendants number 2 and 3 are the GPA holders. The court, by order impugned, has dismissed the IA on the ground that there was no due diligence on the part of the plaintiff. And secondly, that he has already filed a suit for declaration, and the plaintiff has failed to show a reasonable cause for allowing the proposed amendment. Agreed thereby, the petition is before this court. Then counsel appearing for the petitioner plaintiff submits that the court ought to have allowed the application in the substantial interest of the parties. It is submitted that these pleadings would help the court to understand the dispute in a better manner, as he has not he is not introducing any new facts in this case, as all the parties to this case are also parties to the suit for declaration. It is submitted that the court on a hyper-technical manner has dismissed the application. Next para. When counsel appearing for the respondent, the defendant submits, you appear for defendant?
Respondent number 2, my lord. I'm appearing respondent number 2, my lord.
You don't appear for other respondents?
Other respondent.
And he has filed a caveat.
Only for respondent number 2, my lord.
I have served the copy of the caveat to him, my lord.
Then to dispose of others are also required, because you are seeking relief against them by way of this amendment.
For a matter of fact, they have not filed the amended written statement also in this matter, my lords. It is taken as nil.
Then if you say that they are not necessary parties, you are doing at your risk, you file a memo, I'll record it. But if not, they have notice has to go to them. Because I'm disposing it off.
Then, my lords, notice may be issued, my lords. Till then, let the matter be stayed, my lords. Further proceedings not.
Then make it brief. It is submitted that the court has failed to consider the scope of Order 6, Rule 17, and only on the ground that the application is filed with delay, court has dismissed the application. It is submitted that there is not introducing any new facts, that facts are already there in the other suit, only to bring all the facts to the notice of the court. The present amendment is filed and it will not alter the nature of the suit. In that view of the matter, there shall be stay of all further proceedings for pursuant to the order dated so and so. The petitioner shall take out hand summons. Your respondent 2 is defendant number?
Defendant number 2, my lord.
Defendant number 2 petition shall take out hand summons on defendant number 1 and
3.
And shall file a memo to that effect by 3rd of August. If it is filed, list the matter on 11th August.
Much obliged.
Number 40. Gurudat BS for petitioner.
Connected matter, it is posted on Monday. Yesterday it has come. Case number 21-123.
It's along with that on Monday.
Yesterday also it was mentioned, by mistake it does come.
Take it, please write it on a paper and give it.
Number 41. MB Yamal Nagabhushana for petitioner. HV Devaraju.
I appear for respondent on behalf of HV.
Yes.
The respondent has disconnected my electricity connection to given to
What are
the
your
customer.
instructions?
The disconnection was made on without their running a PG in the residential zone. Therefore, Panchayat has given an instruction to disconnect the power supply, and moreover, they are taken temporary connection in the for construction of the building. After completion, they are not sought for a permanent power supply.
No membership.
And
They have
now
not given any commercial activities is going on.
Forget about the commercial activity. You need to have a permanent connection.
No notice has been not served to me, my lordship, regarding this.
No, you have to take, that is your duty to take a permanent connection.
My lordship, after completion of the building, entire building,
You complete the building.
another 3 to 4 months, my lord.
You are not completed.
You're not completed, still going on, work is going on.
It has been completed, and Panchayat is issued this thing without taking prior permission. They are running a PG in the
That is a
residential zone.
different aspect. So running PG and all. As per your regulations, what is the deviation?
No deviation, but they're completed the building. Entire building has been completed.
According to them, it is not completed.
Not completed, my lord, not given to any.
To that
PG or
effect, I will file my
No, my lord,
objection.
my
to
lordship,
The counsel for the petition submits that without any basis, the respondents have disconnected the power supply. Land counsel appearing for the respondent submits that the building is completed. It was temporary connection that was granted. Now, they have not applied for the permanent connection, and further they're running a PG in a residential area, and basing on the communication from the Panchayat department, they have disconnected the power supply. Considering the rival submissions of both the parties, this court deems it appropriate to direct the respondents to restore the power supply forthwith. And what if you have received a notice from them?
No, my lordship, either
The
Panchayat or
respondent
from the
and the
base camp.
respondents shall issue a notice to the respondent, I'll dispose it off on that.
Please.
And
one short day
No, no,
accommodation.
let them give the
I'll-
notice, any proper notice, my lord. I will answer to it, then they
Because
will take
even
an
if
action.
adjourn it also,
Till then,
ultimately
continue
you have
the
to give a
power.
notice to them.
we will give, but they have to give the application, online application have to be.
No, but after completion only I have to
Uh,
give. That is my duty. It's not part of.
Let them come up with objections. This is matter for filing objections. Forthwith inform the respondents to restore the power supply. And the petition shall continue to pay the consumption charges. This is matter on 24th of August for objections.
Obliged.
Question number 42, Sunil Kumar.
Caveator in this case, responding.
Petitioner.
Lord, suit for recovery of money. I am the defendant before the trial court. Lord, the plaintiff filed a suit alleging that he had lent sum of rupees 15 lakhs to me in cash, and because of which I did not pay, he filed a suit for recovery. Lord, in the pendency of the proceedings, my lord, he expired. A GPO holder, even though he had 3 children, a GPO holder filed an application, common record, on behalf of the plaintiff, alleging that all the acts which the plaintiff has deposed in his evidence affidavit, he is aware of the same. Lord, I filed an application stating that he does not have any personal knowledge about the transaction that has happened between the plaintiff or the defendant. And since he has no personal knowledge, he is not a competent witness to depose on behalf of the principal. There are also 2 judgments which I'll take Lordship's attention to that. Now, my Lord, 2024, the affidavit is filed. The plaintiff, my Lord, the suit is filed in the year 2017. Even in the entire plaint, the plaintiff never says there was a witness to the transaction. Cash transaction of rupees 15 lakhs, he says, he has paid to me. I have denied it entirely in my written statement. The only legal question that arose before the court was whether the GPA holder, without having any personal knowledge of the transactions between the plaintiff and the defendant, which has happened between them, can he depose on behalf of the principal?
Come to the order.
Please, my Lord, order. Lord, may I request Lordship, my Lord, to kindly come to page 32, my Lord. In page 32,
Yes,
it begins with para 9. That's the finding of the court.
yes.
As it is discussed above, the original plaintiff has filed the suit based on the promissory note for recovery of the amount. And when he was examined before the court as PW1 in cases adjourned for cross-examination of said witness, the defendant timely did not cross-examine the original plaintiff. Subsequently has died, and now the GPA holder of the legal heirs of the plaintiffs got examined before the court. As it is discussed above, the case was adjourned for cross-examination of PW1 on 18/7/24 until 16/8/2025. The present defendant did not raise his voice to disregard the oral evidence of PW1, but when the case is adjourned for cross-examination of PW1, after recalling him, the defendant came up before this court with present application. The act and conduct of the defendant itself shows that he has not filed the present application with bona fide intention. On perusal of the order sheet, it reveals that he intends to drag the proceedings as it is discussed above. The PW1 in his examination in chief deposed that he is the close family friend of the original plaintiff, and he got knowledge about the transactions. When he, by swearing affidavit, has stated about the said fact, then it is the duty of the defendant to cross-examine the said witness and thereby elicit the transaction took place between the original plaintiff and the defendant. If the PW1 has failed to give answers to the questions posed to him during his cross-examination, then the defendant can make use of the same. On perusal of the affidavit shown by the defendant, his intention is only to drag the proceedings. If really the defendant has filed the present application with bona fide reasons, then he might have opposed the filing of the examination in chief of PW1 when it was filed for the first time before the court. The defendant himself has filed the application to recall the PW1 for cross-examination, and when the case is adjourned for cross-examination, the defendant has come before the court with the present application. As it is discussed above, there is no merits in the present application which is liable to be rejected. That's the only finding that the court has given. May I rely only one paragraph of judgment of this order?
Yes.
Please, my Lord. Lord, in that, my Lord, may I request page number 12, my Lord, please.
Page number?
12, my Lord, 1, 2. 12. But it begins with para 18, my Lord, where the Honorable Supreme Court has summarized the legal principles. It says, we may now summarize for convenience the position as to who should give evidence in regard to matters involving the personal knowledge. In that, my Lord, subclause C, I'll just rely on that. The attorney holder cannot depose or give evidence in place of his principal for the acts done by the principal or transactions or dealings of the principal, of which.
Or we understand the other.
Please, madam, ABC also. Please.
Right from the beginning of 18.
Yeah. 18, we may now summarize for convenience the position as to who should give evidence in regard to matters involving personal knowledge. An attorney holder who has signed the plaint and instituted the suit but has no personal knowledge of the transaction can only give formal evidence about the validity of the power of attorney and the filing of the suit. If the attorney holder has done any act or handled any transactions in pursuance of the power of attorney granted by the principal, he may be examined as a witness to prove those acts or transactions. If the attorney holder alone has personal knowledge of such acts and transactions and not the principal, the attorney holder shall be examined if those acts and transactions have to be proved. The third one, the attorney holder cannot depose or give evidence in place of the principal for the acts done by the principal or transactions or dealings of the principal of which the principal alone has personal knowledge. Further, where the principal at no point of time had personally handled or dealt with or participated in the transaction and has no personal knowledge of the transaction, and where the entire transaction has been handled by the attorney holder, necessarily the attorney holder alone can give evidence in regard to the transaction. This frequently happens in case of principals carrying on business through authorized managers or attorney holders, or persons residing abroad managing their affairs through their attorney holders. Where the entire transaction has been conducted through a particular attorney holder, the principal has to examine that attorney holder to prove the transaction and not a different or subsequent attorney holder. Other things will not, because my lord, in this case, it is not a business transaction. Relying on that, even one more judgment of the Honorable Supreme Court, Rajesh Kumar's case, my lord, the Supreme Court has summarized based on these principles. It clearly says, my lord, in suits for specific performance as well as for the recovery suits, if there is a personal transaction, personal knowledge is very important. But now he comes after 7 years and says that I am a family friend, I will depose on behalf of the principal. Well, in this judgment, may I request Lordship, my lord, page 19, my lord, please. In page 19, begins with the first line, my lord. In other words, in page 19.
Yes.
Please, my lord. In page 19, it begins with the words, in other words. In other words, if the power of attorney holders has rendered some acts in pursuance of power of attorney, he may depose for the principal in respect of such acts, but he cannot depose with the principal for the act done by the principal and not by him. Similarly, he cannot depose with the principal in respect of the matter of which only the principal can have personal knowledge. And sorry, my lord, in page, sorry, my lord, in that 19, my lord, page 19.
Page 19.
19, sorry. The first line, my lord, begins with in other words. Please. In other words, if the power of attorney holder has rendered some acts in pursuance of power of attorney, he may depose for the principal in respect of such acts, but he cannot depose for the principal for the act done by the principal and not by him. Similarly, he cannot depose for the principal in respect of the matter of which only the principal can have personal knowledge and in respect of which the principal is entitled to be cross-examined. If a plaintiff in a suit for specific performance is required to prove that he was always ready and willing to perform his part of the contract, it is necessary for him to step into the witness box and depose the said fact and subject himself to cross-examination on that issue. A plaintiff cannot examine in his place his attorney holder who did not have personal knowledge either of the transaction or his readiness and willingness. The term readiness and willingness refers to the state of mind and conduct of the purchaser as also his capacity and preparedness, one without the other being not sufficient. Therefore, a third party having no personal knowledge about the transactions cannot give evidence about the readiness and willingness. I'll only rely on only one provision, my lord, and I'll conclude. Please. Order 19, Rule 3, my lord, which speaks about the affidavit, my lord, in the format of the affidavit which has to be filed before the trial courts.
Order 19 rule.
Order 19, Rule 3, my lord. It begins with matters to which affidavits shall be confined.
Yes.
Please. Order 19, Rule 3, matters to which affidavits shall be confined. Affidavits shall be confined to such facts as the deponent is able of his own knowledge to prove, except on interlocutory applications on which statements on his behalf may be admitted. But there should be a personal knowledge to the transaction. He can't come after 6 years and say that I will depose everything on behalf of plaintiff. Hence, my lord, my application was not considered.
My lord, this case, my lord, the original plaintiff had filed the suit for recovery money based on the on-demand promissory note or consideration receipt, and he has reduced his evidence during 2017. And thereafter, my lord, the matter was posted for cross-examination. The defendant has failed to go on with the cross-examination. However, in the meanwhile, due to COVID-19, unfortunately, original plaintiff passed away. So the legal heirs have come on record. Then thereafter, my lord, what has happened? The plaintiff's son is residing in the USA. So after the death of the original plaintiff, wife joined his son in the USA, and in view of that, they given the GPA to the legal heirs are given GPA.
He was the deceased was alone the plaintiff. or any others were there earlier?
Sole
These
plaintiff.
was only the
So it
plaintiff.
was sole plaintiff.
Only the plaintiff. So they have given the GPA to the GPA, so executed GPA. So in view of that, my lord, what has happened, he has reduced his evidence during 2024. From 2024 to 7/3/2025, the defendant failed to go on with the cross examination with one or the other reason. Then what has happened, my lord? Then he has the honorable trial court was pleased to taken his cross examination as nil. Then I posted for defendant evidence. Then after the posted for defendant evidence, defendant further not chooses to go on with the evidence. Then matter was closed. Defendant side evidence was closed. Posted for argument. Then he has filed two applications for reopening, open and recall the PW1. That is a PW. That is.
Suit is of which year?
Pardon me.
2017.
2017. So in view of that, my lord, after the matter was posted for cross-examination, the same person, the defendant, has filed an application for recall and reopening. Though the recall and reopen has been allowed along with payment of cost, then the matter was posted for cross-examination. On the day on which the matter was posted for cross-examination, this application came to be filed by the defendant.
No, in this case.
So.
No, plaintiffs do the children also do not have the same, the knowledge about what has taken place.
But maybe they have a chance because the father would have told them everything. But now he's a stranger now. At least if the children had come on record, we would not have objected for that. Now a third party, after 7 years, my lord, his name is not even there as a witness. Nowhere is in the picture. All of a sudden, after 7 years, he comes and says, I'm deposing on behalf of the plaintiff. Lord, he can depose as a witness provided if he has some knowledge of the transaction. He was nowhere there in the picture.
My lord, 2021, the original plaintiff has reduced his evidence. My learned friend is submitting that after a lapse of 6 years, 7 years. He has failed to go on with the cross-examination. Now we cannot make a submission stating that.
Can he have a personal knowledge of the transaction?
We are not
legal
because
question.
when the chances have been given, sufficient opportunity has been given for cross-examination when the original plaintiff was alive. Then subsequent thereafter also.
Heard reserved.
Please.
Cell number 43.
Grateful.
Much.
Yeah, Abhinav Ramanan for petitioner. P.P. Shivkumar for
Was for the
respondent.
petitioner. And before this honorable court, challenging the order dated 2/5/2026 on IA number 1, which was filed for impleading me as proposed defendant number 5.
That's ordered.
My lords, kindly take page
What
71.
is the suit for?
My lords, the suit is for partition. My lords, there is no relief which is claimed against me. There was a JDA joint development agreement which was made in the year 2006. And if my lords may peruse the written statements filed by the other defendants, there is.
Come to the IA application.
Please.
Page number.
57, Annexure B.
57. Yes. You're going to make you're making construction on the in the joint family that is the suit schedule property is the allegation.
Please, my lords, there is another suit which was filed in the year 2025 on 17th of this December, which they were seeking for an interim order. It came to be, the interim order was not granted in their favor. On 4th of January 2026, they filed this impleading application, seeking that I'm a necessary party. My lords, in a partition suit, the relief is with respect to them. If I may take my lords to the prayer at page 29.
No, you are asserting title on that property.
Please, my lords, but there is
That
another
is why
suit.
you are not
There is
necessary
another
party.
suit pending where suit for permanent injunction has been filed against me, that is pending, my lords. On which they have filed another impleading application in this suit, which is of the year 2014, which is about to commence with final disposal, my lords, where DW2 evidence is almost
In
finished.
respect of the very same property.
Please, my lords.
Please come. The counsel for the petitioner submits that on an application filed by the plaintiff on order 1 to 10. The court has allowed the application by pleading the petitioner. It is submitted that the petitioner and the plaintiff has instituted a suit against the implead applicant, that is in a suit for injunction. In that an IA is filed seeking interim injunction that was not granted by the court. Now, what he could not get in the other suit, now the petitioner, for the best reasons known to the plaintiff, he wants to implead the petitioner in the present suit. Considering the same, there shall be stay of operation of the order dated so and so.
For 43, for respondent,
Which one?
for respondent number 1.
43.
Yeah. Caveator. Yes. Which if I seek for a senior held up in another court.
You know, I granted learned counsel appearing for the caveator 6 times. Shall I record it?
To file objection.
Yes, to file his objections. The same, the operation of the order dated. I'm not to state the suit. Only operation of this one. Operation of the order dated so and so is state. Yes. Notice to the, which respondent you appear?
1 to 4 there, caveator 1 to 4. Respondent 1 to 4, caveator.
Who are the other respondents?
Plus the other defendants sailing through.
He appears for 1 to 4.
Then 5 to 9.
5 to 9 petitions permitted to take out hand summons. I shall file a memo to that effect by 3rd of August. This matter on 2nd of September.
Obliged.
Then number 44.
Appearing for the petitioners, it's a mandamus seeking for direction for disposal of an
What is,
IA.
the
The suit is for bare injunction. I'm the plaintiff.
Which year is the suit?
4300 of 2025.
Why should there be a mandamus of 2025?
There's one IA pending, but it's not for the entire suit.
For the IA?
For the IA.
IA number?
IA number 7.
When did you file?
1725.
My lord, may I make a mention, my lord?
How can you file an application on, what is that IA?
For police protection. It's a suit for bare injunction. The IA is at page 24.
Yes.
My lord, this matter may be kept tomorrow or day after tomorrow, my lord.
Notice
I'm
has
asking
not
for
yet been
day,
issued.
my lord. I'm asking for 1 or 2 days. It may be listed tomorrow or day after tomorrow. Let them serve me a copy so that I'll represent tomorrow.
There is no notice to you in this required.
Yes, my lord.
They're only
but,
seeking an order.
Yes, my lord. But my representation is required, my lord.
Have you filed a caveat?
No, they have not filed any case.
Yes, the writ petition is filed seeking the following prayer. It is a case of the petitioner that an IA is filed on 1/7/2025 seeking police protection that is not considered by the court. Considering the same, there shall be direction to the, in that view of the matter, this court is disposing of this writ petition by directing the trial court to expeditiously dispose of the matter.
Within 29/7, because Chaturmasa happens, the Swamiji,
Expeditious disposal.
at least 2 weeks from the date of receipt, my lords.
First of all, filing an application in the month of July and coming to the court.
25 July I filed. 2025. It's been pending for over
2025 July.
July.
I was thinking that this 26.
No, man.
An application is filed on 25th July.
1/7/2025.
1/7/2025. Considering the fact that the application is pending for more than 1 year, the trial court shall consider the same and pass appropriate orders within a period of 4 weeks.
2 weeks, my lords.
4 weeks.
Grateful.
45. Swami MM for petitioner. P. Suresh for case.
Here for the caveator.
This is a matter, Lord. A partition suit has come to be filed against me, my lord, by the respondents herein. Lord, I filed a written statement on 2 grounds. One is, my lord, I have in fact denied the relationship of most of the respondents. And secondly, my lord, there are multiple, in fact, suits filed against these suit schedule property by the third party claimants. They are all pending, in fact, seeking declarations of their title. In fact, my lord, during the pendency of this partition suit, an application came to be filed by the respondents under Order 39, Rule 1 and 2, seeking an order of injunction restraining me from alienating 4 items of the suit schedule properties. The same came to be allowed. I challenged the same by filing an appeal before before this honorable court in MFA, wherein in fact after hearing both the sides, this order was set aside, modifying the same into status quo, directing the parties to maintain status quo with regard to possession and alienation. Lord, and in fact, there was specifically, in fact, the trial court was directed to dispose of the suit within 6 months. When this being the case, what happened was, Lord, I filed a transfer petition under section 24 of the CPC before the learned district judge, stating that there are in fact suits filed by the third party claimants that seeking declaration that they are the owners. In fact, in one of the matters, there is already a declaration given. Your Lordship may kindly, in fact, may not kindly see annexure.
Yes, we will take it.
Declaration was again stating that they are the absolute owners of these suit schedule properties. Because their contention is they have purchased this suit schedule property from their vendor, who in fact participate in the court auction under which in fact he had purchased it in the year 1944-45. And from them, in fact, the claimants claimed that their father purchased under different sale deeds in the year 1950. This is their contention. Not upholding their contention, a declaration was given by the trial court, that is by the reference court, in order to decide who is entitled for a compensation. Because one of the pieces of the land was acquired by the NHAI for national highway purpose. Therein, in fact, I claimed that I am the owner, I am entitled to the compensation, but they also disputed that. The matter was in fact ultimately referred to the civil court. In the civil court, under reference, in fact, the evidence was let in, extensively witnesses were examined, several documents were produced. There finally a declaration was given stating that they are the absolute owners of the entire suit schedule properties.
No,
and they are entitled for. Now, transfer in the transfer petition. In fact, I said that this suit may be transferred to the court where in fact the declaratory suits are pending.
How many suits
and
are
both
pending?
of them.
How many suits are pending?
2 suits. 2 suits. So both of them, both these suits in fact connected and tried together. And my lord, any outcome, my lord, would be in fact would be binding on us. This is what. In fact, my lord, now the interim order, appreciating my contention, interim order was granted, staying the proceedings of the trial court. Later, my lord, on appearance and on filing and vacating application, the same has been vacated only solely on the ground that this court in the MFA proceedings had in fact fixed a time bound. Within 6 months' time, in fact, the suit has to be disposed of. Therefore, my lord, this stay cannot be continued. Kindly, in fact, look at the order, the imputed order at page 150, the relevant portion, reasons. Para 9 may kindly be seen, the last paragraph. In this case, on perusal of the order passed in MFS so it was passed on 17/4/2026, whereas the present petition
Yes,
is
what do you
filed.
say?
I raised an objections before the trial court for vacating the interim order which was granted in ex parte. The transfer petition has been filed. Kindly look at the page number 64 of his miscellaneous petition for transfer mail. Because he seeks for a transfer of the suit wherein the junior civil judge court has no jurisdiction at all about my case, because my suit is pending before the senior civil judge court having 17 items of the properties. That
No,
the 2 suits which are pending.
So he wants this matter to be transferred to the junior division.
No,
junior division.
any court.
Kindly see-
Either those suits can be
No, those suits are pending before the junior division.
Junior
court.
junior
Suits,
division, my lord.
Kindly
They
see
can
the,
be transferred here itself.
Prayer,
All of them can be tried.
That you can ask for that.
No, all of them can be tried together.
those
All
two
that
suits to
that's
be
what.
In that case, you should
Having a
for
jurisdiction.
transfer in that case.
I can ask that, but in the meanwhile, my lord, they are going rapidly. The trial court is going rapidly. Kindly, in fact, we'll look at.
now the
worry
receipt
about
is
it.
posted for arguments, my lord.
Once Now
the matter has been posted
we
for
have
arguments.
not been given any
2010
opportunity.
matter. Now, 2016, they have come up with an application for transfer of the suit to the principal civil judge, junior division, which is not competent to try the suit. Because if the suit is decreed, it is a nullity decree. How can the junior civil judge court?
My submission
That
to
is my,
Lordship is
the honorable court has
the
rightly
issue of title is
vacated the
foundational.
application.
Unless in fact, my lord, the title is declared in respect of these properties, it cannot be in fact, my
That
lord,
reason you will not
determined.
seek, how can you seek transfer of a case pending before a senior division to the junior division court?
No, no, junior.
That is prayer notice, prayer A. Transfer of OS number 123 of 2010.
Yes,
on the
partition
file of
suit.
civil judge court, senior division Nelamangala, into the court of principal civil judge
No,
and
that the
JMS
prayer can
junior
always
division
be amended.
Nelamangala. How can
No, all that I want is all these suits to be tried together.
those two suits is
No,
transferred
your
there?
only cases from here to there it should go.
Ah.
This order I'll set aside.
Please.
To ask for that court, that matter to be come to this court, that is a different proceeding.
Please.
Yes, the present miscellaneous is fine.
Because provision of 24(2) is very clear, my lord. Transfer of the same for the trial or disposal of
Where is
any
this,
court,
where is the impugned order?
150, my lord, page number 1.
150.
To any competent to try the dispose of the same.
Not required, all those
Please,
provisions
please.
are
Any
not required.
competent court.
The
said,
civil
okay,
judge junior
fine.
division is not a competent court for a disposal of my suit.
Yes. The agreed with the orders passed in. Civil miscellaneous number 68 of 2026 dated 10 July 2026. By the Principal District and Session Judge Bangalore. The petitioner, you are the defendant in the suit.
I'm the first
He's the
defendant, first
defendant.
defendant.
Defendant is before this court. The respondent herein filed a suit for declaration.
Partition suits.
Partition in respect of 32.
17 items of the property.
79 properties.
Please.
The petitioner
The amendment hakiddani.
petitioner has filed an IA. Initially, the court has granted a stay of the further proceedings. In that, an application is filed by the plaintiff seeking to vacate the order.
Stage.
That came to be allowed. And while dismissing the application, the court has observed that the instant petition is filed with the petitioner to transfer OS number 123 of 2010 on the file of Senior Civil Judge Nelamangala to the court of what is this?
Principal civil judge.
Principal Civil Judge and Junior JMFC Nelamangala and to club the said suit with OS number 76 of 1997 and OS number 312 of 1997 pending before the same court. After filing the petition, the petitioner has sought for the stay of the proceedings in OS number 123 of 2010 and our court by order dated 16/6/2026 has stayed the suit till the disposal of the transfer petition. The court observed that in this case on perusal of the order passed in MFA number 7739 of 2026 dated 17/4/2026
That has been suppressed by the
which
petition
shows
there.
that already there was a direction issued in the MFA to dispose of the matter since it is of the year 2010. This matter was not brought to the notice of this court. Further, when there is direction to the concerned court, even though there is serious dispute regarding title to the properties, if any order is passed for this court, it will cause hindrance to the trial of that suit, wherein there is a direction is issued. Hence, the court do not find any reasons and accordingly dismiss. When counsel appearing for the petitioner submits that in respect of the suit scheduled properties, the suit for declarations are filed, and in fact, one suit is decreed unless and until the suit is transferred to the other court and clubbed with the matters, it would cause law. There is every scope for conflicting of judgments, and declaration goes to the root of the matter. The court, without considering all this, only on the ground that the MFA is an order is passed, a direction is issued in the MFA, has dismissed the petition. Next parallel, and counsel appearing for the respondent submits that the petitioner's case cannot be transferred to the other court for the reason the petitioner has sought for partition before the senior civil judge in respect of several properties, whereas the other suits are pending before the junior division. It is submitted that
Only one survey numbers.
Huh?
Only one survey numbers.
in respect of
No,
one
no,
survey
it has
number,
been-
in respect of one property.
No, 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 that is incorrect, my lords. In fact, I have produced the plaint also. They have filed. In fact,
It
they
is
have
submitted
purchased all the
that,
items of the
whatever, that is not relevant,
Yes.
however,
Not
properties. The suit for, what did you write? Pending before the junior civil, the junior division for declaration. It is submitted that the suit cannot be transferred to the junior division and the court has no jurisdiction to decide the dispute that is raised by the petitioner in this case. And that apart, when the order is, the suit is of the year 2010 and MFA orders are passed to dispose of the matter in time-bound manner. And this aspect was also not brought to the notice of the court. And the court has rightly dismissed the application. Next, having heard the counsels on either side, there is a material on record. The suit is filed in the year, suit of the present suit filed by the respondent herein for partition is of the year 2010. In respect of that, injunction is granted against certain appeal is filed in appeal. There was an order to dispose of the suit as expedition. There was a timeline fixed to dispose of the suit. Now the present contention that the sum of the suits are pending in respect of the very same properties before the junior division, and this matter also has to be transferred to that. As rightly submitted with the land counsel for the respondent, the junior division has no jurisdiction to try this suit for partition where several properties are involved, and the court, further considering the orders passed in MFA, has rightly dismissed the application, and this court finds no reasons to interfere. Accordingly dismissed.
Please.
46 for admission matter. 46 K. Sri Hari petitioner.
Well, as the land of the father of the petitioner was acquired, and my lords, award came to be passed on 30th of September 2013 in LAQ CR 96 bar 30th of September 2013. My lord, being aggrieved by that, for enhancement, he has filed an appeal before senior division, civil judge senior division. My lord, during the pendency, he died. My lord, present petitioner herein came on record. My lord, in spite of that award passed by the civil judge, my lord, the amount has not been paid. I filed execution. My lord, in the execution petition, I filed a memo of calculation. The award passed by the civil judge court clearly states that the interest should be calculated from the date of award or from taking possession of the property, whichever is earlier. But instead of doing that, the executing court had held the date of taking possession, that is in the year 2015.
Come to the impugn order.
My lords, may I draw the attention of the court to page number 13, my lords. 13. That is order on memo of calculation. I think court got it, my lords. May I read it?
Now it is execution is closed.
Execution is closed by dismissing my memo of calculation and holding that their calculation is correct. I would lose around 10 lakhs because of this interest.
Notice to the respondent.
Cell number 47. KG Sadashivaya.
Petitioners have filed an application before this Honorable Court under Order 7, Rule 11 of the Code of Civil Procedure in a suit filed by the other side before the trial court on the ground that they wanted an injunction, permanent injunction against the petitioners before this court. For the facts of the case are this, my lord.
We go to the affidavit that is filed in support of the IA. Why you wanted the plaint to be rejected?
Yes, my lord.
Page
There
number.
My lord, there are several grounds on which, my lord, the properties
So stated so in your affidavit. Let's read it.
in the application, my lord.
Where is it?
But the application has not been produced.
Why they, how they have numbered it without the application?
True,
File
madam.
it tomorrow.
Please, madam.
Not tomorrow, we'll have it on Tuesday. List it on Tuesday. By the time the petition shall file the affidavit in support of the IA. Yes.
Please.
Number 48. Satisha DJ for petitioner. 48.
No representation in the month of September.
Then number 49. For DK for petitioner.
Seek for a short accommodation, my lord. Some inconvenience to senior counsel. Taken up anytime next week, my lords.
This, next week not possible. List on 12th of August. Yes.
Then number 450. Subramanya. Yes, Upasana.
Defendant's revision against the order rejected my application order 7 rule 11. The proceedings are a P&SC proceeding. P&SC for succession certificate. My lords, the application has been filed with respect to 3 items in the scheduled property. Lords, before filing the petition, all the 3 properties, 2 of the properties were in the joint name of me and the deceased. And 2 of the properties have got transferred to me. The shares were transferred to me. One set of shares, I was a nominee.
How many are the properties? 4 properties.
There were various securities, my lords, 3 items of the property. May kindly take it as 3 items of the
2
property.
items are in joint name.
Were in joint name. Being the survivor and the second holder of me being the second holder, they were transferred to me. The one set of shares, I am the nominee, I was nominee, and I have transferred it to the children of the deceased. And by the time the petition could be filed, the cause of action has,
Let's file the petition.
the children of the deceased have filed the petition even with respect to the shares transferred in my name, contending they are entitled to those shares, being the successor to the estate. I took up a contention that by the time the petition could be filed, the cause of action has exhausted itself because it's already been transferred in my name and transferred to their name. Therefore, the succession certificate cannot be granted because under section 390 of the Act, Indian Succession Act, it can be granted, 370 of that, I'm sorry. It can be granted only with respect to those certificates which are the live with respect to the deceased entitlement. And that application came to be rejected on the ground that they are the successors, they are entitled to a share therein, and therefore it required to be. My lords, I would request this honorable court to kindly look into the operative portion of the order. I would, my lords, the discussion.
No,
I
if
would
you're-
request this
no,
honorable
if
court to
you're
kindly turn to page number 31.
Holding it jointly, there must be, what is the share of the deceased?
My lords, I'm sorry, notes.
No, you said in respect of 3 items, in 2 items, both of you are holding it jointly.
Jointly. I was the second holder.
Yes.
Under the rules of under the company rules, the moment the first holder dies, the shares will be transferred to the second holder's name. There is dispute with respect to the position of law on that, whether second holder becomes the absolute owner or it required to turn back to the deceased LRs. This is a question, that's a different question altogether. But the point that I'm trying to submit before this honorable court is, by the time this petition could be filed, the cause of action got exhausted because it's already been transferred. If the LRs have a right on these shares, that required to be agitated in a separate suit, and they're required to establish their right, and thereafter only required to recover. And a petition for the succession certificate proceeding does not lie prima facie on the matter. Is what my contention is before the court.
When counsel the petitioner submits that, in respect to the 3 properties, 2 properties are in the joint name of the petitioner and the deceased, and they've already transferred to the petitioner. Another property, he was a nominee. It is submitted that as on the date the P&SC is filed, no cause of, all the properties are already settled, and the remedy of the petitioner is elsewhere, and these aspects were not considered by the court. Yes, notice there shall be stay of all further proceedings.
So sought for stay of further proceedings through the trial court.
Yes.
Okay.
Petition is permitted to take out hand summons and file a memo to that effect by 3rd of August, or else a stay granted by this court stands vacated. Yes.
Then number 51. H. Devendrappa. 51 H. Devendrappa.
Appearing for the petitioner matters. This second petitioner is the second defendant in the OS suit matters. We have challenged the rejection of plaint order on the ground that they have not disclosed the cause of action and suit is barred by
What is
law.
the suit for?
Suit is for partition and separate possession. Second and third.
For the member of the family.
Yes, ma'am. Second and third defendant had done partition in the 2016, and the respondents were aware of that fact. Now they have challenged at the belated stage in the year
No,
2020.
did they say so in their plaint that 2016 there was a partition?
They have not admitted it, man, but
So, but in the light of the settled law,
their contention is in the year 2022, when they approached us for partition, then they came to know that there is already a partition.
it's a matter of fact.
Yes, ma'am, it's a matter of file. Apart from that, my grounds are, my lords, that they have not filed any document also as to which property they are claiming as ancestral property.
Those
And
are
upon
not the grounds under order 7 rule 11.
valuation, defect in valuation, because the suit properties are undervalued, my lords. Below jurisdiction it will come.
Come to the order.
Order is at page number 31, my lords.
Page number 31.
31. It
Relevant?
starts from page number 31. The operative. The
Yes.
reasoning is at
Come to
page
page, paragraph number 10.
10, Ms. Manoj.
Yes.
May I read it, ma'am?
Yes.
On perusal of the plaint reveals that the plaintiff are claiming 1 night each share in the suit properties as the legal heir of Dodlingappa and Gorama. Further in the plaint, the plaintiffs have specifically pleaded cause of action for the suit has arisen at Navi Lehal village, Taluk Changiri, since December 2022 and subsequently within the jurisdiction of this court. Further, the plaintiff shows valuation. The suit schedule item number 1 and 2 properties are Arakanate Garden in total measures 1 acres to 20 guntas, and the plaintiffs value the market value of the said lands as rupees 10 lakh. The sub-registrar value of garden land of Naveli Hall village as per the valuation chart is rupees 9 lakh per acre, and the total value will come to rupees 13 lakh 50,000, and market value of the 5/9 share of the plaintiff came to rupees 7 lakh 50,000. Further, in addition to the landed property, there is one house property, that is a suit item number 3. Property whose market value was valued at rupees 5 lakh. And the market value of finance share of the plaintiff is rupees 2,77,778. In total, 10,27,278. Further, only because in between of the referendum number 1 and 2, there was registered partition had effected in respect of the suit property, cannot be a ground to hold that
Please come.
there is no cause of action and barred by law to file this suit. Moreover, how the plaintiffs are entitled for the shares grounds made by the defendant to reject the plaint.
Agreed with the orders passed on.
At least notice may be issued.
Agreed with the orders passed on item number 3, notice number 95/2023. Date 17th of January 2026 by the senior civil judge and JMFC Channagiri. The petitioner defendant is before this court. Respondent herein has filed a suit for partition. And in that, the petition herein filed an application on order 7 rule 11 seeking rejection of the plaint. According to the plaintiff, according to the defendant, earlier partition had taken place in the year 2016. 2016, and suppressing the said fact, the present suit is filed. When already the partition is effected, there is no cause of action for the plaintiff to file the present suit. It is submitted that all these facts were not considered by the court, and the court ought to have rejected the petition. Next paragraph. Having other counsel for the petitioner, peruse material on record. The petitioner is, according to the petitioner, already a partition has taken place, and that is not the case with the plaintiff as stated in the plaint. When an application is filed under order 7 rule 11 or seeking rejection of the plaint, court can only consider the plaint and the document that are filed along with the plaint. As in this case, the averments were made by the petitioner in the written statement, and those the written statement or the pleadings of the parties cannot be the basis for the court to reject an application under order 7 rule 11. In that view of the matter, this court do not find any reasons to interfere.
Obliged.
Number 52, Shahida Khanam J, petitioner.
Respondent.
List this matter in the month of September.
ಇದರಲ್ಲಿ connecting matter is there. In the connecting matter, CRP number 491/2025, it is there.
List along with so and so.
491 what?
Write it on a paper and give.
Next week, I'll have to next week.
Number 50.
In that matter, what happened, they have obtained interim order. I'll have to next week, both the matter.
Next week, it's not possible to take 25 matter. Why should, but what is the urgency for this?
But
list it.
Number 55, 53, TN Srinivas Reddy.
I appear for the respondent.
The other case is posted on 19/8, my lord, it may be.
List along with,
posted.
give the number, 19/8.
CRP 801 of 25.
Yes. Right,
Cell number
give it to the court office. Yes, 54.
54.
May I, my lord?
Yes.
Your lordships will kindly recall, I'm sorry, my lord, I couldn't be personally present.
Yes.
My lord, your lordships will kindly recall, my lord, I only had to show one judgment to your lordships on the position of law, that if order 6 is not complied, then my lord, it amounts to, my lord, it would give rise for rejection of plaint under order 7 to 11. Our High Court judgment, my lord, is Lordship Justice Hemant Chandan Gowda. Lord, my learned colleague is passing it on.
Yes.
My lord, the judgment of our Honorable High Court, my lord, is Lordship Chandan Gowda. I would only read, my lord, paragraph.
I'll hear this matter on some other day. List this matter on.
Greatly obliged, my lord, greatly obliged.
On 27th July at 2:30. Look at
Great,
it, 2:30, whatever it is.
My lord,
27, 28, 9th, 29th, 2:30.
Greatly obliged.
Yes.
Cell number 55. Sundar Raman MD.
The petitioner, my lords, led by senior counsel. It's on his legs today. May we
List
had
the matter on 5th of August. 56.
Cell number 56. PS Bob.
Yes.
This CRP is arising out of an order passed invoking order 7 rule 11 CPC.
Tomorrow in the first list, S57.
Cell number 57.
This is the defendant number 1 CRP challenging an order whereby my application for rejection of plaint has been.
Tomorrow in the first list.
Yes.
S58.
May I request for day after tomorrow?
The day after tomorrow in the first list. S58.
58.
Same tomorrow. Tomorrow? Tomorrow in the first list. S59.
Cell number 59.
59 is also same.
Ramanyar.
First list.
22.
Yes, 60.
Cell number 60.
60 minute time for the petitioner. It can come next week. There is no urgency. My application for rejection of the plaint is rejected.
Yes. List is matter next week. List on 29th.
Yes, please.
For order. Cell number
Call the orders matters.
61. Cell number 61. Siri Rajshekar.
Lords, appearing for the petitioner, my lords, we have served this hand summons, my lords, on 16/7/2026, my lords. For the council appearing before the trial.
To all the council?
Please, my lords, and the other three are the co-defendants, my lords. For them, it's not necessary.
Memo is filed.
It's on 16/7/2026 file.
No, memo file stating that notice is not required.
No, my lords, that is not. Last occasion, I think senior had stated that.
My lord, the present petitioner is the defendant number 1. The rest of the petitioner respondent.
What do you have to give a memo?
I'll file a memo.
I'll file a memo.
This is a matter. List a matter after 2 weeks.
Interim order may be kindly extended.
Earlier granted is extended. 62.
62.
62 also same.
Same.
Same, my lords.
Yes, 63.
Cell number 63 disposed. 64. Gautam Chen.
Here for petitioner in this case.
Maintainable.
On maintainability. Next state I will argue. It is maintainable. Next state I will argue. Senior will
How it
argue.
is, what is the order?
My lord, objection is raised on the maintainability.
What is the impugned order?
Impugned order is defendant filed leave of the court to defend his case under in a summary trial. Same was allowed. Being agreed by that, we are challenging before this honorable court. It
No,
is
for
maintainable.
example, if this application is allowed, suit will be dismissed.
Yes, my lord. That is yes, my lord. If that
How
if,
can suit?
if the
Defendant has filed the application.
yes, my lord. If
Plaintiff suit will not be dismissed on that ground.
it would decree would be it will be attained finality, my lord, of the suit. If the IA filed under order 37 rule 5 is rejected, my lord, then the court would have passed order.
Yes, keeping open the maintainability issue. One maintainability issue is kept open. Notice to the respondents.
Cell number
Great.
65.
For the respondent, it's an application under 7 rule 11 that has been.
Filing memo for having served a copy of rejoinder to respond, along with acknowledgement.
It's an application under 7 rule 11 that has been rightly dismissed by the trial court. The petitioners have preferred an appeal before this court.
Then
I
why
filed
the
an IA for
why the
vacating
office
IA.
is saying that appeal is not, this CRP is not maintainable? 64, isn't it?
65.
Oh, this is 65.
I filed an IA for vacating stay.
Well, hear it. List is matter on 12th of August. Office objections. What about this office objection on the
Well,
rejoinder?
they have served a copy on me. They've also filed a memo,
ma'am.
if I'm not mistaken.
I filed a
Submitted
acknowledgement.
that they have served the copy, office objections are overruled. Yes. Yes,
Great
66.
Cell number 66. Cell number 66, Joseph Anthony,
Appearing with the petition in the matter.
early hearing application.
I'm going to for an IA for early hearing. The respondent,
2026 matter early hearing.
yes, my lord, the reason being, my lord, we have constructed the apartment. The apartment is ready for, we have already created third party
IA
rights.
number 1 of 26 is filed. 26 is filed for early hearing. List the matter on 13th of August.
My lord, one submission. My lord. Last time, the matter was listed on June 19. The respondent was supposed to, directed to file objections in this matter. They have
They
not
didn't file?
filed it. They have not filed it as.
List the matter on 13th August. By 31st August, the objection shall be filed by serving a copy of the same to the counsel for the petitioner. If it is not filed, the respondent right to file the objections will be forfeited. Yes.
Greatly obliged.
67, Raghavendra Reddy CR. 67,
Office objections to be complied with within a week. Yes.
cell number 68.
What are these
Shivakumar.
IAs?
My lord,
You're
yes,
for the
Your Lordship was pleased to refuse to grant a stay order, my lord, because they filed a writ petition challenging the two order.
No,
And they filed affidavit to vacate the premises in the trial court. In execution petition, Your Lordship kindly say, the
No, what are these two IAs?
two is, one is seeking a direction executing court to deposit the money by the landlord before the court. The other IA is recall the warrant. Those application, Your Lordship was pleased to
No,
hear the matter.
list this matter in the month of August. Yes, 69.
Number 69.
I'm seeking
To R1 and R2.
R1 and R2, man, I'm served the hand summons and also filed acknowledgement.
68, they filed affidavit in the trial court to vacate the premises.
This is your respondent in this.
Yeah, yeah.
Oh.
They filed an affidavit, undertaken affidavit to
So whatever
vacate.
it is, no interim order is here.
No,
Yes.
no interim order is there.
That's what.
Please.
I'm seeking
69, memo is filed stating that as per the order passed by this court, hand summons are served on the counsel appearing for
response number 1 and 2.
1 and 2, and a memo is filed to that effect. Memo is taken on record. Notice to respondents 1 and 2 is held sufficient. Then what about the others?
3 and filed memo for dispensation of notice 3 to 8 months.
File seeking dispensation of notice to R3 and R8, dispense with at the risk of appellant.
My interim prayer may be considered. Further, the amendment application in the appellate stage is allowed.
This matter on 28th of July in the first list.
Cell
My
number
lord,
70.
my sincere apology, my lord. Serial number 67, my lord. I'm appearing for petitioner, my lord.
To comply with the office objections within 1 week.
Please.
Yes,
Grateful.
70.
Number 70.
70 minutes, kindly have this matter tomorrow at 2:30 minutes, because this matter is reaching from last four days minutes. Kindly have this.
You have to comply with the office objections. Why are you not complying with it?
We have filed amended petition minutes.
Office objections shall be complied with by tomorrow. If it is complied with, list this matter on day after tomorrow in the first list. Yes.
Cell number 71. 71, Sidramaya VP.
I served the copy to the
Memo.
R1 and R1 to R8.
Please, my
Huh?
lord. Please, my lord.
Memo is filed stating that the notice, as per the order passed by this court, hand summons are served on the counsel appearing for respondents 1 to 8. Accordingly, notice to respondent held 1 to 8 is held sufficient. List this matter 1 to 8. This is 71. List this matter on 30th of July.
Please.
Cell number
first list.
72.
Yes.
For
Shivakumar.
respondent, and I have filed my power in the office today
For the first respondent.
for the only respondent.
Only respondent.
Only response.
So and so submits that he has instructions to file wakalat on behalf of the first respondent. Any urgency?
In extension of interim order, it stays there.
Early interim order earlier granted is extended.
No,
list
there is no interim order.
No,
Stay has
it's
not been
granted.
granted.
Give
To
the
an
fa- give
to
the
an
file.
extent,
You're the file.
My only prayer is that to an extent of remitting the dictatorial amount
There
from
is
the
the
commercial
interim
court.
order that I want to see.
Please, please.
There is no interim order.
There is no interim order.
Well, I was directed to remit the balance amount of
No
28
order
lakhs.
of that nature.
But there is a direction
Issue
to
notice to
deposit.
the respondent.
That's
In
all.
addition, petition is permitted to take out hand summons. If the memo is filed with 27/2026, list this matter on 21/7/2026 and list.
I'm extremely sorry, madam. I thought I heard that there's an interim order. That's the reason I served the copy also. I may be wrong in making a submission.
List this matter on
24th, my lords.
28th in the first list,
May I request on 29th?
29th in the first list,
Obliged.
73.
73.
Till then, they'll not precipitate to the order, madam, please.
Even otherwise, the
Allah,
matter is.
Allah, they will go for an attachment. That's the reason. My only request is this.
List the matter tomorrow in the first list.
Nale badas, day after tomorrow. I have
Day
some
after
income.
tomorrow in the first list.
Please.
Yes, 73.
Serial number 73.
Minutes, I will carry out the amendment today, minutes, and filing the amended petition, minutes. Since the matter is very urgent.
What about the amended cause list, cause set?
I amended the consent. No.
File before the registry. The petition shall file the
Matter is very
amended cause
urgent,
title.
minutes. They are going to disconnect the electrification, minutes. That's why the cause of the notice under 42 sub plus 5 of connection and maintenance act of electricity.
Whom you have amended, implemented now?
All the electricians come, party managing director, AWE, executing, everybody of the party.
The list is matter. Have you
Tomorrow.
served on them?
No, minutes.
Then how will you get an order? If it's taken tomorrow also.
And now I'm going to serve the copy, minutes, 2 days.
Mr. H. Devraj is directed to take notice on behalf of the respondents.
Have it tomorrow, please, your answers.
List is matter in the first list tomorrow.
Grateful, minutes.
Serial
Yes,
number
74.
74.
Office objection shall be complied with within a week.
Shall I?
Yes, 75
Shall
75.
I submit the?
Number 75.
in the registry.
They have challenged the IA number 11 and 12 in the common order was passed, my lords. I have made a submission. That is the only office objections, my lords.
What is the common order?
On application number IA 11 and recall and reopen, my lords.
Recall office objection with regard to office objections or overruled. Yes, list this matter tomorrow for hearing.
List
Yes,
one.
76.
List
Serial
one,
number
my
The
76
first,
disposed.
the list one.
76 disposed. 77 hearing on IA. interlock.
Notice to the respondents.
Serial number 78.
Notice, there is a delay, yes.
Yes, 4,000.
Notice to the respondents on all the IAs, I number 2, 1, 2, 3, 4, and 5. Yes, 79.
Serial number 79. Read by SCA.
Petitioners.
Oh, I'm not hearing it. When do you want next
need him.
date?
Next week here, my lord.
Yes, list the matter on 30th of July.
Much
In the first list, yes. Yes.
My lord, for serial number 80, my request for a shorter date, my lords. Serial number 80, my execution proceedings.
I appear in 80, matter would have to be heard. Any date that's
Execution
convenient
petition has
next
been
week.
stayed, my lords. They are asking for absolute exemption from deposit of money.
Whatever is the urgency, you can tell the court officer. I've already instructed her to give the date.
My lord, list number
Very
2.
Very grateful, very grateful.
Serial number 7.
All that to the court officer, I've already instructed her, based
My lord-
on the urgency date.
My lord, the
will be given.
urgency is this.
Lord,
Serial number 7. It may be ordered to be listed tomorrow, my lord.
My lord, it is not
70,
reaching
please.
your
70,
my
they have
lord, it is
complied, my
not
lord.
reaching serial number, list
70,
number
my lords.
214. There is an urgency, my lord.
I said, I have instructed the court officer, tell the court officer, matter will be heard. In spite of that, if everybody wants to say the same thing, I can't help it.
And my lord may be directed to list at least in the list number 1.
Her matter, don't list it. Her matter, list it after a month.
70, madam, 70.
Serial number 7, second list.
Ravi, Ravi, ಇದು pickup ಆಗ್ಬೇಕು, ನಾಳೆ date.
70.
Madam.
ಅಲ್ಲ, ಅವ್ರು ನಾಳೆ date
Madam.
ಇವಾಗ ಈಗ ಬಂದು ಕೇಳಿದ್ರೆ
Or they'll